Recorded Books is pleased to present the Modern Scholar series, where great professors teach you. My name is Richard Davidson, and I'll be your host. Today, we begin a course entitled The American Legal Experience. Your professor is Lawrence M. Friedman, Marion Rice Kirkwood Professor of Law at Stanford University. Professor Friedman has been a practicing attorney since 1955, and he served on the faculties of St. Louis University and University of Wisconsin before joining the faculty of the Stanford University School of Law in 1968. He's also served 10 years as the president of the American Society for Legal History, president of the Law and Society Association, and vice president of the Research Committee, Sociology of Law, at the International Sociological Association. Professor Friedman is the author of more than 20 books on a wide range of legal subjects. Among them are his very popular and critically acclaimed A History of American Law, as well as American Law in the 20th Century. Professor Friedman's many awards and honors include the prestigious American Bar Foundation Research Award, the Silver Gavel Award of the American Bar Association, and the Harry Calvin Prize for Distinguished Research on Law and Society from the Law and Society Association. The legal system in America is the very basis of freedom as we know it today. Legal history in the United States not only defines our society, it charts the course of our democracy from its infancy, based primarily in British common law. Since colonial times, law in America has been in a constant state of development. As the law has helped to shape society, societal influences such as economics and morality have also helped to shape the law. Through history, the legal system has been intimately involved with the prevailing concerns of the American people: slavery, Native American relations, the family, crime, and issues of equality. In this course, we'll investigate the development of the American legal system as we approach it as a living, breathing institution. We'll consider exactly how the law has been used to mold our society as we explore the issues that have challenged the legal system in the past 2 centuries. In the end, we'll arrive not only at a better understanding of the American legal system in general, but also how the rule of law has helped influence and define the development of the American Republic. For more information on this course, please visit its webpage at www.modernscholar.com, where you'll have access to links to related sites, a seminar room to share your thoughts with other students, and yes, of course, a final exam. And now we begin the American Legal Experience Lecture 1, Introduction to the American Legal System. And now, Professor Friedman.
The purpose of this course is to introduce you to the story of the growth and development of the American legal system. The story is going to cover a period of almost 400 years. It begins in colonial times, when what is now the United States was part of the British Empire. We want to see how the law developed during that period, how it differed from the law in the mother country, and what the features and factors were on this side of the Atlantic that molded a distinctive kind of law. After that, we're going to look at the Revolutionary period and the problem of creating a new legal system for an independent nation. As we proceed from there, we're going to look at the relationship between the law and economic development. We're going to look at the rise of government, the rise of regulation, the way in which the legal system dealt with issues of family law, with issues of social control, crime and punishment. And we're going to bring the story completely up to date, ending with our own contemporary times. It's a very interesting and a very important story. But before we can tell the story, we have to ask a number of fundamental questions. We have to ask what we mean by the American legal system, or what we mean by a legal system altogether. We also want to set out here some basic ideas that animate the whole course. Any social system is made up of people of various sorts and classes. There are rich and poor men and women, powerful and weak people. The law is the product of the social forces brought to bear upon it at any given time. The wealthy and the powerful obviously have more influence than the weak and the powerless. The basic thesis that underlies this course is not that law is solely a tool of the powerful to oppress the powerless, and certainly not that law is a neutral instrument embodying timeless precepts of justice and fairness, but that law is a struggle, a constant battle of interest groups, and that the resulting law comes out of the struggle between people with different ideas, different capacities, and is molded decisively by social norms, by political, economic, cultural currents at large in society. If you pick up the daily newspaper that's published in your city and look at it, you'll notice something which, in a way, may surprise you. Every single story in the front part of the paper that deals with domestic issues, every last one of them will have a legal angle. There will be something in the story about the president or a governor. There will be something perhaps about a court or the police or some law or some action taken by government. Look carefully and you will see that this is always the case. Everything that's done through or by public life has a legal action, touches on some aspect of the legal order. Why is this the case? Why is the American legal system so ubiquitous? What is it that it's trying to accomplish? These are among the questions that I hope this course will answer as we investigate the various periods in American legal experience and the ways in which social forces and social movements have affected the organization and operation of our legal system. Before we do this, we have to ask exactly what we're talking about when we talk about a legal system. To a certain extent, I've already given you a clue. There isn't any agreed-upon definition, but we have an idea in mind when we talk about law and the legal system. We certainly are thinking about courts, we're thinking about lawyers, we're thinking about the police. We're thinking about organized government. We're thinking about ways in which government organizations or official organizations of any kind make rules and enforce rules. Roughly, the legal system is concerned with making rules and enforcing them. Now, in fact, there are other ways of looking at the legal system. There are other definitions. A lot depends on the purpose we have for defining the law. To a certain extent, law doesn't really depend on government at all. Let's take a large institution, a bank, a corporation, a hospital, a university. All of these institutions have a kind of internal legal system. That is, they all have rules and regulations and ways to enforce them. I happen to be a professor at Stanford University. At Stanford University, which is a private university, there is a fairly complicated system that we could call a legal system. If a student gets into trouble, the university has procedures. It has rules and regulations that have been adopted. If a student is accused of vandalism or cheating on an exam, the student can request some kind of hearing. In some situations, the student can even bring a lawyer with him. There's a kind of trial before students and faculty. There's a decision. The decision can be appealed. The president of the university has the final say. All of this is completely unofficial because the university is totally private. We could even talk about the legal system of a family. Families make rules. Kids have to be home by 10 o'clock. They enforce these rules. You stay out longer, you're grounded. In other words, whenever there's a system, formal, informal, official, unofficial, we can talk about it as a kind of legal system, a system for making rules, a system for enforcing rules. In this course, we're not going to forget this point, but we're going to focus on law that's official. That is, the law that's connected to the state, to the government. And all of us really have a good idea of what's involved in this legal system. First of all, there are statutes, which Congress passes, or the legislature of the 50 states. There are also rules and regulations of administrative agencies. The Food and Drug Administration has power to decide whether or not a certain kind of red dye can be put in food. And they make rules, and they also enforce these rules. Then there are municipal ordinances. The cities have boards that pass rules, make rules. There are zoning boards, there are health boards, there are school boards. All of these are part of the official government. They all have rules and regulations, and they all have some mechanism for enforcing them. And last but not least, there are the decisions of courts. The decisions of courts affect not only the people who are the parties to the suits, but they also set down basic rules, general rules, which later courts and other citizens will have to follow. All of this constitutes an enormous body of do's and don'ts, and all of it constitutes the legal system of the United States. Well, when we think about the legal system in this way, it's obvious that it has a really important function in our lives. It affects almost everything that we do. We're driving a car, going to work, buying clothes in a department store, going to the grocery. There's a thick network of rules and regulations that covers almost every aspect of life. Business life, work life, even private life. There are laws of marriage and divorce. There are laws about child custody, for example. If I go into a grocery store and I buy a head of lettuce or a can of soup, I'm followed, in a sense, by the legal system. There are legal rules about buying and selling, the law of contracts. There are, of course, in the store, all kinds of rules about the labor relations between the store and the people who work there. Minimum wage for the checkers, mandatory vacation laws, all kinds of laws. There are laws about the quality of the food that they produce. It's obvious also that walking on the street, crossing the street, driving a car, subjects me to an enormous body of rules. The traffic laws, laws about driver's licenses, laws about keeping in your lane, all kinds of laws that we take almost for granted. So there is this dense network of rules and regulations that blankets the whole country. Has it always been so dense? How did this system evolve in the United States? Do we need all these rules? If so, why? This course will try to give at least something of an answer. It will give the answer by tracing the history of the legal system, watching how it evolved, and what kind of social forces it reacted to. Because this course rests on one basic assumption. This assumption is that, in essence, the legal system is a product of our society. Its independence is important, but its autonomy is limited. I'm making a distinction here between independence and autonomy, and I want to explain this. We want our judges to be independent, by which I mean that we want them to be free to decide cases fairly and honestly without feeling the pressure of the government. That's one of the aspects of a free society, a democratic society. In totalitarian systems, they have what used to be called telephone justice. That is, the party or the authorities would call on the phone and tell the judges, this is how we want the case decided. Judges under that kind of system are not independent. So we want our judges to be independent, and basically they are. Autonomy is quite a different concept. By autonomy, some scholars are trying to refer to the idea that the legal system marches entirely to its own drummer, that the law is a kind of enclosed system insulated from the outside world. I want to reject this assumption, and this course is going to operate on the opposite idea, that political, economic, cultural forces are always important, that they determine the shape, the content of the legal system. And we're going to see that throughout. We will begin, for example, in the next lecture, with the colonial system. Later we'll talk about the 19th century and then the 20th century. We're taking, in other words, various cuts through time. And at each point, we're going to ask, what was the nature of this system? What was life like? What were the political, economic, cultural forces? And how did they make the legal system what it was at that particular time? And we're also going to watch how it evolves, how it changes its shape, its content over the years. Before we do that, we're going to have to try to situate our own legal system, the American legal system, in the context of the legal systems of the world. Every country, of course, has a legal system. No two legal systems are the same. Actually, law has a real peculiarity that differentiates it from almost every other field of human knowledge. Electrical engineering or astrophysics or even economics are sciences or claim to be sciences, and they don't differ from country to country. The study of electrical engineering in Honduras or Fiji or Uganda is in principle exactly the same as it is in the United States. But as soon as you cross a border, you're in a different legal system. The law that applies in one state even is not the same as the law that applies in another state. And each international border is also a border between two or more legal systems. Nevertheless, legal systems may resemble each other more or less, and there are ways of classifying them. One method classifies legal systems by their ancestry. This is in a way similar to the way languages are classified. We know, for example, that French, Spanish, and Italian and the other Romance languages are the descendants of Latin. English, Danish, German, Norwegian, and other Germanic languages are all descended from a common parent. If we use a method somewhat like this, we find that in the world there are two classes or groups or families of legal system that are particularly important. Probably the most important is the one which is called the civil law system. It covers almost all of Europe, Latin America, and parts of Asia and Africa. The civil law systems trace their ancestry to the classical Roman law. Of course, classical Roman law was nothing much like the law of, say, modern France. But some of the basic ideas, concepts, and terms can be traced that far back. In the Middle Ages, scholars rediscovered the classical Roman law system. And as this system was reworked, it was adopted or received in one European country after another. Starting about 200 years ago, these systems began to rearrange their fundamental rules in the form of codes of law. The most famous of these were the German Code at the end of the 19th century and the French Code or Napoleonic Code at the beginning of the 19th century. The French Code, for example, spread to Spain or influenced the Spanish Code enormously, and from there was adopted by all the Latin American countries that were colonies of Spain. The German system was used also in Austria and was influential in many other countries. Starting in the 19th century, a number of countries outside of Europe also began to adopt civil law systems. in their search for modernization. The most famous case is that of Japan. In our century, Turkey is another famous example. So by now, the system that we call the civil law system covers, as I said before, almost all of Europe, Latin America, parts of Asia, and Africa. It is by far the most important family of legal systems. Well, I had mentioned the reception of the revived Roman law in Europe in the Middle Ages. There was one country that resisted this reception, one country that more or less stubbornly stuck to its own native system. This was the island kingdom of England. England's system is the so-called common law. The civil law influenced it, but it never replaced it. Now, England in the Middle Ages was a country of no particular importance, but by one of those accidents of history, it became a mighty empire. And the common law spread to the colonies and then to the colonies of colonies. So the common law today is a very important system. It's the basis of the law of Canada, with the exception of Quebec. It's the basis of Australian law, New Zealand. It's the basis of other English-speaking countries, such as Jamaica and Barbados, and many of the former colonies of England in Africa and Asia. And what's most important for us, it's the basis of the law of the United States of America. There is one partial exception in the United States, and that's the state of Louisiana. Louisiana, which was once under French and Spanish control, adopted the Napoleonic Code, and it retains it to this day, is quite proud, in fact, of its heritage of French law. In many other ways, Louisiana has assimilated itself to common law habits and ways of thinking, but there is a lot of stubborn pride in this somewhat unique heritage. One interesting point about the common law is that it has never spread beyond the ambit of England, its colonies, and the colonies of colonies. When a country like Japan or Turkey decides to modernize and adopt a legal system from somewhere else, they never turn to the common law. They always turn to the civil law system. Now, why should this be the case? Why is our own dear legal system so unpopular? The answer is that it is not a codified system. The civil law systems, beginning in the early 19th century, adopted these comprehensive codes of law. These codes of law are statutes which purport to set out all the fundamental rules of the legal system. The common law system is not codified. In essence, it's judge-made law. That is, judges create the principles and doctrines that lie at the basis of the common law. How do they do this? They do this in the course of deciding actual cases. Now, these decisions are reported in hundreds and hundreds of volumes that line the shelves of law school libraries. And this is one of the main features of the common law that sets it off from the civil law systems. It is a judge-made system, and it is not basically codified. This means that it's not packaged for export. The reason the Japanese or the Turks turned to the civil law is because the civil law countries could say to them, you want our legal system? Here it is. It's a set of codes. It's compact. It's easy to ship. Translate it into Japanese, translate it into Turkish, and you have our legal system. The common law system could never make that claim and still cannot make that claim. The common law system, then, is a system in which the judge is at the center of the lawmaking process. But you say, what about Congress and the state legislatures? They're passing laws all the time. This is true. And to a very great extent, the common law today is a codified system. Just as a matter of fact, the civil law systems have placed a lot of power in their judges. The judge still remains at the core of the common law system. There are many other traits that set off the common law system from the other systems of the world. For example, there is the institution of the jury. Civil law systems basically do not have a jury. Judges decide on guilt or innocence. Common law procedure is very strongly oral in nature. The common law loved the spoken word. Think about the common law trial, the trial that you're familiar with, the trial that you see on TV every day or every night. It's dominated by lawyers, and it's dominated also by the spoken word. The heart of the common law trial consists of cross-examination, testimony given orally, the lawyers arguing with each other, the judge sitting there as a kind of umpire, just ruling on objections. The drama of the trial consists of the presence and oral testimony of witnesses and the presence of a jury. The civil law systems historically leaned very heavily on written documents. They avoided the dramatic, lawyer-dominated trials of the common law. A trial in a civil law system consisted basically of the shuffling of documents. The lawyers played much less of a role. The judges did much more of the work of investigating, working up the case, and, of course, the actual decision. There are many other differences, small and large, between the two legal systems, two great families of legal systems. And of course, there are also many other families of legal systems in the world. There is, for example, an important group of religious-based legal systems. Many of you have probably heard of Sharia, the sacred Islamic law, which governs in countries like Saudi Arabia. There are also many indigenous systems of law that operate within societies, for example, within African countries, among certain tribal peoples that have retained their own historical ways of dealing with rules and their enforcement. Even within the United States, there is a certain amount of autonomy which has been granted or retained by the native peoples. There is, for example, a Navajo Supreme Court, a court system within the Navajo people, and it applies, of course, for the most part, the same rules and regulations that operate outside the reservation, but they are entitled in some areas to apply norms which are indigenous to the Navajo people. But basically, the common law, as it has been inherited and developed in the United States, is the system which governs in this country. What is it about the American common law which sets it off historically and functionally from the rest of the common law world? Well, there are a number of these peculiarities. One of them that we will talk about a lot is its federalism. We are a federal system, a cluster of states, and each state is sovereign in many ways within its borders. Each particular state controls such things as ordinary crimes, the educational system, family law, commercial law. There are other federal systems. Canada is a federal system and Australia is a federal system, but each one divides up the business between the central government and the individual parts of the country in its own particular way. The United States also has a written constitution, and it has judges who can review the work of other parts of the government. These are important structural traits that were developed after independence. England, the mother country of the common law, was not a federal system. It also did not have a written constitution. In fact, it doesn't have one to this very day. And the idea of judicial review, which we will talk about a great deal in connection with the United States, is lacking in England. In this first lecture, we stress the importance of the legal system in our daily life. We also explore to a certain extent exactly what we mean by a legal system. We talked about the various groups or families of legal systems that exist in the world, especially the difference between the great civil law system and the system to which American law belongs, the common law system, which is basically derived from the English tradition of the common law. In the lectures to come, we will see what is distinctive about the American legal system and how this distinctiveness is derived from the concrete social, economic, political, and cultural factors that obtained on this side of the Atlantic.
After listening to Lecture 1, a student posed this question to Professor Friedman. Do the British have a constitution similar to the U.S. Constitution? Let's listen to the professor's response.
The British, of course, talk about the, quotes, Constitution, end quotes, of England. But when they do that, they're not referring to a written document at all. What they're referring to is simply the English tradition, the rules and regulations that are embodied in the statutes of Parliament, but more fundamentally, the kind of underlying idea of what British government is. It may seem strange to us to operate this way without a formal written document that sets out the rules and regulations that organize the government, the basic frame of government, the basic assumptions under which it operates. But as a matter of fact, the American Constitution, when it was adopted in the late 18th century, was a unique document. At that time, there was no such thing in almost any country as a written constitution. By now, it's sort of de rigueur for any country to have a written constitution. England, which lacks one, seems like a rare exception, and is. But at the time the American Constitution was framed, this was distinctly an innovation. England operates under the system of parliamentary supremacy. In theory, if Parliament passed a law that said everybody whose last name begins with Q is to be shot immediately, there is no way that that could be questioned in court. Of course, in practice, the British say, of course, Parliament would never pass such a law, but in fact, there is no Bill of Rights in England, and Parliament has in fact passed some laws that would never have passed muster in the United States. Nevertheless, as we all realize, England is a democracy. It does have parliamentary government. It does have a strong sense of fairness that operates in trial systems, and on the whole, it's a functioning democracy.
This ends Lecture 1. The American Legal Experience, Lecture 2, The Colonial Legal Experience.
In this lecture, we will be talking about the colonial legal experience. This was the experience of the various colonies during the whole period before the Revolution. The colonies were settled first in the early 17th century. The Revolution took place in 1776. There was therefore a period of 150 years or more, which is a very substantial period. It's about the same as the length of time between the Revolution and, say, 1925. The colonial experience varied, of course, from place to place. The experience of New Hampshire, New York, Virginia, Georgia were very different. Each colony was more or less independent from the other colonies. Each colony developed some sort of legislature which passed laws. Those laws, of course, were valid only within the particular colony. The colonies were part of the British Empire, but the British were more or less stumbling into an empire, and they had not developed ways of really governing their distant colonies. You also have to remember that the colonies were very far from England, that travel was slow and precarious and dangerous. The control that could be exerted from London over events in Boston or in Virginia was very weak and tenuous, particularly in the 17th century. In this lecture, we will be looking at some aspects of colonial law. Each colony had its own system of law, and these systems governed many aspects of their lives. The criminal justice system will be treated in the next lecture. In this lecture, we want to stress two particularly important aspects of colonial law: the land tenure system and the labor system. The land tenure system is significant because it was the foundation on which a very different society was erected on this side of the Atlantic. The American labor system is significant particularly because of the law of slavery. The law of slavery, which governed the relations between Americans of dark and light skin, was the foundation of what became the most bitterly contested and perhaps the most unhappy aspect of the American social system, a story or tragedy in which the legal system played a vital role. In this lecture, we're going to talk about the system of law that developed during the colonial period. The colonial period in the United States lasted from the early 17th century till the outbreak of the Revolution in 1776. This was a period of about 150 years or more. In other words, it was about as long as the period between the Revolution itself and 1925. So this was a very long period in which the legal system developed in many very important ways, and in which, in some regards, American law was set firmly on a particular path. We're going to talk about the colonial legal experience in this lecture and the next lecture. The next lecture will be primarily about the criminal justice system, the way in which the colonists defined crime and punished crime. This lecture will talk about the organization of the legal system, the court system, a little bit about land law, and very significantly about the very peculiar labor system that developed in the colonial period. That labor system was made up of two main features: indentured servitude, which was a kind of temporary slavery, and slavery itself, which is, in some ways, the original sin of the American legal system. English-speaking people arrived on the Atlantic coast in the early 17th century and founded settlements all along the coast. The Pilgrims left the northeast of England, went to Holland, and then on to found a colony at Plymouth. They tried to create a community that lived a biblical life as they defined it. Another group, the Puritans, had tried to reform the Protestant Church in England. They too came to the New World to escape persecution, and they founded colonies, particularly in what is now Massachusetts. Now, the English, of course, were not the only people who were interested in settling the New World. The Dutch were in New York, the Spanish were in Florida, and of course, there were Native American peoples throughout the area. The English pushed out the Dutch and displaced its legal system. The United States would acquire Florida, but not until the 19th century. By and large, they ignored the legal systems of the native tribes. The colonists brought the common law with them. It was the only law that they knew and the only law that they understood. To understand the nature of colonial law, it's worthwhile doing a kind of thought experiment. Imagine a shipload of people that's shipwrecked on a desert island. I know that today it's impossible to think of this because we have airplanes, we have radios, satellites, and all the rest of this. But imagine that it was at a period in which it was possible to land on a desert island and be isolated and have to remain there. What kind of law would be established by the people who were shipwrecked on this island? Well, the first element would be what we call remembered folk law. So this is a bunch of Americans, let's say, and they're trying to organize themselves. They would naturally say, well, we're going to have a jury. Well, if somebody commits some offense, we'll have a jury. How many people will be on the jury? Well, 12, that's the right number, isn't it? It's something they remember. They're not lawyers, but they remember the living aspects of the legal system. So that'll be one element of the law they establish. A second element of the law they establish would be determined by their precise situation. Let's say they hope to be rescued someday. There's a hill on the island, so they're going to light a fire at the top of the hill, and they'll have someone guarding it day and night to see that the fire doesn't go out. So they'll have rules about punishing people who let the fire go out, or how they select people to watch the fire. Now, back home in the U.S., we don't have any rules about fires on hills and signals to passing boats. We don't need it. So the second element is things that are just dictated by their situation. The colonists, when they came to this country, had to deal with hostile and friendly native tribes. There was nothing in English law to prepare them for that, because English law did not have such a problem. The third element would be ideological. It would make a difference who the people were on the boat. There'd be a difference between, let's say, a shipload of people who belong to the Young Socialist League or a shipload of born-again Christians. That would determine the third element of the law they created. So if we look at the law of Puritan Massachusetts, for example, we find in it all three elements. We find many elements of English law that they simply brought with them. The terminology, judge, jury, plaintiff, defendant, court, all the ideas that were common to people in England, even though at first they had no lawyers. Then they had to make rules and regulations to govern their own particular situation. And in the third place, they were trying to found a particular kind of religious community. And many of their rules were rules that governed religion, rules about attendance at church, and rules about, for example, what to do with people who deviated from the particular religious beliefs of the Puritans. Now, we know that people came to the United States to escape religious persecution, but to be perfectly frank, many of them did so in order to be able to persecute for themselves. For example, under the law of Massachusetts, Jesuit priests were not allowed in the colony. Any Jesuit priest who appeared there was to be banished, and if the priest was so bold as to return, there was the sentence of death. Now, I said that the colonists had brought the common law with them, and that it was the only law they knew and understood. But the legal institutions that they set up were very different from the institutions in England for the reasons I've already explained. In the first place, English law was extremely complex and had many local variants. Some of these local varieties had a special impact on the colonial law, depending on where the colonists came from. But mostly American law veered off in its own direction because of the vast differences between the colonial situation and the English situation. The colonies at first were very small and precarious. The smallness had a lot to do with the kind of law and legal system they set up. One way of understanding that is to think about the difference between the kind of shopping you can do in New York City and the kind of shopping you can do in a small town. In a small town, you'll have a general store. In New York City, there's probably a store that sells nothing but Cambodian pottery. The larger the society, the more specialization is allowed or necessary. The British system of courts was extremely specialized and extremely complex. The courts that were set up in the colonial system were kind of one-stop, do-it-all general stores of law. Every colony set up a system of courts, and they simplified the complex jungle of overlapping and confusing jurisdictions that existed in England. They were cheap, they were accessible, they handled a wide range of business. They weren't just courts in the modern sense. They handle a lot of what we would call administrative and legislative work, along with the ordinary work of settling disputes. If you look at the records of a court in, say, Massachusetts Bay, you find all kinds of things spread on the record. For example, people would come in to register the earmark for their cattle. They'll come in to record a will or a deed. The courts were really basic institutions of government. The law they applied was also very much more streamlined, much simplified. The law of England was complicated, was handled by lawyers who were skilled and trained. It was also, by and large, a law that concerned the landed gentry, the small proportion of the population that owned almost all the land. The law that was applied in the colonies was a law for the masses, because it was the masses who owned the land. This is, I think, one of the most significant aspects of colonial law. It was less a matter of ideology than circumstance. England was governed, as I said, by a small elite, the landed gentry. Their control of the population was based on their ownership of the land. This English class system was impossible in the colonial situation. There was an abundance of land. The land was there for everybody. Now, I know that, in fact, there were people living here, there were native peoples, and they had claims to the land. But the colonial settlements largely ignored these claims and in effect shoved the native peoples aside. From their standpoint, the land was free and unowned and theirs for the taking. The legal system reflected this reality. For example, most of the northern colonies rejected the idea of primogeniture. The English system of primogeniture meant that land descended to the eldest son. The eldest son was the heir to the land. The other children, well, they had to make do. The daughters were supposed to marry well. There might be some money or property to settle on them, but the basic estate went to the heir, the eldest son, just like the monarchy descended to the eldest son. The point of primogeniture was to keep an estate together as a single entity. This was unacceptable and unnecessary in the northern colonies, where there was so much land that there was no reason why it should be monopolized by the eldest son. So most of the colonies, in fact, treated children equally. Massachusetts, for a while, gave a double share to the eldest son in accordance with the biblical tradition. But aside from this, the idea of partible inheritance, that is, equal division among children, became the norm in the colonies. The colonies also innovated by devising a system for recording transactions in land. That is, a way of buying and selling land in which the transaction would be recorded, would be noted down in the court and kept on the public records. No such system existed in England. In England, land was transferred in traditional ways, and there was no felt need for a recording system. The essential point about the colonies was that land was a commodity. It was not divided into estates with traditions, but was treated as a commodity. It was fungible, which means that one piece of land of a particular quality and another piece of land of the same quality were more or less the same, just as 1 pound of sugar is fungible with another pound of sugar. In England, in other words, land was the basis of a hierarchical social system. In the colonies, land was a commodity, something to be bought and sold, and especially in the northern colonies, society became organized in terms of family farms rather than large estates with landlords and tenants who worked the land and paid rent to the landlord. The England of Jane Austen, the England of English literature of Anthony Trollope never existed, nor could it exist in the United States. There were some exceptions. Large estates in the upper Hudson Valley owned by the so-called patroons, many of them were descended from the Dutch, with large numbers of tenants who paid rent, though very reluctantly. The other big exception, which we will come to shortly, was in the South with the development of the plantation system. There was no shortage of land in the colonial period, but there definitely was a shortage of labor. Labor was a rare commodity, and the regulation of the supply of labor was a very important function for the legal system in the colonial period. The labor system was organized in ways which are very foreign to our modern way of thinking. There were some colonists who worked for wages like modern workers, but there were two other kinds of labor which are distinctly foreign to us. The first is indentured servitude, and the second was chattel slavery. An indentured servant was a kind of temporary slave. He was called an indentured servant because he usually had a kind of document called an indenture on which the terms and conditions of his employment would be set out. Typically, the indentured servant worked for a particular master. He lived in the master's household. He was fed and clothed by the master, but he earned no wages, and he had no right to quit the job. 7 years was a very common term for an indentured servant. The master was supposed to treat him humanely, and if the master was cruel or unusually cruel, beat the servant could go to court and complain, and there are many instances recorded. But the servant was bound to the master. The servant could not quit the job. There was no way for a servant to say, "Take this job and shove it." If the servant in fact ran away, the servant could be forcibly returned and punished. At the end of the period, however, the servant was free. But before this, he could be bought and sold. If you had an indentured servant with a 7-year term, and after 2 years you didn't need the servant anymore, you could sell the 5-year period to somebody else. If the master died, his heirs could inherit the rest of the servant's period of work. Now, indentured servitude was a very common phenomenon, and it was indeed very useful. One use in particular is worth mentioning. There were many people who wanted to settle in the New World, either coming from the British Isles or from Germany. How could they pay for their passage? Most of them lacked the money to do so. They entered into an agreement. They would pay for their passage by selling themselves into servitude when they landed. So upon landing in the United States, or what is now the United States, the servant would be sold for a period of years, and the buyer would pay the money not to the servant, but to the ship captain. There are many, many other examples of the way in which indentured servitude could be used. There are cases, for example, which a person who wanted medical attention and couldn't pay for it would agree to be bound to the doctor for a period of years. In fact, there are all kinds of ways in which indentured servitude proved useful. Indentured servitude was also closely related to apprenticeship. It was extremely common for young people to be bound to a master until they reached their majority. They would live in the household of the master and mistress. They would sleep there and eat there. Of course, they wouldn't be paid, but the master would teach the young man a trade, perhaps. If it was a young woman, she would be trained in household economics, in how to cook and sew. Essentially, the slave was a servant for life. And this status was associated from the very beginning with black people imported from Africa. There's a great deal of controversy about the origins of slavery in the United States. Slavery was found in the West Indies, in the British colonies such as Barbados and Jamaica, before it was found in what is now the United States. And some of the first slaves came from the West Indies. It isn't at all clear in the very earliest years whether a particular African was treated as a servant, that is, an indentured servant, or as a slave. And of course, it was not very clear what the legal status of a slave might be. You have to remember that there were no slaves in England. The English common law had no such institution as slavery. Slavery is an American innovation, although not one, of course, that we're particularly proud of. Quite the opposite. During the course of the 17th century, the law of slavery became crystallized and formalized. That is, rules began to be passed which established slavery as a regular, legal institution. In Virginia, for instance, we can trace the development of laws that made slavery what it became. Perhaps the most important of these was a law that provided that children of a slave mother were themselves slaves. A woman who was held in slavery and gave birth to a child was giving birth to a slave. This was regardless of the identity of the father. Normally, in a common law system, the father's status determined the status of a child, but not under slavery. Under slavery, it was the status of the mother. This meant, of course, that many of the children who were begotten by slave owners were themselves slaves. Otherwise, these children of mixed blood would have constituted a class of free blacks, and this would have been intolerable in a system of slavery. Moreover, since the slave children were owned by the same owner as the owner of the mother, the birth of children was of economic benefit to the slave owner. Something that surprises a lot of people is to find out that every colony had slaves. There were slaves in Massachusetts. There were slaves in New Hampshire. There were slaves in New York. In fact, in New York, slaves were a pretty substantial proportion of the population, at least 10%. But the slave population was most significant in the southern colonies, in the colonies that had developed a system of plantation agriculture. By the middle of the 18th century, black people constituted 40% of the population of Virginia. Almost all of these black people were slaves. Virginia and the other southern colonies built up an elaborate body of slave law. First of all, there were rules defining the status of slavery itself. I've already mentioned perhaps the most important one. Another very significant one dealt with the religion of the slaves. This was a law that said that baptism and conversion to Christianity did not affect the status of a slave. The reason that was given for passing such a law was this, that otherwise slave owners would discourage their slaves from becoming Christians, since if they became Christians, they would no longer be slaves. But behind this, one doesn't have to be cynical to suspect that it was the economic interest of the slave owner which was dominant here. That slavery was already associated very deeply with race. The southern colonies never wanted the free black population to grow. Conversion to Christianity would have meant the end of slavery without the rule that conversion did not affect the status of a slave. There were elaborate rules about the conduct of slaves and the social control of slaves. The master was given the power to punish slaves. A statute in Virginia in 1669, which is somewhat chilling to read today, provided that if a master was correcting or punishing a slave and accidentally killed the slave, that this would not be a crime, because, as the statute says, we will never assume that a man would destroy his own property. It was theoretically the case that a very cruel master could be brought to book, but in practice, the master's power over the slave was absolute. There was also a very large body of quite technical law which related to slaves. This is the least known, but in some ways the most interesting branch of the law of slavery. By the middle of the 18th century, slaves were really an essential part of the economy of the southern plantation colonies. This meant that the assets, the wealth of these colonies rested largely on land and slaves. The buying and selling of slaves, the commercial law of slaves, was therefore at the very heart of the economy and the legal system of the southern colonies. And this body of law about buying and selling inheritance and the like of slaves, which seems so heartless to us today, was essential for the operation of the plantation economies of this part of the country. Since the slaves were so essential, it is also, of course, understandable that there were such strict rules on the disciplining of slaves and rules designed to prevent slaves from rebelling against their masters. One point that has to be made about slavery, and cannot be stressed too much, is that slavery and race feeling were intimately related. Slavery from the very start was associated with race, and with one particular race, African Americans. There were experiments with the enslaving of Indians, but these did not succeed for a variety of reasons, including the fact that the Indians, if they escaped, could go back to their own people. They had a hinterland, they had a culture. The African Americans had been snatched from Africa and had nowhere to go if they fled. But there also were elements of racism from the very start. Whether slavery produced racism or racism produced slavery is a kind of chicken and egg issue that we cannot solve at this point. A Virginia statute of 1670, which is very interesting, provided that free blacks, African Americans who were not slaves, and Indians were forbidden from possessing servants who were white. In other words, even if a free black had the money and position to be able to afford a servant, that servant could not be white. The significance of this is that it emphasizes that slavery had become a kind of caste system, in addition to being a labor system. It was a system under which all whites were held to be socially superior to all blacks, regardless of status. To sum up the contents of this lecture, we began with a consideration of what elements of English law the colonists brought with them or did not bring with them to the New World. We emphasized the fact that the colonial social system was bound to be different from that of England because of the difference in land tenure and land tenure opportunities. And we talked also about the development of a very peculiar labor system, the system of indentured servitude and slavery. In the next lecture, we will turn to the system of crime and punishment in the colonial period.
After listening to Lecture 2, a student posed this question to Professor Friedman. How did the colonies arrange their legal system? Let's listen to the professor's response.
Every colony had some kind of legislative body that passed laws. These laws were effective within the colony. Each colony had its own separate system. In many ways, the colonies were functionally independent of each other, and in many ways they were also functionally independent of the mother country, which was very far away and had only limited methods of controlling them. In theory, colonial laws could be reviewed in Parliament and discarded there if they contradicted English law. This happened occasionally, but it took a long time and was sometimes ignored by the colonists.
This ends Lecture 2. If you borrowed this course from a public library and would like your own copy of the course guide for future reference, call Recorded Books at 1-800-636-3399, and we'll send you a free copy. A shipping charge will apply. The American Legal Experience, Lecture 3, Criminal Justice in the Colonial Period.
In this lecture, we're going to talk about the criminal justice system in the colonial period. Like all societies, colonial society had ways of defining acts as crimes and punishing those acts. We're going to emphasize here some of the aspects of colonial criminal justice which are most interesting and in some ways differ the most from what we expect and what we experience today in our criminal justice system. In particular, we're going to discuss what we now call victimless crime. These were crimes, on the whole, against morality. We're also going to examine the use of capital punishment and other forms of punishment during the colonial period. In addition, we're going to explore criminal procedure, the ways in which persons accused of crime were actually dealt with in the courts of the colonies. But I want to begin by talking about what we would now call victimless crime. This is a term which is particularly modern. In colonial societies, there was no such concept. There was no such idea as a victimless crime. When we use the term victimless crime, we're more or less assuming something. There's a kind of judgment implicit in the term itself. Let's take a crime called fornication. Fornication is the offense of sexual relations between people who are not married. We would call this a victimless crime because it's entirely consensual. But to colonial society, and particularly the Puritans, it made no sense to talk about a crime of this sort as victimless. The society was the victim. This society made very little distinction, if any, between sin and crime. Remember that it was a deeply religious community. The clergy were the most important figures in the colony, as indeed in all the colonies. The colonies enforced religious orthodoxy. They punished blasphemy. They punished heresy. In Massachusetts, as I mentioned, there were laws against Jesuit priests. There were also laws against Quakers. Breaking the Sabbath was quite generally a crime in all of the colonies. Non-attendance at church was an offense. In other words, the colonies believed that they were trying to set up communities that would live according to God's ways. And they felt that it was important for the community to punish offenses against religious morality. These crimes were not victimless. God himself would see and punish the community if it transgressed. After all, God had destroyed the cities of the plains, Sodom and Gomorrah, because of the sins of their inhabitants. It was important that that fate not be visited upon Boston or Salem, Massachusetts. Consequently, we find that the colonies were extremely active in enforcing the laws against immorality. Lying, idleness, drunkenness, foul language, all of these were crimes. What was especially important were the crimes against the sexual code. Sodomy, fornication, and adultery were criminal acts. Indeed, in some colonies, fornication was the most frequently punished crime of all. In the colonial records, we find hundreds and hundreds of instances in which men and women are whipped, fined, admonished, or ordered to get married because they committed the crime of having sex outside of marriage. Of course, the colonies punished the most ordinary, conventional, familiar crimes like murder, rape, arson, assault, various kinds of robbery and burglary. And these were in fact punished much more severely than a crime like fornication. So the pages of the record books of the courts of, say, Massachusetts Bay are filled with instance after instance of young men and women who are punished for violating the sexual code. We can read this evidence in two rather contradictory ways. On the one hand, it shows that life in the Puritan colonies was a lot less strict, severe, and religious than we like to think. Many people seem to be doing acts which went against the teachings of the church, the Bible, and the clergy. On the other hand, the evidence also shows that these crimes were taken very seriously. They were not only taken very seriously by the authorities, but they were taken seriously by the average person, as far as we can tell. It's interesting also to note the way in which these crimes were punished. The colonies made very frequent use of fines, that is, monetary payments. That's true. But corporal punishment was also extremely common. What was interesting particularly is that all forms of punishment were administered in public, including whipping and including the death penalty. It's also interesting to note that they made very frequent use of punishments that inflicted stigma and shame. For example, in 1641, a man named Thomas Owen in Massachusetts Bay was convicted of adulterous practice. He was told to sit on the gallows with a rope around his neck for everyone to see him. A woman named Sarah Hales, who was also censured for misbehavior, had to sit an hour or two with a rope around her neck. A man named Samuel Hawkes, who was convicted of swearing, cursing, and lying, and unclean speech, had to sit for an hour in the stocks and have a, quotes, cleft stick on his tongue. And a man named Thomas Scott and his wife, who had fornication before they were married, had to stand an hour in the marketplace, quotes, with each of them a paper with great letters on their hats. People were made to sit in the stocks, or they were gagged or ducked in water. Everything was done in public. The point of this was to expose them to the community for shame. It's a little bit like having a student in an old-fashioned classroom sit in the corner with a dunce cap. The idea is not only that the criminal is being punished and taught a lesson, but the community is also contributing to the punishment. The community is punishing by inflicting shame, and the community is also learning a valuable lesson. This indeed is the underlying theory of all colonial corrections. Another way of punishing for more severe crimes was branding with a hot iron. For some crimes, mutilation was prescribed, cutting off an ear. Adulterers, as in Hawthorne's very famous novel, in some colonies could be made to wear a big capital letter A on their clothes. This is not simply fiction. This is the actual practice in a number of communities. Again, all of these are public. Even branding with a hot iron or mutilation has the effect of making the criminal visible. The loss of the ear is not only punishment, it means carrying around with you the sign that you are a lawbreaker and have had to be punished. Slaves were also punished, and they were punished on the whole more severely than whites. What to our modern ideas seems peculiarly missing from the whole system of colonial corrections is imprisonment. There were such things as jails in the colonial period. They were pretty ramshackle affairs. The fact is that they were rarely used as places of punishment. The men and women in jail were either people who were waiting for trial and had not made bail, or people who had been imprisoned for debt. It was foreign to the colonial mentality to lock up a man or a woman for a period of years as a form of punishment. This is, of course, the primary method of punishing people who commit serious crimes today, and I guess it would be natural for people to think that it goes back to time immemorial. In fact, as we will see in a later lecture, the big prison, the walled prison, the penitentiary, the big house, that was something that did not exist in the colonial period. The colonial period was a period in which labor was in short supply. The idea that you should lock someone up for a period of years and take them out of the community was something that was simply foreign to them. Moreover, the whole idea of a prison did not fit in with the colonial theories of crime and punishment. A criminal was a man or woman who transgressed against the rules of society. The solution was not just to punish the criminal. The criminal had to be brought back into society. The way to do that was not to remove him from society, but to expose him to society. Not less of society, but more of society. Hence the whipping, the sitting in the stocks, the branding, all of this done in public, in the public square. The road to redemption lay through the path of public condemnation, the path of stigma, and the path of shame. I want to say something now about capital punishment. The colonies were not particularly bloodthirsty. In England, property crimes were, in general, capital. If you stole something, let's say a plate of silver, that was worth more than a certain threshold amount, you could be hanged for it. This was not the common practice in the colonies. On the whole, property crimes did not lead to hanging. The only exception was for repeat crimes. An early Massachusetts statute, for example, on burglary, provided for mutilation and whipping, for a second offense, the loss of ears, and hanging only for a third offense, at which time it was clear that the man was completely incorrigible. There were, of course, some episodes of savagery, to be sure. The famous Salem witchcraft trials were the most important example, or perhaps the most notorious example. Witchcraft was a well-recognized crime, but in this notable instance, a kind of hysteria seized hold of the community and led to a wholesale denunciation of witches. Quite a few of these witches, or alleged witches, died, along with a number of men, including one who was crushed to death because of his refusal to plead either innocent or guilty. The death penalty was also heavily used after real or imagined slave revolts. One of the most notorious was the occurrence in New York in 1741. Here, too, a kind of panic overtook the colonies, and there were scores of executions of slaves and the white people who were supposed to have conspired with them. As we said, capital punishment, like other forms of correction, was carried out entirely in public. Capital punishment was used for such serious crimes as murder and rape. It was always done in public, in the public square. At a hanging, large audiences came to witness these spectacles. Men, women, and children gathered round to watch the hanging. Very often, the condemned man or woman made a speech from the gallows. In fact, this was probably, if you can talk about such a thing, the ideal hanging. The criminal would stand on the gallows and, in his speech, would confess to crimes. He or she might say, "This is how I went wrong. Please don't follow in my path. Don't do what I do, but instead follow the path of righteousness." They would also often talk about how they had been converted and saved, and how they were going joyfully to meet their Maker. Very often, the hanging had been preceded on the Sunday before by a special sermon delivered in church. The whole execution was a kind of didactic theater. It was a drama played out before an audience, and it was a drama with a point. Hanging was therefore used by the elites, the leaders of the community, to reinforce their notion of right conduct and to teach important lessons to the community as a whole. But this was generally true of the whole criminal justice system. It was the point of the very heavy use of stigma and shame. The whole system of corrections, in other words, was a community matter. It depended, of course, on a particular kind of community. The communities were small, everyone knew each other, and this kind of punishment works best in that kind of community. There's a lot of talk today about reinstituting stigma and shame as auxiliaries, at least, of the criminal justice system. And the people who suggest this often look back to the colonial period and the way in which stigma and shame were made part of that criminal justice system. But it's important to remember that the criminal justice system fits its society like a glove fits the hand. These were small communities, as I said. If a man and woman committed fornication together, it was likely that the story would come out. At the same time, it's also likely that there was a community of believers who agreed with the norms of the community. In order for stigma and shame to work, there have to be two prerequisites. First, general consensus about the norms. And second, and perhaps more important, a community in which people are more or less condemned to life together. In a large, heterogeneous community like the United States today, a person can escape from stigma and shame simply by moving. In a small community in Massachusetts in the 17th century, this was very much less the case. I want to say a few things finally about criminal procedure during the colonial period. Many aspects of the colonial procedure would be very familiar to us today. The use of a 12-person jury, for example. There was also a grand jury which heard accusations and decided whether there was enough evidence to warrant a full trial. There were some striking innovations in criminal procedure compared to England. England had a system of private prosecutions. In other words, if you were a shopkeeper and someone stole from you, the shopkeeper, had the responsibility of prosecuting that criminal. A constable might have caught him running away from your store holding the valuable goods under his arm, but as far as sending him to jail, that had to be done by you in the sense that you, the shopkeeper, had to pay for it. There was no such thing as a district attorney or public prosecutor. Very early in their history, however, the colonies made use of prosecutors which the government itself paid for. This was a distinct innovation. It, I think, reveals the fact that the criminal justice system was more democratic on this side of the Atlantic. If you have to pay for prosecution yourself, obviously this disadvantages relatively poor people who are victims of crime. The colonies were also more generous in allowing the use of counsel for the defense than was true under English practice. In England, you did not, in general, have the right to be represented by a lawyer in a criminal case of any seriousness. The theory was that the judge was an honorable and fair man who would look out after your interests. The colonies ultimately rejected this English view, and the Bill of Rights provided for a right to counsel. I'd like to mention one other aspect of colonial criminal procedure which would strike us today as quite odd, but which illustrates something rather interesting and important about the development of a common law system. I'm referring to the practice called benefit of clergy. In a number of the colonies, particularly in the South, if a man was accused of a crime, he could plead benefit of clergy. This was an ancient institution which goes back to the medieval period. At one time in England, the church had its own system of courts. If a person was accused of a crime and the person claimed to be a monk or a priest or a nun, then the courts had no jurisdiction over him or her. The defendant had to be transferred to a church court. This was called the benefit of clergy. Well, how did you know if a person was a member of the clergy? Well, one way to know was to ask them if they knew how to read, because basically only members of the clergy could read and write. Over the course of time, benefit of clergy turned into something quite different. If you asked for benefit of clergy, you didn't have to be a clergyman at all. And then you were asked whether you could read or write. And then you would reply, yes, I can read. But you didn't even have to read because the Bible was opened up and it was always open to the same verse. All you had to do was memorize this one verse and you could have the benefit of clergy. If the alternative is being hanged, I think it's easy to memorize one verse from the Bible, from the book of Psalms. Now, what happened to you if you pleaded benefit of clergy? Well, you didn't get hanged, but you didn't get off scot-free. Instead, you were branded in the thumb with a hot iron. And there are many instances in which this was done, for example, in colonial Maryland. In other words, benefit of clergy had become a way of saying, for certain crimes, not murder, of course, but for certain other crimes, a first offender will not be punished very severely, but will simply be branded on the thumb. Why didn't the courts just say so? Why didn't they say, okay, we want to be lenient to first offenders? Why did they go through this rigmarole of pretending that you were a clergyman, which you weren't, that you could read, which you may not have been able to, and that you were being sent to another court, which you weren't? The whole thing was a charade. It was a legal fiction. And the answer is that the common law often used legal fictions as a way of changing the law without admitting you were actually changing it. There are many other examples of legal fictions in the history of the common law. Benefit of clergy is only one of them. For example, there was a special court system in England, the Admiralty system, which dealt with matters that occurred on the high seas. Eventually, the Admiralty courts also took jurisdiction over commercial contracts that related to ocean commerce. These contracts were not executed on the high seas, but in London. In order to give jurisdiction to the courts of Admiralty, the plaintiff in a case involving a contract, a maritime contract, would come into court and say, we entered into this contract on the high seas, to wit, in London. Now, I know it rains a lot in London, but London is not on the high seas. And of course, the judge and everybody else knew it, but no one was allowed to contradict this. So the legal fiction which we see in benefit of clergy was a common device of the common law for evolving with and at the same time denying the fact of evolution. And this is a general characteristic of the common law. It was less true of the northern than the southern colonies. The southern colonies, in this way and many other ways, were always more conservative. The northern colonies never used benefit of clergy at all. Another aspect of criminal procedure worth talking about is the jury. As I said, the colonies used a jury of 12, which would be quite familiar to us. What would be less familiar is the fact that in many cases the jury was less independent than it is now. There are cases on record in which judges told a jury, I don't like your verdict, go back and think about it some more. This would be impossible today. The judge is not allowed to contradict a jury's finding. But at this point, the jury was still in the process of its slow evolution toward its modern state. In other words, there were many aspects of colonial criminal procedure which differed from modern criminal procedure. These differences are not accidental or random. They relate to the type of society that people were living in. In this lecture, we began by discussing the punishment of what we would now call victimless crimes. The point we made is that these were basically theocratic societies, or at the very least societies that took very seriously the notion of punishing sin and crime as if they were the same phenomenon, and refusing to make a distinction between them. We also showed that the forms of punishment, particularly the use of stigma and shame, and other aspects of didactic theater, like the ways in which hangings were arranged, were used to convey lessons to the community and were based on an implicit theory that in a society of this type, the community was the source of redemption and an instrument not only for inflicting punishment, but for teaching people the rules and regulations. Later, when we talk about the 19th century, we will see how the ways in which society changed, and changed dramatically, had a corresponding effect on the theory and practice of criminal justice.
After listening to Lecture 3, a student posed this question to Professor Friedman. Is there such a thing as victimless crime? Let's listen to the professor's response.
I think it's arguable whether there is or is not such a thing as victimless crime. We use the term today, and as I suggested, I think the term is emotionally loaded. Take adultery, for example. This is supposed to be a victimless crime because it's consensual. On the other hand, there is a victim, the deceived spouse. In fact, it could be argued that most victimless crimes have a victim. How about gambling? Gambling is a victimless crime where it's still a crime because the gambler wants to gamble and the casino or whatever wants his business. But you can say that the gambling hurts the whole community. In fact, the argument made by the Puritan communities is not so absurd as we might think. That is, in many cases, what we consider victimless crimes can arguably be said to hurt the morals or the way of life of the whole community. The real issue is not whether or not they're victimless, but whether or not we want to punish them at all. And this, of course, is something on which we can disagree. Interestingly, although most victimless crimes today have been decriminalized, this is definitely not true of the drug laws. These are technically victimless crimes because the drug seller and the drug buyer are acting perfectly consensually. But we don't accept this as a reason for not punishing both of them.
This ends Lecture 3. The American Legal Experience, Lecture 4, Revolution and the New Republic.
In this lecture, we're going to talk about the coming of the American Revolution, though we're not going to stress the events like the Boston Tea Party and so on that led up to it, but rather how the changes in the social order made the revolution almost inevitable. We're then going to talk about the problems that confronted the newly independent country, how it went about framing a government for itself. Ultimately, this was the Constitution of the United States. What's less often stressed is that each state faced the same problem and also had to draft constitutions. We'll say a few words about these constitutions, too. Then we'll talk about how a judicial system developed independent of the English judicial system, and some of the characteristics of that system, in particular, the development of the amazing power of judicial review. And lastly, we'll say something about how a kind of native common law system developed in the early years of the Republic. The political events that led up to the American Revolution in the late 18th century are fairly familiar to all of us from study in school. The controversy over the British trade laws, the Boston Tea Party, and many of the other incidents that finally came to a head with armed conflict in the 1770s. The political disputes with England were very important. The colonists certainly put stress on them. No taxation without representation, irritation at many of the trade and navigation policies of the British. But more important, perhaps, than these political controversies were some cultural differences. The two countries had traveled in very different directions politically, economically, and socially. I've already mentioned what I consider the most important one of these. On this side of the Atlantic, land was very widely held. This was even relatively true in the plantation South, and it was absolutely true in the northern colonies, which were organized on the family farm system. England was controlled by the landed gentry. English society was hierarchical. At the tip of the hierarchy stood the king. And in legal theory, all offices were held of the king. The king was the fountain of honors, the fountain of offices. The king, his court, his favorites, the little circle of upper nobles who surrounded him, they were the very core and center of the country. The colonists had no such society. They had the habit of governing themselves. Their society was relatively open and egalitarian compared to the English system, which was much more patriarchal and hierarchic. English society was bound together in knots of deference and authority, but these aspects of the social order had loosened considerably in the colonies, and an entirely new kind of society had developed. Now, I know that from the standpoint of the 21st century, it's almost absurd to talk about American society in 1776 as open and egalitarian. We all know that a large percentage of the southern population consisted of black African slaves. There was nothing open and egalitarian for them. Even in the North, there were large numbers of indentured servants. There were, of course, children, and, of course, women, and particularly married women, as we will discuss later, were under very severe legal disabilities. When we say society was open and egalitarian, we really mean it was open and egalitarian for northern white men. This is a very important point to make, that the openness was limited in this regard. But if we compare American society not to America as it is today, but to contemporary England or France or most other countries, it looked amazingly open and egalitarian. In any event, the real differences between the two countries were found on this plane of culture. The typical American, simply could not understand the British mentality. And the British parliamentarian simply could not understand the American mentality. Eventually, the two sides came to blows. In the end, the United States prevailed and was faced now with the problem of forming a new political system. In this new republic, there were many elements of continuity. The common law system remained totally in effect. The courts continued to function and to apply the law that they were used to applying. However, there was the problem of organizing a central government. This was the main job the country faced after the War of Independence. The monarchy had been overthrown. King George no longer had any authority in this country. There was going to be a new system, a new state. It was not going to be based on loyalty to the crown, but loyalty to a system of order, loyalty to law. New political ideas were in the air, and they rested on assumptions that were foreign to the English legal order. There were concepts of equality, as I said, at least for adult white men, and concepts of the sovereignty of the people, for example. Structuring the new government would not be easy, and it would have to incorporate some of these ideas. The individual colonies had been virtually independent of each other. They cooperated more or less in running the war, but they were very jealous of their independence. The first plan for a central government was the Articles of Confederation. The Articles of Confederation called for a very weak form of central government. For example, there was a clause in the Articles about the right to make war. The United States in Congress could make war, but only if 9 states assented. And this was true of appropriating money for an army and navy, appointing a commander-in-chief, and so on. 9 states had to agree. This was typical of the way in which the states had retained a great deal of sovereignty, and the central government was weak and relatively powerless. It became clear to a lot of people, and fairly soon, that the Articles of Confederation were not working the way they wanted them to. A constitutional convention gathered in Philadelphia and drafted a constitution, and it was adopted after considerable controversy and debate. It is this constitution which is still in effect. This is our constitution. It provided for a somewhat stronger central government. It set up a system of 1 president, 2 houses of Congress, and a national court system. But it was still a federal republic. The states retained an enormous reservoir of power. The Constitution also embodied a whole series of compromises between big states and small states, for example. In the Senate, big and small states had equal representation. Delaware had the same 2 senators as Virginia. This still is the case today. My state, California, with over 30 million people, has 2 senators, and so does Wyoming, with less than 1 million. The Constitution also embodied some compromises on the subject of slavery, but the essential plan proved to be very durable and very effective. The constitutional idea was already in place in the states. In fact, we have to say something about the whole idea of a constitution. It is a very familiar idea today, but I believe the American Constitution was the first of its type ever to be adopted. The colonies were, however, used to the notion of being guided by a fundamental written document. Many of them had begun with a kind of charter or statement of their rights and duties. And many of the colonies had drafted constitutions right after the Declaration of Independence. Some of these constitutions contain bills of rights, that is, lists of fundamental rights of the people. For example, Virginia adopted a constitution in 1776. The Virginia Constitution began with a Bill of Rights. Section 1, all men are by nature equally free and independent, have certain inherent rights. Then went on to more or less say what these rights could be. For example, Section 9, excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And Section 11 said that the ancient trial by jury ought to be held sacred. A number of the states had bills of rights, and when the Constitution was adopted, one of the criticisms that was made of the Constitution was that it lacked a Bill of Rights. So soon after the adoption of the federal Constitution, a Bill of Rights was engrafted onto it as a series of amendments. The Bill of Rights guaranteed freedom of speech, religion, and the press. It also contained rules to guarantee the right to trial by jury and to a fair trial in general. It outlawed cruel and unusual punishment too, and unreasonable searches and seizures. It seems clear from the history of the Bill of Rights that the Bill of Rights was meant to apply basically to the federal government and not to the states. The states, in turn, had their own bills of rights. From the standpoint of today, it may seem a little odd that a Bill of Rights in the federal Constitution had nothing to do with the states, but we have to remember that from the standpoint of the late 18th century, one of the problems to be dealt with was the possibility of tyranny from a central government. This helps explain the whole idea of checks and balances, and the reason why the Constitution so sharply limited the powers of the national government. The colonists were much more afraid of a strong central government than they were of the governments of their own states so close at hand. There's a famous statement by Tip O'Neill that all politics is local. I actually think this isn't true today, but it certainly was true in the 18th century. Local politics, local government, and the localities were much more important than the central government. After all, transportation was crude and primitive. To travel from Massachusetts to New York was a chore, and to travel from Massachusetts to Virginia was even more difficult and slow. There was no telephone, telegraph, or ways of communicating rapidly between parts of the country. The country was decentralized, in other words, not only as a matter of theory, but much more importantly as a matter of substance. I have mentioned that each of the states had their own constitution. Some of these constitutions were enormously interesting. Many of them were important influences on the federal Constitution. This was the case of the Bill of Rights, for example. In turn, afterwards, the federal Constitution influenced many of the state constitutions. One of the most interesting of the early constitutions was the Pennsylvania Constitution of 1776. I want to mention one specific aspect of this Constitution because it leads me into the next subject that I want to talk about, and that is judicial review. Under the Pennsylvania Constitution of 1776, a very peculiar body was to be formed called the Council of Censors. The Council of Censors was to act as a kind of guardian of the Constitution. If it saw something happening in the legislature that it believed might be a violation of the Constitution, it had the right to recommend changes, and in fact, it had the right to call a convention to amend the Constitution. Now, the Council of Censors was a rather peculiar institution and in the end quite ineffective. It didn't last very long because the whole Pennsylvania Constitution was thoroughly revised in 1790 and the Council of Censors was ended. It does illustrate something, though, very important in the legal culture of the times. What was the idea behind the Council of Censors? It was the idea of checks and balances. The Constitution was going to institute a legislature. The legislature was going to meet and pass laws. There was also a written Constitution. Suppose the legislature violated the Constitution. What then? The answer in England, of course, was obvious. There was no Constitution, and therefore Parliament could not violate something that didn't exist. But once you had a written Constitution, you faced the question, what happens if the Constitution is violated? The Council of Censors shows Pennsylvania groping for a solution. What's important about it is not the precise solution, but the idea that some solution had to be found. This brings me to the great case of Marbury versus Madison in 1803. Marbury versus Madison was decided by the United States Supreme Court. The federal Constitution, in one of its innovations, had established a separate federal court system. Each state, of course, had its own court system, headed by what was usually called the Supreme Court, There's a Supreme Court of Pennsylvania, Supreme Court of Georgia, Supreme Court of Virginia. Parallel to the state courts, there was now to be a system of federal courts. The apex of that system was the United States Supreme Court. What was the difference between the jurisdiction of state and federal courts? That's a very complicated question, only partly spelled out in the Constitution. But clearly, any case that arose under a federal statute or involved an act of Congress in any way was a federal case and would go to the federal courts. In Marbury v. Madison, the United States Supreme Court, under its Chief Justice John Marshall, declared that a particular act of Congress was unconstitutional and therefore void, of no effect, a piece of paper. This was an extraordinary assumption of power. Was it intended by the drafters of the Constitution? That is a very difficult question, and it is not clear what the answer is. Whatever they intended, John Marshall asserted the power. And similar powers were asserted by state courts. Each state, of course, had its own constitution, and the Supreme Court was the final authority on the constitution of the state. It had always been conceded that the federal courts had the right to pass on acts of state legislatures, and the Supreme Court decided many important cases on that basis. But Marbury v. Madison was something special. It meant that the Supreme Court had power even over the National Congress. This was a power, of course, that no English court had ever asserted. By no means did everybody acquiesce in John Marshall's decision. It was bitterly criticized. Marshall had been appointed by a Federalist president, John Adams. The president, when Marbury v. Madison was decided, was Thomas Jefferson, a member of a different party and an enemy of the Federalists. Jefferson was by no means happy with the idea of supremacy vested in the federal judiciary. He had not appointed the vast majority of the federal judges. They had been appointed by his predecessors. He is said to have said, "Few die and none resign." But ultimately, the nation acquiesced in the assumption of power in Marbury v. Madison. As we will see later on, judicial review has become more and more important over the years. Today, it is one of the outstanding features of American government. It is also an institution that has spread throughout the world. Marbury v. Madison does illustrate, however, a problem, or what is felt to be a problem, and that is the power of the judges. There's an old Latin saying, "Who will watch the watchman?" Well, the courts would watch over the actions of the legislature, but who would watch over the actions of the courts? The courts obviously have enormous power. They have power to make law, and they have power to declare laws made by legislatures to be void and unconstitutional. Perhaps this is too much power. Nothing could be done about the federal courts because judges under the federal system are appointed for life. Once a judge is appointed, the only way to get rid of him is to impeach him for high crimes and misdemeanors. This is a rare and dangerous action. In a number of famous instances, impeachment was in fact tried. The most notable instance was the attempt during Jefferson's presidency to impeach Chase, a Supreme Court justice. It failed by a very narrow margin. The states went along a different path. In the course of the first half of the 19th century, they evolved a system of electing judges. The election of judges is a solution to the political problem which the power of judges presents. If judges really do exert so much power, perhaps we ought to make them subject to the will of the people. And the way to subject them to the will of the people is the usual way, to make them stand for election. This is the theory that underlies the development of the electoral principle. By the middle of the 19th century, virtually every state had swung over to the electoral principle. There were a few exceptions like Massachusetts, but in the typical state, all judges, from the lowest municipal judge to the highest high court judge, was elected in a regular way at regular elections. This is one of the aspects of the American system that seems most bizarre to foreign visitors. As far as I know, there is no other country in which judges are elected. Judges are certainly not elected in England. The continental solution to the power of the judges, or their excessive power, or their potentially excessive power, is to make them more like civil servants and to inculcate in them an ideology of judicial restraint. They are to be treated only as craftspeople, interpreting the law narrowly according to professional norms. I think Americans were much more realistic about what judges actually do and recognize that, particularly in a common law system, they're making up a lot of the basic rules, and they are also deciding cases that are terrifically important politically, economically, or in any other way. Hence, the idea of controlling them by subjecting them to the people seemed to make eminent good sense within the context of the United States. The judges under a common law system make law. Exactly what sorts of law were they making? Here I'd like to refer to a very interesting, somewhat obscure case decided very early on by the United States Supreme Court. The name of the case is Calder versus Bull. The precise issue in the case isn't particularly important, and there wasn't any particular disagreement about the outcome among the justices. What is interesting about Calder versus Bull is a little colloquy between two of the justices on an issue of enormous importance. The issue is simply this: are there some basic principles that are so fundamental that they don't have to be written into a constitution? Is there such a thing as natural justice, so that a law which is against natural justice is just void, and it doesn't matter what the Constitution says? Or to put it another way, along with the written Constitution, is there an unwritten Constitution, a Constitution which is higher than the Constitution itself and which governs it? And one justice thought, yes, there was such a thing. There were principles of natural justice, of fundamental fairness, which exist and which can be applied by courts, regardless of what the Constitution says. But the other justice disagreed and said, look, once you have a written Constitution, that Constitution provides the whole of the fundamental law, and the only role of the judges is to interpret the Constitution. There can be and is no unwritten Constitution. This is an important debate, but the debate quickly ended. Everyone agreed that there is no unwritten Constitution, that if something is not in the Constitution, it is not part of our fundamental law. And to this day, this remains the theory. What's interesting is that the practice is entirely different. The Supreme Court, in theory, only interprets the Constitution. But as we shall see later, vast body of modern constitutional law was developed by the United States Supreme Court in ways that very often have only the most thin and gossamer connection to the written text of the Constitution. We've tried to stress a number of points in this lecture. First, the social and political conditions that led to the formation of the Revolution and a new country. Second, the ways in which the new country faced the issue of creating a frame of government appropriate to it, the experiment with the Articles of Confederation, and the drafting of federal and state constitutions. Lastly, we talked about the development of judicial review and the problem of controlling the power of the judiciary and the various solutions devised in this country. In the next lecture, we will consider how the legal system played a role in the economic development of the country in the first half of the 19th century.
This ends Lecture 4. Remember to visit this course's webpage at www.modernscholar.com, where you'll find additional information about the lectures you just heard. The American Legal Experience, Lecture 5, Law and Economic Development in the 19th Century.
In this lecture, we're going to talk about the role of law in the economic development of the United States in the first half of the 19th century. This was, in fact, a period of very rapid economic growth. To what extent did the government and the legal system play a role in this dramatic story? We're going to talk first about the relative positions of the state and federal governments. We're also going to see how the public land policy affected the growth of the country. Government involvement in the economy, as we will see, was largely promotional. That is, it was designed to stimulate private enterprise much more than to regulate or control it. We're also going to see how economic considerations played a role in the development of a branch of law which on the surface seems to have very little to do with economic development. This is the law of torts, in particular the law relating to personal injuries. We're also going to take a look at the development of the business corporation during this period. People very often assume that the 19th century was a period of laissez-faire, that is, a period of minimal government. One of the reasons for this impression is because we're used to taking a look at the federal government. We assume that the federal government is going to be the branch of government that plays the largest role in regulating and controlling the economy. But of course, this was far from true in the 19th century. In the 19th century, most of the action was at the level of the states. The federal government did very little. It ran the postal service. It handled foreign affairs. It did relatively little else. Washington, D.C. in, say, 1820 or 1830 was a tiny village. I like to compare Washington in the 19th century with the brain of a dinosaur, a tiny little clump of nerve cells in a gigantic body. Most of the action, such as it was at the state level. There's one big exception to this generalization, and that has to do with the vast public domain. The federal government did have one enormous asset. Early in the history of the Republic, many of the states, like Massachusetts and Virginia, had vast claims to western lands with very uncertain boundaries. These were ceded to the national government to be used as a kind of common fund for the benefit of the whole country. Congress had power to dispose of and make all the necessary rules and regulations dealing with the territories. At the beginning of our career as a nation, most of the population was strung out along the coasts. There was an enormous amount of land inland, but it was thinly populated or populated only with native peoples. The Louisiana Purchase added an enormous new amount of land to the claims of the federal government. And the federal government proceeded to dispose of this land. And it disposed of it basically by selling it to people who had actually settled the land. One of the interesting things about this country, which is strikingly different from Europe, is that we are basically a nation of squares. I like to ask a trivia question. How many of the 50 states do not have a straight line somewhere on their borders? The answer is one, Hawaii, which cheats because it's a collection of islands. Every other state somewhere has a straight line. Some states like Wyoming and Colorado are nothing but straight lines. Under a law of 1796, the government proposed dividing the land into little squares, surveying the land, and then selling it to actual settlers. The land was sold in chunks, basically rectangular chunks. When you fly over the United States, you're struck by the fact that the ground is made up of rectangles, especially the farmlands in the Middle West. Everything is square. Even the cities, the newer parts of the cities, are laid out on rectangular grids. In a city like San Francisco, the charm of the city comes from the fact that a square grid is plunked down on top of an extraordinarily hilly location. In Europe, by way of contrast, and in the very old parts of the oldest U.S. cities, like New York and Boston, there are no straight lines. Everything is higgledy-piggledy. So the very shape of the country was determined by the fact that land here was a commodity and that the public domain was disposed of by being divided into little squares and sold off. The way in which it was sold and the aims for which it was sold were very complicated. In the first half of the 19th century, no area of the law was more important or more closely contested than the law relating to the disposition of the public domain. Was the land to be sold for cash, or could it be sold on credit? Statutes vacillated. What about the rights of the squatters, that is, the people who moved onto the land before it was actually surveyed and proclaimed ready to sell? Did they have superior rights, or were they just trespassers? Ultimately, the answer was that they had superior rights and would be given preference. This is because, whatever their moral claims, they were definitely voters. The basic use that the land was put to was to settle the West. This is not only policy that promised to bring some money into the federal government. Much more important was the fact that this was a response to the land hunger of the growing population of the country. But the land could also be used as an asset by the federal government. Indeed, it was practically the only major asset that the federal government owned. From the very start, then, the government could use this land to try to pursue some policy. During the Revolutionary War, for example, the Continental Congress had little or no ways to induce people to join the army. They could appeal to their patriotism, but that only goes so far. What Congress did was to promise bits of public land to soldiers. So much for a private, so much for a corporal, so much for a major, so much for a general. These grants did not require anybody to actually go and live on the public land, but the right could be sold. In the early part of the century, land rights of this kind circulated and were sold and had markets somewhat like the stock market in later times. The disposition of the public domain is, I think, emblematic of government policy with regard to the economy in general. The government involvement was largely promotional. It was designed to stimulate the conditions under which wealth would increase. The great legal historian Willard Hurst has used the phrase, the release of energy. The government was intensely involved in policies that would stimulate the economy. In a way, it's kind of misleading to say government as if this was a separate entity. What I mean is that the voters, the mass of the population, wanted the economy to be stimulated. They wanted public help in financing and building roads, canals, turnpikes, and then railroads. Farmers and small merchants were very eager, in particular, to stimulate the building of railroads. The typical Illinois farmer, for example, who lived on his farm, grew more crops than he needed for his family's consumption. In order to improve his economic condition, or to put it more bluntly, in order for him to get rich, or at least richer than he was, he had to sell his crops. To whom would he sell his crops? Not to his next-door neighbor, the farmer, because he too was growing wheat and other crops. No, the success of the Illinois farmer depended on his ability to sell his crops to people who lived in New York, Philadelphia, and the cities in the East. In order to do this, he had to get his crops to the market. Hence, he was vitally interested in government help for building roads, bridges, canals, turnpikes, and, most of all, ultimately, the railroads. There were some notable enterprises of this kind that were actually owned by the states. Eventually, disillusionment set in, usually after some kind of period of financial crisis. And at that point, the railroads and the like reverted almost totally to private ownership, but usually with some measure of public support and later public control. There was also intense legal activity and controversy about banks, insurance companies, and the money supply. The tilt toward a market economy also resulted in a vast expansion of the law relating to contracts, that is, voluntary market transactions. A lot of very important doctrines of the law of contracts developed in the early part of the century. It's difficult always to summarize a country of this size and policies over a 40 or 50-year period. But it's hard to resist the dominant impression mentioned earlier that government involvement in the economy, though often intense, was largely promotional and only designed to help private business and private citizens improve their economic condition. This point shouldn't be over-exaggerated. There was a considerable amount of regulation in the interests of public health and safety, or to conserve resources, or to promote the general welfare. States passed laws to guarantee the quality of certain products, especially export products. Let's take a look at the laws of one state, the northern state of New Jersey, in the 1840s. If we looked at the collected statutes of New Jersey, we would find the state doing a lot less than it does today, to be sure. But we would still find quite a bit of what we could honestly call regulation of the economy. For example, there was an elaborate statute on inns and taverns requiring licensing. There was a law about railroad safety and steamboat safety. There was a law on the regulation of herring, which was packed for export. There was a tax placed on hawkers and peddlers. There were provisions for the building of roads. One of the interesting things about this provision, quite typically, was that everyone was required to labor on the roads. Instead of raising taxes for roads, taxation was something that states did very little of. The state required each adult male citizen to spend a certain amount of time every year actually working on the roads. If you had money and didn't feel like this kind of labor, you could substitute money for the labor payment. There were also provisions about gunpowder manufacturing, not to be within a quarter mile from any town or village. There was also restrictions on the sale of firecrackers, regulations of clams and oysters setting a season, and other rudimentary conservation measures. For example, no muskrats could be trapped between April and December. Economic considerations were also crucial in the development of tort law. Tort is a legal term which is mostly defined as a civil wrong. If a person backs his car into mine in a parking lot and dents the fender, and it's his fault, well, he's done a wrong. But it's a civil wrong, by which I mean simply that he's not going to go to jail for it. He's simply going to have to pay me some money. The heart of the law of torts is the law relating to personal injuries. Personal injuries basically were a product of the Industrial Revolution. Before the Industrial Revolution, of course, people were injured. They fell into ditches. They could be hit by a carriage. But it really took the invention of the steamboat and the railroad to mangle bodies and cost lives on a scale that created an actual social problem. The steamboat was a marvelous invention, but it was powered by boilers that had the disconcerting habit of blowing up from time to time. Railroads had a tendency to run off the tracks. In almost all cases, the plaintiff, that is the injured party, in a lawsuit was an individual. The defendant, of course, was a business. The business was a railroad or a steamboat company or the owner of a factory or mine. A cluster of rules developed in the 19th century to distribute the risk and the cost of these accidents somehow. Was the plaintiff, that is the injured person, going to win most of the time, or was the railroad or steamboat company? In developing the law, really almost out of nothing, the courts used as their key concept the concept of fault. There was liability on a railroad, for example, only if the defendant was negligent. That is, if its behavior did not live up to the standard of the reasonable man. Now, this may seem like a perfectly logical rule and perfectly understandable, and perhaps it was. But it's quite a contrast to the rule that was developed for damage to property. If you shipped goods on the railroad and the goods were damaged, the railroad was simply liable, absolutely liable, no excuses allowed. It didn't matter if the railroad was careless or not careless. The idea was you shipped, they hurt, they pay. But for people, for individuals, for passengers, the rule was quite different. Here the fault principle operated. There's a lot of arguing among scholars over whether or not this was intended or not intended to be a kind of subsidy to the railroads. My own view is that nobody intended anything, but that the temper of the times was such that the railroads were genuinely popular. The farmers wanted them, the merchants wanted them, everybody wanted them. A rule that distributed the loss on the railroad would have been an unpopular rule. The most notorious of the rules that limited liability on the part of corporations, particularly railroads, was a rule called the fellow servant rule. It appeared in the 1840s and spread to every state. The most influential decision was a Massachusetts decision, the Farwell case, decided in the 1840s. Nicholas Farwell was a railroad employee. He was injured on the job. He sued his employer. He claimed that the injury was caused by the negligence or carelessness of another employee. The case went up to the highest court in Massachusetts. Presiding over the court was a judge named Lemuel Shaw, a very brilliant judge, powerful jurist, and, incidentally, the father-in-law of Herman Melville. Shaw denied recovery. According to Shaw, when a person signed up for a job, he entered into a labor contract, and the risks of the job were included in the terms of that contract and affected the wage rate. Consequently, one employee could not sue his employer for the negligence of another employee. The term servant was often used in the 19th century to mean employee, and this came to be called the fellow servant rule. In hindsight, it seems extremely calloused and biased. It seems an act of gratuitous cruelty for poor Nicholas Farwell, who was severely injured and undoubtedly unable to work anymore. This in a time in which there was only a rudimentary welfare system, basically the poorhouse, and in which there were no government programs, no social safety net whatsoever. The Farwell rule, the fellow servant rule, was, however, infectious. Every single state in the next few years adopted it. Many of the early cases were railroad cases, and as we noted, the railroads were genuinely popular with farmers and small merchants. Again, we can't read Shaw's mind, and we can't determine if he really deliberately wanted to favor the railroads at the expense of railroad workers. Probably no such idea was in his head, at least consciously. But it cannot be a mere coincidence that the whole tenor of the early 19th century tort rules tilted toward enterprise. This was, as we said, a period that believed very strongly in economic growth and that wanted nothing to stand in the way of economic growth. To someone like Shaw, the fellow servant rule was an excellent rule for distributing loss and preventing an undue burden from being placed on the nascent railroad net. It is often said that the 19th century was a period that favored property rights, and this is to a certain extent true. But there really was a bias in the law toward a particular kind of property, which we could call dynamic property, entrepreneurial property, property that was not static or vested, property that was being used. Again, this is in line with the dominant ethos of the time, the ethos that favored promotion of the economy. Property was a valued good, but it had to be used for the public interest, that is, in increasing the stock of national wealth. This tendency is illustrated by one of the most famous cases of the first half of the 19th century, the famous Charles River Bridge case. The issue in the case was the interpretation of a clause of the federal Constitution. The federal Constitution forbade the states from impairing the obligation of a contract. The Supreme Court had expanded the meaning of this clause in a notable series of cases. One of these cases, the Dartmouth College case, had to do with the charter of the Dartmouth College, which, of course, as you know, is a college located in New Hampshire. The Supreme Court decided that a corporate charter granted by the legislature was a kind of contract between the state and the corporation. The state could not alter, amend, or otherwise change the charter later on. This would be an impairment of the contract, and the Constitution did not allow it. The point of the Contracts Clause was essentially to prevent the states from intervening on behalf of debtors during times of economic crisis. The Dartmouth College case really extended the Contracts Clause considerably, but it opened the door to the Charles River Bridge controversy. Massachusetts had authorized the construction of a toll bridge over the Charles River many years earlier. Later on, they gave a charter to another bridge company. The second bridge was to be built very close to the first one, and the second bridge was going to be a free bridge. The owners of the first bridge, rather naturally, sued, claiming the legislature had destroyed the value of their franchise. They invoked the Contract Clause of the Constitution. Their argument was that if you charter a bridge over a particular river and you authorize the owners of the bridge to charge tolls, you really can't turn around and charter another bridge very close by, which will be free, and therefore ruin the business of the first bridge. This has to be read into the contract, even though it doesn't specifically say so. But the Supreme Court ruled against the proprietors of the original bridge. The opinion was written by the new Chief Justice Roger Brooke Tawney. Among other things, Tawney stressed the importance of progress. Technically, what he decided was that nothing would be implied in the charter, that charters had to be read absolutely literally. But in the course of his opinion, Tawney made some very trenchant remarks about progress and the necessary destruction of old values in favor of new values. What Tawney was saying, in effect, was you can't make an omelet without breaking eggs. He implied that progress meant winners and losers, and that there was no point in shedding too many tears over the losers if the winners stood for something new, something progressive, something that would increase the values in the economy. The old bridge had had its day and must now yield to the new bridge. This was also a period in which the business corporation rose to prominence. Business corporations were known in the 18th century, but there were comparatively few of them. Most corporations were not business corporations at all. They were charters or municipalities. In the business world, partnerships were more common than corporations. Corporations were chartered one by the legislature. Each particular corporation started its life with a statute. The statute chartered the corporation and expressed the terms on which the corporation could survive and gave the corporation whatever powers it might have. But in the course of the 19th century, businesses became bigger. The corporate form became more popular and began to be used more widely for businesses. The corporate form was an excellent way of aggregating capital for major enterprises. The states moved away from the idea of customizing corporate charters. There were so many demands for charters that they cluttered up the legislative docket. The legislatures therefore began to pass general laws. These laws allowed any group of entrepreneurs to form corporations easily and with a minimum of expense. With hindsight, we see that at the middle of the century, in 1850 or so, the economy had grown tremendously and was poised for either further growth. The signs of rapid industrialization and the creation of big business enterprises in the corporate form, this was already on the horizon. In this lecture, we have seen the ways in which the government was involved in the economy in the first half of the 19th century. We stressed the fact that government intervention was mostly promotional. Even the federal government's disposition of the public domain was, on the whole, designed to increase the population and to encourage the settlement of the West by actual settlers. We also saw that the law of torts developed in such a way as to make it easier for large enterprise to avoid liability for accidents, at least for passengers and very much so for workers. We saw also that law tended to prefer property rights that were used to further the economy and that they could define as progressive rather than static or vested. In this dynamic growing economy, the business corporation also became the business form of choice for more and more enterprises. In the next lecture, we will look again at race relations in the United States, at slavery, and its aftermath after the emancipation of the slaves.
After listening to Lecture 5, a student posed this question to Professor Friedman. What other uses did the government find for its land-grant policy? Let's listen to the professor's response.
It's true that the basic thrust of the law of the public domain and the basic thrust of government policy was to dispose of the land to actual settlers. But they did, from time to time, make use of their stock of land to try to pursue other policies. The railroad land grants are a very important example of this. Another example was the creation of the so-called land grant colleges. The federal government gave a kind of dowry to every state out of its stock of public lands. The point was that the states would sell the land in turn and use the money to fund the creation of public higher education.
This ends Lecture 5. The American Legal Experience, Lecture 6, Black and White, Slavery, and its Aftermath in the 19th Century.
In this lecture, we're going to talk about relations between the black and white populations of the United States in the 19th century. First, we're going to talk about what happened to slavery during the first half of the century. Basically, slavery was abolished in the northern states, but continued in the southern states and became more and more entrenched. We'll also see that the existence of slave states and free states created enormous strains, legally and socially, that ended with the outbreak of the Civil War. When the Civil War ended, there was the problem of dealing with the South and dealing with the newly freed slaves. At first, the North attempted to impose its rule on the South in the period called Reconstruction and to empower the freed slaves in ways that would have been inconceivable before the Civil War. But when Reconstruction ended, the North more or less withdrew. The Southern states were left to run their own affairs. White supremacist governments took over in the Southern states and imposed a rather severe form of oppression on the black population. We'll begin by taking a look at what happened to slavery in the period right after the Revolutionary War. You'll remember that during the colonial period, there had been slaves in every colony. After the Revolution, however, the country divided into slave states and free states. The northern states abolished slavery and freed their existing slaves. It's also true that at this time, the system of indentured servitude more or less came to an end. The result of Northern emancipation was that for the first time we could talk about free states and slave states. The Northwest Ordinance of 1787 provided for the development of government in the Old Northwest. This is the area of the country that includes present-day Ohio and other Midwestern states. At the time, in 1787, it was very lightly populated. The Northwest Ordinance prohibited slavery in this entire region. In general, during the rest of the period before the Civil War, there was a close balance between the number of slave states and free states. This balance was carefully preserved by a whole series of compromise laws. The most famous of these was the Missouri Compromise of 1820. Under the Missouri Compromise, Missouri was admitted to the Union as a slave state, and Maine was admitted to the Union at the same time as a free state. Because each state had 2 senators in the Senate, it was important to the South, which was outnumbered in population and wealth by the North, to preserve a balance between the numbers of free and slave states. In the South, slavery was a very important institution economically and socially, and it became even more important over time. Slaves, of course, worked on the large plantations. They were the farmhands that gathered the cotton and other crops. But they also toiled away in factories, hotels, and stores, and thousands of slaves worked as domestic servants. Each state of the South maintained an elaborate slave code. Law and custom regulated the slave population tightly. For example, the laws placed restrictions on the right of a slave owner to free his or her slaves. The freeing of a slave was called manumission. Laws in the South often provided that if you freed slaves, these slaves had to leave the state quickly and never come back. To be sure, this was never fully enforced, but it indicates that the South really did not want to create a sizable class of free blacks. Of course, each state did have a population of free blacks, but nowhere in the South were they allowed to vote, and nowhere were they accorded full rights as citizens. They were always treated more or less as semi-citizens or, at best, second-class citizens. It must be admitted that this was also true for the most part in the North. Meanwhile, the enormous economic significance of slavery for the South meant that there was a huge body of commercial law which regulated traffic in the bodies and labors of slaves. In legal theory, slaves were entitled to decent treatment. But the slave codes made it clear that decent treatment for a slave was not what we would consider decent treatment for anybody else. For example, slaves were not supposed to be educated. It was an offense to teach a slave to read or write. Slaves were not allowed to marry. In fact, many slaves, perhaps most slaves, were married in the sense of entering into a long-term union, and on some plantations the slave owner would allow these unions and in fact allow a certain ceremony. But legally speaking, no slave was married and no slave child was legitimate. These codes of law enforced a caste system, even in those cases in which the unusual owner wanted to act otherwise. For example, North Carolina and other states prohibited letting slaves hire out their own time. This meant that it was an offense for an owner to let a slave go free in the sense of going into town and getting a job and using the money to buy his own freedom. In fact, it was the case that some slaves were allowed to do this, and some, in fact, did buy their own freedom, but strictly speaking, this was against the law. Slaves were also not allowed to own any property. There are cases on record, for example, in which white men are fined on charges of, for example, allowing a slave to own a horse. A lot of the anti-slavery literature stressed the cruelty of the system. Law and custom granted owners almost absolute rights over their slaves, including the right to punish them. The whip was in universal use on plantations. Some owners used it sparingly, and some used it very, very frequently. Even punishment that was extremely severe, even punishment that resulted in death, was essentially within the power of the master. It is true that according to the slave codes, if a master treated a slave with particular cruelty, the master could be prosecuted. And there are, in fact, a small number of cases in which owners of slaves were prosecuted for murdering a slave. But these occurred only in cases in which the cruelty was so egregious that it offended the rest of the white population, because no slave was empowered to bring a lawsuit against any white person. Books like Uncle Tom's Cabin often stressed other aspects of slavery that were particularly offensive. One was the habit of selling slaves down the river, of splitting up families, separating parents and children, brothers and sisters, and so on. The defenders of slavery often claimed that this rarely or never happened, that masters tended to keep families together. No doubt there were many slave owners who were genuinely concerned with preserving slave families. On the other hand, when a master became indebted, or when an estate had to be divided among heirs, there was practically no choice but to sell the slaves, and sometimes the slaves would be sold in ways that split up families. Research on South Carolina in the 1850s have shown that between 1820 and 1850, about 2% of the slave population was sold each year. By the time a slave got to be 50, he would have had a 60% chance of being sold. And over half of all slave sales were court sales, sales that were made for debts or upon the breaking up of an estate. It seems obvious then that the risk of a slave being separated from his family or her family was a very real risk and has not been exaggerated in the literature. The cruelty of slavery was apparent to some people in the South and to more and more people in the North. Over the course of time, up to the Civil War, slavery became more and more of a national issue. The North resisted the expansion of slavery. The South felt more and more beleaguered. Another fertile source of controversy was the issue of the fugitive slave. Congress passed a fugitive slave law in 1793. It passed a more stringent one in 1850. Attempts to return fugitive slaves led to a number of bitterly contested cases and even incidents of violence in which crowds in northern cities forcibly attempted to free slaves who were about to be returned to slavery. But slaves continued to try to escape. Some slaves fled all the way to Canada by way of the Underground Railroad. As time went on, the positions between North and South hardened. Originally, New York, for example, had a law which allowed slaves temporary residence up to 9 months. The point of this law was this: if a slave owner came to New York on a visit, he would naturally bring with him a slave or two. You couldn't expect a slave owner, for example, to carry his own luggage or to dress himself. The reason why such a law was necessary was because of a doctrine that once a slave entered free territory, the slave became automatically free. This was a doctrine that came from England, from a famous decision by the English judge Lord Mansfield. Lord Mansfield had held that the law of England did not allow slavery, and that therefore when a slave entered English territory, the slave became free. Because of this doctrine, it was necessary, in order to allow Southerners to travel with their slaves into northern cities, for the northern states to have laws of the New York type. What happened, however, as the 19th century wore on, is that the northern states repealed these statutes. New York, for example, repealed its statute in 1841. This meant that any slave entering their territory, whether as a refugee or accompanying a slave owner, was automatically free. This was New York law or Massachusetts law, but it was not federal law. Federal law was that the fugitive slave had to be returned, and that the states had to recognize the existence of slavery, at least to this regard. On the question of the freedom of the slave who somehow entered free territory, this was the issue of the famous Dred Scott case, decided in 1857. Dred Scott had been a slave in Missouri. His owner, Dr. Emerson, a surgeon in the United States Army, had taken him to Fort Snelling, which was part of the Northwest Territory. In the Northwest Territory, slavery was forbidden. Dred Scott and his owner then returned to Missouri, but the issue presented to the federal court was whether or not Dred Scott was now a free man. The case went up to the United States Supreme Court, and the decision was enunciated by the Chief Justice Roger Brooke Taney. Taney came from Maryland and was quite pro-slavery. He went out of his way in this case to defend the rights of the slave states. Much of the opinion was unnecessary to actually decide this issue. Taney held that Dred Scott was not a citizen of Missouri and was not entitled to sue in the federal court. He denied the claim that Dred Scott had become free when he reached Fort Snelling. He also went on to decide that the Missouri Compromise of 1820, enacted 37 years earlier, was unconstitutional. You will remember that this act admitted Missouri to the Union as a slave state and admitted Maine as a free state. It also forbade slavery in the territories north of a certain line. But Taney said Congress had no power to do this. It had no power to prohibit a citizen from holding and owning property in any territory of the United States, north or south. And no black person could be a citizen either of a state or of the United States. What Taney hoped to accomplish in this decision was to put the issue of slavery out of contention once and for all by guaranteeing in constitutional terms the property rights of slave owners all over the United States. But Tawney was wrong if he expected the northern states to accept the Dred Scott case as a good or even a legitimate decision. And indeed, the Dred Scott case was one of many that simply exacerbated the situation and made the clash between North and South more extreme and more pronounced. As you all know, the climax of the dispute between North and South came with the secession of the southern states after the election of Abraham Lincoln to the presidency. There followed the most bitter and bloody war in human history up to that point. Over 500,000 died before the war ended with the defeat of the South. That defeat obviously meant the end of the system of slavery. The Emancipation Proclamation had been a very important symbolic event, but it did not apply to the entire country. After the war, however, the Constitution was amended, and the 13th Amendment made slavery and involuntary servitude illegal in the United States. When the war ended, the question of how to deal with the southern states was very high on the national agenda. For their part, the southern states recognized that they had been defeated. They also recognized that slavery was ended. Most of the southern states then enacted a group of laws usually called the Black Codes. These laws recognized that slavery was over, but they tried to keep as much of the pre-war racial caste system alive as possible. For example, under the Mississippi Black Code, no African American could own farming land. And under this and other black codes, blacks were not given the right to vote, not given the right to serve on juries, or in general to take part in politics. Under the leadership of Congress, however, federal armies occupied the South, ended the period of the Black Codes, and gave political rights to the freed slaves. The period that followed, up to 1876, is called the period of Reconstruction. During this period, many blacks held state offices, blacks served in state legislatures, blacks were elected to Congress. The white South never acquiesced. This was a turbulent period, both North and South. In the South, the rise of the Ku Klux Klan began a period of violence and intimidation of the black population. By 1870, the Ku Klux Klan had been thoroughly established in the South. In Greene County, Georgia, for example, Klansmen seized a black leader and beat him. In Monroe County, Mississippi, Jack Dupre, a black leader, had his throat cut and was disemboweled in the presence of his wife simply because he was a black leader and president of a club of Republicans. White carpetbaggers were also whipped. In Mississippi, a black was whipped for suing a white man. In Louisiana in 1872 occurred the so-called Colfax Massacre. In a bitter election struggle between the two main political parties, whites stormed the town and killed 280 blacks. There were attempts to enforce acts against the Ku Klux Klan and some sporadic drives and some federal legislation. But these acts were hard to enforce. Local juries did not easily convict people, and if they did, they simply fined them in trivial ways. In 1876, Reconstruction ended, and the South formally reverted to white supremacy and to a regime of racial segregation. A dense network of laws bound the majority of the black population to the soil. It was even a crime for a white person to offer a better job to a farm worker, almost all of whom were black. These were the so-called enticement laws. The vagrancy laws were interpreted in such a way as to make it possible to round up unemployed blacks and turn them into virtual serfs. Through legal and extra-legal devices, the southern states also disenfranchised their black population. The Constitution of South Carolina, for example, in 1895, provided that the only people who could vote were those who could read and understand the state constitution or had $300 in assessed real property. This was interpreted to exclude any blacks. There was also the use of the poll tax and the so-called grandfather clause. Under the grandfather clause that was used in a number of state constitutions, there were stringent requirements for registry to vote. But you could be excused from these requirements if you had fought in the Army or in the Confederate forces, or were descended from anyone who had fought, or were descended from a foreigner. This excluded all blacks and almost nobody else. The results were dramatic. In Louisiana, there were 130,000 black voters in 1896. In 1904, there were 1,300. Literacy, property, and poll tax qualifications in the interim had resulted in the destruction of the black electorate. For those that were still stubborn enough to want to register and could meet the qualifications, a little bit of violence was necessary to persuade them to desist. Black political power was completely at an end. From this point on, there were no black office holders, no black jurors, no blacks in any position of authority throughout the white South. In the late 19th century, the black population was thus under firm, harsh rule. Blacks could expect little or no justice from the courts. The subjugation of the black population and the dominance of the Southern Code was reinforced by an epidemic of lynching, often of incredible brutality. Lynching took place publicly. The victims were often tortured, sometimes burned alive, and in full view of the public and of the authorities. But nobody was ever punished for participating in a lynch mob. This took place in the Deep South. What was the role of the federal courts? Did they do anything to help the cause of black liberation? In the latter part of the 19th century, quite the opposite was the case. Indeed, the Supreme Court in 1875 struck down a civil rights law that attempted to outlaw discrimination in public accommodations. The fact is that the North had lost interest in what it considered the problem of the South and left the white South to pursue its own remedies. The fact of the matter is that while the Northern population at the time of the Civil War and afterwards hated the idea of slavery, this did not mean that they embraced the notion of the brotherhood of all races. It was the institution of slavery that they found offensive. Slavery was a violation of the Northern principle of freedom of contract and free labor. Nowhere in the North, before and after the Civil War, were black people treated as the equals of whites. The Supreme Court, therefore, was simply following, alas, dominant public opinion in the North when they struck down the civil rights law in 1875. At the very end of the century, the court decided one of its most infamous decisions, Plessy versus Ferguson. This was a case in which the Supreme Court essentially enunciated the separate but equal doctrine. Plessy versus Ferguson was a case about racial segregation. The Southern states in the late 19th and early 20th centuries began to pass laws legally establishing a system of apartheid. Schools, of course, were divided into white schools and black schools. The issue in Plessy itself had to do with transportation. Plessy was a light-skinned black man who objected to being placed in a special blacks-only compartment of a train. The Supreme Court, by an 8-1 decision, decided that Plessy had no real case. It was acceptable to segregate the races as long as the facilities were, quotes, separate but equal. Segregation was given a green light, and it was written into law in the South for all areas of life. For example, under the Arkansas statutes of 1903, there had to be separate portions of jails and penitentiaries for white and black prisoners, and separate bunks, beds, and bedding, separate dining tables, and all other furnishings. In any precinct in which more than 100 votes were cast, if there were persons of both races ready to vote, the officials had to segregate the voters so as to permit persons of the white and colored races to cast their votes alternately. In fact, of course, separate but equal was always a facade. The separate part was dutifully carried out and enforced by the South, the equal part never. But the courts, including the federal courts, turned a blind eye to these issues. The history of black-white relations in the 19th century is therefore not in any way a pretty picture. In the first half of the century, although the small black populations in the North were emancipated, slavery in the South took deeper and deeper roots. Anti-slavery passion of the North extended basically to the institution of slavery and to what it meant for the country. It was by no means a conviction of racial equality. The Civil War brought an end to slavery, but it did not end the racial caste system, either in the South or in the North. The results in the South were particularly unfortunate. By the end of the century, the South was a fully segregated system in which the black population had no political power and relatively little economic power. The vast majority of the blacks were tied to the soil as an illiterate class of serfs. The northern courts and the federal courts did nothing to interfere with the system at this point, and in fact, in the Plessy case, gave their seal of approval to America's system of apartheid. In the next lecture, we will take a look at other racial minorities in the United States and also a look at the developing law of immigration.
This ends Lecture 6. If you borrowed this course from a public library and would like your own copy of the course guide for future reference, call Recorded Books at 1-800-636-3399 and we'll send you a free copy. A shipping charge will apply. The American Legal Experience, Lecture 7, The Other Americans, Natives and Immigrants.
In the last lecture, we traced the unhappy story of the relationship between whites and blacks in the United States in the 19th century. In this story, we're going to deal with other American minority groups. We'll say a word or two about religious minorities, and then about the Native Americans, and about the Chinese. The treatment of the Native Americans and the treatment of the Chinese is, like the treatment of African Americans, nothing for the country to be proud of. They did, however, differ in some very interesting ways. The goal of policy with regard to Native Americans was one of assimilation. The goal of policy with regard to the Chinese was expulsion. In this lecture, we'll explore exactly what these policies were and why they came about. In this lecture, we also will talk a little bit about the rise of immigration law and how the United States changed from a country which, at least in theory, had open arms toward anyone who wanted to settle here, and a country in which immigration was very strictly limited in ways that were quite discriminatory. We want to begin with a word or two about religious tolerance in the United States. On the whole, from independence onward, the United States and the constituent states maintained policies of toleration of religions. This was a country of many religions from the very beginning. It was a country also in which there was no history after independence of persecution of any of the established religions in the country. All were free to build their houses of worship and to worship God as they saw fit. This does not mean that there weren't examples of religious prejudice. In the first half of the century, there were a number of incidents of anti-Catholic rioting, some of them quite violent. But perhaps the most outstanding example in U.S. history of controversy over a religious group had to do with the Church of the Latter-day Saints, commonly known as the Mormons. They were severely persecuted from the very beginning, and ultimately, as is well known, their leader, Brigham Young, took them out into the desert state of Utah, where they founded Salt Lake City and created what was in effect a theocracy in territorial Utah. The Mormon Church was very controversial from the outset, especially because of the practice of polygamy. The federal government, responding to widespread propaganda and horror stories about the sexual practices of the Mormons, much of it exaggerated if not untrue, enacted a series of laws aimed at stamping out the offense of polygamy. One of these laws, the Edmunds Act of 1882, created a new offense of unlawful cohabitation. It was made a crime for a man to live simultaneously with more than one woman as his wife. This was punishable by 6 months in prison and a $300 fine. The federal government had jurisdiction, of course, because Utah was a territory, not a state, and therefore under the control of the federal government. The Edmunds Act also excluded from any jury persons who believed in polygamy. It was followed by a raid on the polygamous communities of Utah. Hundreds and hundreds of prosecutions followed, and the leadership of the church had to go into hiding. Later, the federal government moved to dissolve the Mormon Church and to seize all its property. At this point, the church in effect capitulated. The president of the church, claiming a revelation, renounced polygamy. The seized property was returned, and pardons were issued to the convicted polygamists in 1893 and 1894. The Mormons have long since re-entered the mainstream. Religious minorities in general have fared better than racial minorities. But the example of the Mormons show that there have always been limits to the tolerance which the ordinary or average American was willing to show toward religions whose precepts were found to be in some way offensive to the dominant code of morality. The relationship between white settlers and the native tribes had always been complex. But in general, the native peoples were the victims of the insatiable land hunger of the settlers who pressed in on them from all sides. One striking example was the fate of the Cherokees. Under a law of 1830, the President of the United States was authorized to arrange to exchange land west of the Mississippi for tribes of Indians that may, quotes, choose to exchange the lands where they now reside and remove there, close quotes. Well, the Cherokees who lived in Georgia never, in fact, chose to exchange their lands. They were a relatively advanced tribe. They had set up a written language, adopted a constitution, and declared that they were autonomous from the United States and from the state of Georgia. Unfortunately for the Cherokees, gold was discovered on their lands, and in 1829, Georgia declared that its law, and not Cherokee law, would apply in Cherokee territory. The Cherokee Nation tried to get the Supreme Court to enjoin or prevent the enforcement of Georgia law in its territory. And the case decided in 1832, John Marshall's Supreme Court did decide that Georgia law had no effect in the land occupied by the Cherokees. At this point, there was a kind of stalemate, or apparent stalemate. The Supreme Court had decided in favor of the Cherokees, but the president, Andrew Jackson, simply said the opinion was wrong, and he had a duty to interpret the Constitution as he saw it. He is said to have commented, "Mr. Marshall had made his decision, now let him enforce it." The net result was that the Supreme Court decision ended up meaningless. Over the 1830s, the Army rounded up as many as 100,000 of the Indians in the Southeast and herded them off to the Indian Territory in what is now Oklahoma. This was the so-called Trail of Tears. The Cherokee had won their victory in the Supreme Court, but the Supreme Court lacked the power to enforce its own decision. The power of the presidency, and more significantly, the power of the whites of Georgia and their insatiable hunger for the lands occupied by the Cherokee, was what prevailed in the long run. Thousands of Cherokees died on the Trail of Tears, and the settlers rushed in to take up the land as they were leaving. By the late 19th century, the native peoples had been totally defeated militarily. They had lost most of their lands and had been herded into reservations where they did retain some small measure of sovereignty. In 1887, Congress passed the Dawes Act. This was an attempt to destroy the Indian land tenure system. Most native peoples did not treat land the way it was treated by the white settlers. They believed in communal ownership of land. Under the Dawes Act, an Indian could become a citizen if he or she gave up tribal ownership and converted holdings to individually owned plots, just like the white farmers. Perhaps some of the people who backed the Dawes Act were thinking of the Indians' own welfare. They thought that the Indians were doomed to extinction unless they adopted the white man's ways. In practice, however, the Dawes Act was a disaster. The aim was to assimilate the natives into white society, but the result was even further loss of land and a riot of cheating and divestment. Most of the land subject to the Dawes Act ended up in the hands of whites. Under doctrines of the Supreme Court, the Indians were defined as, quotes, dependent domestic nations, close quotes. But it was never exactly clear what this meant or what the precise legal status of the tribes were. In a case decided in 1903, the Supreme Court tried to give an answer. The court held that Congress had the full power to do whatever it pleased with regard to the native peoples. In other words, the court emphasized the dependent part of the legal situation of the natives. In essence, the Bureau of Indian Affairs ran the reservations in a more or less colonial manner and with deep hostility to Indian culture, language, and religion. It is worth pointing out, however, that this goal of assimilation, although probably in the long run disastrous to the Indians themselves, was strikingly different from the policy with regard to African Americans. There was never any attempt to assimilate African Americans. Intermarriage between African Americans and whites was strictly forbidden, not only in the southern states, but in many other states as well. Intermarriage between members of native tribes and white citizens was never so stigmatized. The black population was considered necessary for the economy of the South, and the caste system was, at least in part, an economic system as well as a social system. The role of the native peoples was quite different, and consequently, while they were equally under the power of the majority, the policy toward them was strikingly different as well. It's interesting also to contrast another minority group, the Chinese. If the aim of policy toward African Americans was subjugation, and if the aim of policy toward Native Americans was assimilation, the aim of policy with regard to the Chinese was outright expulsion. The Chinese came to this country mainly as workers, especially on the transcontinental railroads. They were concentrated on the West Coast, particularly in California. Anti-Chinese sentiment in that state was quite virulent. In California in particular, there were laws and ordinances that discriminated against the Chinese, and there were occasional acts of violence. In 1880, for example, the California Penal Code made it a crime for a corporation to directly or indirectly employ, quotes, any Chinese or Mongolian. In 1885, California law allowed the establishment of separate schools for children of, quotes, Mongoloid or Chinese descent. The Chinese were feared as unfair competition on the labor market. The unions in particular were violently opposed to the importation and retention of Chinese labor. In a famous Supreme Court case, Yick Wo versus Hopkins, decided in 1886, the Supreme Court confronted an ordinance of San Francisco dealing with laundries. Under the ordinance, as a fire prevention method, no laundry was supposed to be made out of wood. But the local authorities were given the right to grant exemptions from this ordinance. Every Caucasian who applied was given an exemption. Every Chinese who applied was refused. The United States Supreme Court struck down this practice and said it was a violation of the constitutional rights of the Chinese. They had a right to be treated as the equals of whites. But this victory in court was a very rare exception. Starting in 1882, federal law began to aim at the elimination of the Chinese community. No Chinese could become a naturalized citizen. Chinese who left the country were not allowed to return. Later in the century, federal law excluded aliens completely from entering the country, first for a period of 10 years, and in 1902 permanently. On the West Coast, it was typical for states to forbid the intermarriage of whites and Asians. Alien land law barred Asians from acquiring land. In this case, the main target was Japanese immigrants. And under the so-called Gentlemen's Agreement of 1907 and 8 between the United States and Japan, the Japanese government promised to keep its workers from moving to the United States. As is obvious from these last few instances, immigration policy and racial policy had become intimately connected. America had expanded from coast to coast. In the process, it gobbled up a large chunk of what was once Mexico. It expanded into the Pacific area, too, with the acquisition of Hawaii. And the war with Spain at the end of the 19th century brought more empire, notably Puerto Rico and the Philippines, territory where the population did not speak English and was most definitely non-white. How would these territories be governed? This was a very important political decision. It was an issue, for example, in the election of 1900 between the Republican McKinley and the Democrat William Jennings Bryan. McKinley won by a relatively large margin. Shortly thereafter, a group of cases came before the Supreme Court. They are collectively called the Insular cases. These were the cases that definitively answered the question: did the Constitution follow the flag? Must we treat these territories as falling totally under the Constitution, or can Congress treat them as colonies? In 1900, under the so-called Foraker Act, Puerto Rico was organized. A governor and council were to be appointed by the President of the United States, and the people were to elect a legislature. But the Foraker Act also provided that merchandise going from Puerto Rico to the mainland was to be taxed. And this was an issue in the most famous of the insular cases. The issue came up because if Puerto Rico was a part of the United States in the constitutional sense, it was impossible to charge a tax on goods imported from Puerto Rico to the mainland. The Supreme Court, however, decided that the Constitution did not follow the flag. Congress could impose a duty on goods from Puerto Rico. More importantly, the decisions implied that Congress could really do as it pleased in the governing of these territories. This meant that for the first time, the United States controlled territory which it could treat imperially, that is, as colonies rather than as territories potentially to become part of the greater nation. According to the majority of the justices, the territories were not ready for freedom. Congress could do as it wished. The court made it clear that there was a racial element in its decision, that the people were not of the same race but were members of alien races differing, quotes, in religion, customs, laws, methods of taxation, and modes of thought, period, close quotes. America was thus, by 1900, a mixture of races and cultures, but also the master of a colonial empire. We have to remember that this was a period of imperialism and a period of racism. It was the height of the British and the French empires. It was also a period in which it was widely believed that the white race was superior genetically and culturally to all the other races. These ideas had an impact on immigration law. They definitely had an impact on Chinese exclusion, which we have already mentioned. During most of the 19th century, there were no formal restrictions on immigration. As far as the formal law was concerned, it was a complete open-door policy. Most immigrants, in fact, were Protestants from Northern Europe. The main exception was the Irish Catholics, and as we saw, they faced discrimination and sometimes even violence. By the end of the century, the nature of immigration changed greatly. Around 1900, millions were pouring into the country from Southern and Eastern Europe. They were Jews, Catholics, and Eastern Orthodox for the most part. The Statue of Liberty has on it a poem which says, "Give me your tired, your poor, your huddled masses." But it wasn't very clear that the majority of the population really was interested in the poor and the huddled masses, particularly if the huddled masses came from non-Protestant parts of Europe. The Chinese were the first to be excluded, but a very strong movement arose to limit immigration from countries that were not Protestant parts of Europe. The eventual result was the Immigration Act of 1924, which established the so-called national quota system. Under this law, a quota was established. The number of immigrants was to be limited. 2% of the number of foreign-born individuals of any particular nationality living in the United States in 1890 could be admitted as immigrants. 1890 was chosen because it was before the great flood of immigrants from Eastern and Southern Europe. The statute was a statute characterized by overt racism and ethnic chauvinism. One of the very interesting things about the immigration law of 1924 is what it did not do. It drastically reduced immigration from such countries as Italy and Greece. It drastically reduced immigration of Jews and Slavs. Interestingly, there was no restriction whatsoever on immigration from the Americas. This racist and restrictive law, paradoxically, said nothing about the rest of the hemisphere. As far as this law was concerned, in theory at least, the entire population of Bolivia could enter the United States without any hindrance. This seems like a curious fact that calls out for some sort of explanation. It is true that Mexico was a special case because of the demand for cheap agricultural labor from Mexico. But partly I think the failure to include Latin America was simply because Latin America was mostly too distant, too traditional, and too poor to constitute the same sort of threat that the Eastern Europeans posed to America's traditional ethnicity. After all, we have to remember that in theory at least, as of 1850 or 1870, the entire population of China or India could have come to the United States, knocked on our door, and demanded to be let in. You can be very sure that if this had happened, or even a little bit of happened, that there would have been quick restrictions placed on immigration, as in fact occurred with regard to the Chinese. This puts in perspective the idea that there was free and open immigration to the United States in the 19th century. Free and open it was indeed, but only on the basis of certain assumptions about who would actually come. Immigration law, therefore, as it developed, was racist to the core and deeply saturated with prejudices with regard to ethnicity as well. Nevertheless, the point must be stressed that the U.S. is what is called an immigration country. It is a country which, throughout its history, has wanted to attract immigrants. It is certainly not unique in this regard. Argentina is an immigrant country, and so is Australia. But unlike the European countries in the 19th century, these were net importers of people rather than net exporters of people. Under the 14th Amendment, everyone born under the jurisdiction of the United States is automatically a citizen. This means, and has been interpreted to mean, that anybody, but absolutely anybody, who is born within our country is automatically from birth a citizen of that country. It does not matter whether they're here temporarily, whether their parents are aliens, tourists, or what have you. So long as the birth takes place on American soil, the child is a citizen of the United States. And this was established firmly by the Supreme Court in decisions in the late 19th century. In this regard, the United States occupies what is in some ways an extreme position. There are many countries, Japan is an outstanding example, in which it is certainly not enough to be born there to become a citizen. You have to be a member of the dominant ethnic group. American law has never taken this position. In this lecture, I've taken a look at the way in which the United States in the 19th and early 20th century dealt with its minorities. We took a look at the treatment of the Mormon minority in Utah, at the very unfortunate history of Native Americans. In the first part of the century, warfare and discrimination led to the expulsion of the native tribes from the areas east of the Mississippi and the creation of a reservation policy. Later, the Dawes Act had a disastrous effect with its policy of economic assimilation. The treatment of the Chinese was one of expulsion and exclusion. The changing demographic picture of the United States and the conquest of foreign territories led to restrictions on immigration, culminating in the 1924 Act with its national quota system, and in the insular cases with the creation of what was in effect an American colonial empire.
This ends Lecture 7. The American Legal Experience, Lecture 8, Family Law.
In this lecture, we're going to look at family law, the law that relates to relationships within a family between husbands and wives, parents and children. This is a very complex and interesting area of law. We're going to focus on 4 issues that are particularly interesting in that they illuminate in a particularly dramatic way the impact of social forces and social norms on the law itself. These 4 are the law of marriage, including the very interesting concept of the common law marriage, the law relating to the property rights of married women, the law of adoption, and the law of divorce, the most complex, interesting, and tangled of them all. We want to begin with an interesting and often misunderstood concept, the concept of the common law marriage. A common law marriage is a marriage without witnesses, without a ceremony. If a man and a woman agree to be married, that is sufficient to make a common law marriage. The important thing to remember is that in states that recognize the common law marriage is not cohabitation, is not something illicit. It is an absolute, perfect, valid, complete marriage with all the legal consequences that flow from a marriage, exactly the same as if the man and woman were married in a big ceremony with a clergyman, guests, bridesmaids, and all the rest of that. The common law marriage was a striking departure from English law. Since the middle of the 18th century, under English law, no informal marriage was possible. Marriage had to be something quite formal. In the United States, however, in the early 19th century, most of the states agreed to recognize the common law marriage. For one thing, there was a shortage of clergy in some parts of the country. Moreover, the common law marriage doctrine was very useful. You'll remember that one of the outstanding features of American social life, a feature that had a profound effect on every aspect of the legal system, was the widespread ownership of land and other property. Unlike England and almost every other country, the average family, certainly in the North and Middle West, owned a piece of land, a farm, a lot in town. Since this was the case, it was very important to know who had rights, who inherited the land, what children were legitimate, who was a widow and who was not a widow. The doctrine was useful, therefore, because it legitimized marriages and children in an age in which record-keeping was very poor, and frankly in which these informal arrangements were apparently quite common. What the doctrine meant as a practical matter was that if a couple lived together, acted respectably, behaved as if they were married, the law would presume that they had entered into a common law marriage. That way, the children were legitimate, and when the man died, his wife was a regular widow who inherited his property. Interestingly enough, the doctrine fell into disfavor at the end of the 19th century and the beginning of the 20th century. One by one, the states began to abolish the doctrine. Today, only a handful of states still recognize it, and even in those states, I imagine that it is very rarely used. What led to the decline of the common law marriage? By now, you recognize that we always look for a social explanation for any important legal change. For one thing, formalities of marriage had become cheap, easy to fulfill, and very accessible. There was no longer any shortage of clergy. 20th century courts and legislatures were afraid of blackmail. They saw the common law marriage as a way for women who were schemers and gold diggers to get their hands on the money of rich dead men they had had sexual relations with. There was another factor, particularly in the early part of the 20th century. This was a period which had begun to believe that criminality, perversion, and all sorts of bad traits were inherited, and that it was very important to control reproduction. If a state recognized the common law marriage, there was no way to prevent unsuitable people from getting married. This included people with venereal diseases, the feeble-minded, the criminal, and the otherwise deficient. So a number of states not only abolished the common law marriage, but insisted at this time that in order to get married, you had to have a license, and in order to have a license, you had to have a doctor's certificate certifying that you were free from venereal diseases or that you were not feeble-minded or both. Besides, common law marriages often made title to real estate a little bit confused. They laid the bases for claims to land and property, but they had no documentary evidence behind them. And American law became quite impatient with a doctrine that had this effect. What is common in contemporary society is not the common law marriage, but cohabitation. All this means is that two people are living together without getting married. What are the legal rights and duties of these unmarried people who are living in a more or less stable or long-term relationship? This is an issue that is still in the process of being worked out. The foundation of the law in this area is a famous California case called Marvin versus Marvin. It established the principle that contracts or agreements between a man and a woman who were living together could be enforced. The earlier courts had insisted that you could not enforce any such agreement. Their reasoning was that these people were in an immoral arrangement. The California court in Marvin versus Marvin boldly declared that times had changed, that the mores of society had shifted, and that whatever one might think of such an arrangement, a court could not simply dismiss it as immoral and refuse to enforce it. The Marvin case shows us what a great gulf there is in terms of mores and social customs and the law between our own times and the 19th century. Until the middle of the 19th century, married women were subject to a doctrine called coverture. What this doctrine meant was that a married woman lost her right to buy and sell property and to control her own wealth. All of these rights passed to her husband, and her property was also liable for his debts. In other words, a woman, even of course an adult woman, once she got married, had approximately the same legal position as an infant or a lunatic. She was legally submerged entirely within the personality of her husband. As Blackstone said in the 18th century, husband and wife are one flesh. That might have been true, but the flesh belonged to the husband. Now, there were ways to avoid the doctrine of coverture, but they were expensive and complicated. Again, in the United States, the doctrine of coverture became clearly unsuitable. This was so for two very different reasons. The first reason was the gradual but inexorable change in the relationship between men and women, and the growing sense of women that they had a right to more equality than the law accorded them. But probably more important were the economic consequences of coverture. Let's take, for example, the problem of a woman whose husband deserted her. She was left sitting on a piece of land which she could not sell, mortgage, or deal in any way. She needed her husband's consent, and her husband was simply absent. Or consider the problem of a father whose beloved daughter is about to get married. He would like to give her a piece of land or some property, but he realizes that if he does so, it goes to his son-in-law, who might turn out to be a cad, or, more important and more frequently, might become burdened with debts, in which case the father's property would be sucked into the hands of the creditors. These problems probably weighed more heavily on the minds of legislators than the women's movement, which also called for an end to coverture. The states began to pass statutes called Married Women's Property Acts. The first Married Women's Property Act was passed in Mississippi in 1839. In the 1840s, many other states joined in. By the end of the century, almost nothing remained of the doctrine of coverture, and the rights of married women and single women, and for that matter, the rights of men to deal in property, to buy, to sell, to make out wills, all these were exactly the same. We should say a word here about the law of adoption. Somewhat surprisingly, the common law systems never recognized adoption of children. As a matter of fact, England had no law recognizing adoption until 1926. As far as the common law was concerned, there was only one kind of child that was a blood child. The notion of creating an artificial family through adoption was abhorrent to the common law. Partly this may have been because the common law was so fixated on the inheritance of estates of land through the natural bloodline, especially the male bloodline. But in the United States, once again, the widespread ownership of property made this a very dubious proposition. In the 19th century, women very commonly died in childbirth. Men died of the plague, and so did women. There were thousands and thousands of orphans in the 19th century. Some of these were in institutions. Many of them were raised by friends, relatives, and others. You don't need the law of adoption to take in a child, to love a child, and to raise it and treat it as if it is your own. But for purposes of inheritance, for people who own property, adoption is a most useful device. Already in the early 19th century, we found in the states statutes adopting children one at a time, particular statutes passed by a state which would say something like, Mary Jones is to be treated as if she were the regular daughter, the blood daughter of Henry Jones. And in 1851, Massachusetts passed the first general adoption law, allowing the adoption of children through a court proceeding, and the majority of the states soon followed. The most complex history of any aspect of family law, however, is the law of divorce. And we have to spend a little time talking about this most interesting aspect of our family law system. Before the Civil War, the southern states typically followed a system called legislative divorce. If you wanted a divorce in a southern state, you had to go to the legislature and petition them to pass a special law divorcing you. There are many, many examples of this kind of divorce in the records of the southern states. You won't find any of them in South Carolina, however, because South Carolina alone among the states did not recognize absolute divorce at all until well into the 20th century. The northern states veered off on an entirely different tack. What they adopted was a system called judicial divorce. If a person wanted a divorce, they had to bring a lawsuit. The innocent party would sue in court for a divorce from her spouse who was guilty of violating the marriage in some specific way, either adultery, desertion, or cruelty. The list of grounds for divorce varied from state to state. In New Hampshire, for example, one of the grounds for divorce was joining a sect called the Shakers. The Shakers did not believe in sexual intercourse, and this belief, shall we say, interfered with what most people expected out of a marriage. New York had a particularly stringent and narrow divorce law. In New York, basically the only grounds for divorce was adultery. Many of the clergy and many leading citizens felt that divorce was, at best, a necessary evil. They felt that it should be uncommon, that it should be used only as a last resort. Many people believed that if you made divorce easy to get, there would be instability in marriages and society would crumble into dust. But the fact of the matter is that whether they liked it or not, the demand for divorce rose steadily throughout the 19th century. It's not clear exactly why this happened. The best explanation is that the nature of marriage itself was changing. There was the rise of what is called companionate marriage. By companionate marriage, we mean a concept of marriage in which the husband and wife are more or less equal partners. They're supposed to be their best friends to each other. They share a life. They do things together. In more traditional societies, a man and a woman married, but the woman's relationships remain closest with her female relatives, the man with his female relatives and friends. Under a companionate marriage, marriage is a much tighter and more demanding status than under traditional marriage. the rise of companionate marriage leads to an increase in the demand for divorce. If spouses expect a lot more out of marriage, marriage will much more often disappoint them. But now we come to a problem. The demand for marriage is rising, but the formal law of marriage proved to be very difficult to change. Why was this the case? Very simply because powerful forces in churches and elsewhere resisted making marriage more accessible. It was a case of an immovable object and an irresistible force. What happened was that the working law of divorce, the real law of divorce, the living law of divorce, was bent out of shape. The formal law said one thing, the living law did something entirely different. In other words, escape routes developed to get around the strictures of the law of divorce. One of these was a so-called migratory divorce. Some states eased up on their divorce laws. They lowered their residence requirements, for example. They did this for a very simple reason. They wanted to attract the business of people who were eager to get a divorce. These states were called divorce mills. They were always controversial, and usually they were quickly shut down by the protests of clergy and other respectable citizens. The only really permanent one was Nevada in the 20th century. Nevada, one must say frankly, is a state which has gotten rich by legalizing everything that is illegal in California, including gambling. In the case of divorce, what Nevada did was to lower its residence requirements and to attract people from states with stricter laws. It proved to be a more permanent haven for people who wanted a quick and easy divorce. By the time of the 1920s, going to Reno was almost a synonym for getting a divorce. Migratory divorce had a number of problems. It had some legal problems to begin with. Was a Nevada divorce going to be recognized as valid in New York? Generally, the answer was yes, but there was an even worse problem with migratory divorce. It was expensive. It was simply too much money for the average person. Only the wealthy could afford to take time off, travel to Nevada by cross-country train, live there for a while, and then file for divorce. The ordinary person got his divorce through a much more simple escape route. That was collusion. In theory, divorce was an adversary case. That is, an innocent spouse, usually the wife, filed a lawsuit claiming her husband was guilty of cruelty, adultery, or whatever. In more and more cases, the overwhelming majority by the end of the century, the couple agreed in advance that they wanted a divorce. The trial became a charade. One spouse would ask for the divorce. Let's say it's the wife. The husband simply failed to show up. The divorce was granted by default. In New York, adultery was the only grounds, and a bizarre racket sprang up. The husband would check into a hotel. A woman would appear. They would take off some or all of their clothes. The door would be opened, and a photographer, hired for this purpose, would burst into the room, take their picture, and the photos would then be presented in court as evidence of adultery. Obviously, there was a lot of real adultery in New York, but this kind of adultery, which I like to call softcore adultery, protected the identity of the other woman. There's a very amusing article that appeared in the newspaper in 1936, written by a woman with the title, "I was the unknown blonde in 100 divorce cases." What's interesting is that the judges, who certainly were no fools, recognized very clearly what was going on, but they almost never protested, and these divorces were simply granted. Thus, divorce became what we might call a dual system, in which the formal official law and the living law were radically different. But this never happens accidentally. It is the result of concrete social forces. In this case, it was the stalemate between the powerful forces that resisted reform of divorce and the powerful demand of ordinary people for a way to get their divorce. Despite many calls for reform and the widespread recognition that the system as it existed was rotten to the core, it was amazingly stable, at least on paper. The actual divorce rate rose dramatically. The final breakdown of the system occurred in 1970, when California adopted the so-called no-fault divorce system. Under a no-fault statute, in practice, either party can ask for and get a divorce. No defense is allowed. The no-fault system is in some ways a very radical change. Even the reformers who felt the old system was rotten were asking for what we might call consensual divorce. That is, if a marriage had broken down and both parties wanted out, they should be allowed to put an end to a dead marriage and bury it properly. No fault goes beyond consensual divorce. Under a no-fault system, either party can end the divorce and no consent of the other party is required. What is particularly interesting is to note that the reformers who drafted the no-fault statutes probably never intended this result. They intended a much more complex and formal system. Under the California law, the courts were not really supposed to grant divorces automatically. They were supposed to check and see whether the marriage had in fact broken down. Was the marriage beyond redemption? If it was, a divorce was to be granted. If not, presumably there would be counseling and other steps taken. But no such thing ever occurred. Almost immediately, judges began simply handing out divorces to anybody who wanted one, and it became a system of totally unilateral divorce. This seemed really quite novel, even revolutionary. But in fact, there had been a sort of creeping no-fault in some states long before the new law was passed. There were quite a few states in which it was possible to get a divorce without grounds if a couple was separated for a long enough period. This was really a kind of no-fault divorce. In some states, it wasn't used very often, because why wait 5 or 10 years when a little white lie could end the marriage immediately? When California passed its no-fault statute in 1970, no-fault began to spread very rapidly to state after state. By 1974, the overwhelming majority of the states already had a kind of no-fault procedure. The effect everywhere was almost the same as in California. Whatever the statute said, either party could simply opt out and end the marriage. Judges in no-fault states simply never denied a divorce. But almost immediately, the impact of the no-fault statute in California and other states was as I have described it. That is, automatic divorce for either party simply because they want it. To be sure, many difficult problems of custody and property division remain, but it seems clear that the old system of divorce is almost completely dead. There have been some attempts to revive it, very notably in Louisiana. Louisiana has adopted a statute creating 2 forms of marriage: ordinary marriage, which you can end under a no-fault system, and so-called covenant marriage, in which a husband and wife agree that they will be married for life. They make a kind of agreement or covenant to that effect. Parties to a covenant marriage can still get a divorce, but they can only get it on grounds. They cannot simply walk out of the marriage. So far in Louisiana, most couples are not choosing covenant marriage, but it remains to be seen what the future will bring. In this lecture, we've seen how the law has entered into and affected that most intimate and personal of domains, family life. But as always, the law is less a cause than an effect of dramatic changes in society itself. We traced the rise and fall of the common law marriage and how this was related to other aspects of American society, including the widespread ownership of land, which also had an impact on married women's property, on divorce, and on the law of adoption. In the case of the law of divorce, we traced a very complicated history in which the struggle between the demand for divorce, fueled by radical changes in the relationship between men and women, and the powerful religious and moral objections to divorce clashed. In the end, apparently, the change in the nature of marriage and the overwhelming demand from the public for an easy route out of a marriage and therefore the chance to start over again overwhelmed the objections that had been so powerful in an earlier period. In the next lecture, we will look at another very important aspect of the law, the way it deals with crime and the punishment of crime as they developed in the course of the 19th century.
After listening to Lecture 8, a student posed this question to Professor Friedman. What is a common law marriage? Let's listen to the professor's response.
You often see in newspapers and the like the expression common law wife. People use this loosely to mean simply a woman with whom a man is living without being married or having any pretense of being married. But this is not the historical meaning of the term or the legal meaning. A common law marriage is a regular, valid marriage under the law. It simply is a marriage that lacks the usual formalities, but it is recognized as a valid contract between the parties. A majority of the states no longer recognize this idea, but a handful of states still do. In those states, if a man and woman, completely in private, in their own home, in front of a roaring fire or whatever, say to each other, "Let's be married," they are then, at that moment, from that point on, legally married, and indeed, if they want to unmarry, they have to get a divorce.
This ends Lecture 8, The American Legal Experience, Lecture 9, Crime and Punishment in the 19th Century.
In this lecture, we're going to look at the system of criminal justice as it developed in the 19th century. First, we're going to look at two very dramatic and important innovations in criminal justice: the invention of the penitentiary and the organization of the municipal police. After that, we're going to look at some of the changes in the way criminal justice was administered in the 19th century. We're going to look at correctional policy in particular, how men and women were punished, including the ways in which capital punishment changed in the course of the 19th century. We'll also take a look at the fate of crimes against morality, how in the early part of the century they were de-emphasized, and in the later part of the century there was a dramatic increase in the interest of the legal system in stamping out vice and crime. The two dramatic innovations in criminal justice, the rise of the penitentiary and the invention of the police, are linked to each other. They rest on rather similar social forces and ideas. Let's begin by talking about the penitentiary system. You will recall that when we talked about colonial crime and punishment, we emphasized the fact that jails and prisons were not normally used as ways of punishing people. We talked about the community system, in which all punishment was public. The 19th century was dramatically different. By this time, the country's population had grown tremendously. Immigrants poured in. The cities were growing. New York, Philadelphia, Boston, and other cities had reached what was inconceivable size from the standpoint of the 17th century. The cities were unruly places. Now it was no longer thought that simply subjecting people to bodily punishments and to the community's shame and stigma was an adequate way of punishing people. A new device had to arise, and it took the form of imprisonment. The classic penitentiaries were large, impressive stone buildings surrounded by walls in which prisoners were confined one to a cell under a strict and disciplined regime. In older jails, prisoners were simply thrown into a room or rooms, kind of helter-skelter. Those that could afford it would have food brought in from the outside. Richer prisoners fared better than poorer prisoners. The classic penitentiary eliminated all of that. It invented the prison uniform. The prisoners walked in lockstep. Their hair was shaved. They were given a number. The prisons were also run on the silent system. Prisoners were not allowed to speak. Their daily routine was minutely specified. And they were guarded in these large stone buildings, expensive, massive, and impressive. The classic type is Cherry Hill in Philadelphia, a prison which still exists and which you can tour on payment of a small fee. Cell blocks radiated out of a central core. The penitentiary was then a reaction to the failure of the colonial system of punishment and its reliance on stigma, shame, and the didactic effects of punishment. In the turbulent cities, these methods seemed totally inadequate. To the mind of the 19th century, the community, the mobs, and the underworld of the cities were part of the problem. They were not part of the solution. The criminal had to be withdrawn from evil companionship. He had to be locked up and subjected to iron discipline. That way he would be forced to repent and reform. Moreover, the prisoner was required to labor. Under some systems, the prisoners labored in their individual cells. In other prisons, they labored communally, but the silent system was enforced in all cases. The penitentiary was new and dramatic, and it attracted a lot of attention. Alexis de Tocqueville, who wrote the classic Democracy in America, originally came to the United States to observe the penitentiary system. He found it amazing and laudable. Other visitors were also struck by the prison system. One of these was Charles Dickens. Dickens, unlike de Tocqueville, found the prison to be a place of horror, of dehumanizing influence. The police force was also a reaction to the problem of unruliness and disorder in the cities. Before there was an organized police force, constables made arrests during the daytime and night watchmen patrolled at night. But in the unruly and riot-torn cities, urban disorder frightened elites and led to a search for better methods to control the restless population. The first urban police force was in London, but the idea spread quickly to New York, to Boston, and other American cities. Police forces were paramilitary groups. They were on duty 24 hours a day. They had paramilitary titles like sergeant and captain. They wore uniforms. They carried nightsticks. They were assigned the job of maintaining order in the cities. They were a visible presence with their badges and their uniforms. At the same time, for more secret crimes, including confidence rackets, the cities began to develop plainclothes forces who worked undercover. These were called detectives. By the middle of the century, a number of cities had organized detective forces. Interestingly enough, and not coincidentally, At approximately this same time, a new literary genre was developed, the detective story, in which the solution of hidden, clandestine crime was assigned to a detective, often an amateur like Sherlock Holmes, but sometimes a real detective. A word should be said here also about an important change in capital punishment, which is linked to the two innovations I've just mentioned. Here again, suspicion and fear of urban disorder led to a movement against public executions. In the colonial period, these were didactic theater. They gave moral lessons to the crowd. But they no longer seemed this way in the 19th century. Rather, they struck people as barbaric spectacles that only incited the bloodlust of the crowd. In many states in the first part of the century, public executions were abolished. Executions were moved into the courtyard of the prison or jail. Here they could be seen by a few people who climbed to the roof of houses or by boys who clambered up trees, but on the whole they were much more private. Later on in the century, the invention of the electric chair made executions still more private. This occurred in the 1880s. Now an execution could be held in the bowels of the prison with only a handful of witnesses. All of these innovations reflect the fear of disorder which accompanied the growing population and its growing urbanization. None of them proved entirely satisfactory, in particular, correctional policy. The prisons were not doing the job. For one thing, the silence system did not last very long. The silence system depended on solitary confinement, but prisons were expensive, and very soon it became impossible to maintain single-cell prisons. As soon as more than one prisoner was in a cell, the silence system broke down. In any event, a new generation of reformers and penal authorities in the second half of the century began to rethink the whole issue of correctional policy. The aim of policy was to separate two kinds of prisoners. Some prisoners were incorrigible. They were rotten to the core. Some prisoners could be reformed. Was there some way to distinguish between these two? One key innovation was the indeterminate sentence. The idea here was very simple. Judges would no longer impose a specific sentence on persons convicted of crime. Instead, a condemned man would serve a minimum sentence, often 1 year. At the end of that time, prison officials would assess the man, judge his behavior, and decide how long the man would serve. The idea was to treat crime more or less analogous to disease. As some writers put it, if a person is in a hospital, they're not in the hospital for any specific length of time, but only till they're cured. A person who commits a crime should be kept in prison until he's ready to be released into society. You'll notice that I consistently say he when I'm talking about criminals. We could, of course, say he or she. This is somewhat unrealistic if it conveys the notion that men and women share equally in criminality. The fact of the matter is that, particularly for violent crimes, men are overwhelmingly dominant. The prison population is not exclusively male, but something on the order of 90% of all 19th century prisoners are men. And except with regard to such crimes as prostitution, which are women's crimes primarily, men dominate the field of criminality. Let's get back now to the indeterminate sentence. It is related to two other reforms that served very similar purpose. One was the parole system. The parole system served to release a prisoner early if, in the opinion of a parole board, they showed signs of rehabilitation or reform. Another very important type of reform was probation. A convicted man on probation would not go to prison at all. His freedom, however, was conditioned on good behavior as judged by a probation officer. The net result of these reforms was a radical individualization of sentences. Suppose that two men jointly committed burglary and are tried separately. They've committed exactly the same crime. Would they have the same punishment? Not under the late 19th century system. It is completely possible that one man might get probation and never go to prison at all, while the other man might serve a very long prison term. It would depend on how the two men were assessed by probation officers and by prison officials. So these reforms were in one sense a humanization of the system. A man who got probation never went to prison. He was spared the torture of long years behind bars. This was a humanizing effect. So too of parole and even the indeterminate sentence. But the other side of the coin was this. A lot depended on stereotypes and assessments which could often be unfair. If we look at probation reports in the period around 1900, we find an incredible mix of gossip and stereotypes. Probation officers record, for example, whether or not a young prisoner masturbated, whether or not he went to theaters too often, what his family was like, whether he had an uncle who was insane, and that sort of thing. In one notable instance, it was recorded that the defendant lacked a library card. So although the net effect was a humanization of the correctional system, it also opened the door to a great deal of prejudice and unfairness. What's important to note is that these reforms represented a relative shift of emphasis from the offense itself to the person and character of the offender. I think we can make a generalization. Periods that are obsessed with crime, that are very fearful of crime, and that feel that crime is a major problem in society, shift their emphasis to the offense itself. This is true, for example, of the period in the 20th century from 1950 on, in which the criminal justice system became harsher and harsher, and in which we hear slogans like old enough to do the crime, old enough to do the time. That is a shift from the offender to the offense. In the late 19th century, although people said crime was a problem, it clearly was not seen as a major social problem in the way that it was in the post-World War II period. Consequently, the emphasis shifted from the offense itself to the person and character of the offender. Now, this was always a relative shift. You never got probation if you were accused of murdering 12 people, and the indeterminate sentence did you very little good, nor would you ever get out on parole. But for such crimes as forgery or various forms of property offense, these were very important. Another reform at the very end of the 19th century and the beginning of the 20th century, which should be mentioned, was the creation of special juvenile courts for young offenders and for neglected children. The first of these was established in Cook County. Cook County, of course, is the county in which Chicago is located. In theory, the juvenile court is not a criminal court at all. And in fact, the young people who end up in juvenile court may not have done anything wrong at all. They may simply have been abandoned by their parents. In theory, therefore, this was a place in which the court could deal with the problems of children who had problems. There were therefore three types of children in a juvenile court. Some children were completely innocent of any offense. They were neglected or abandoned. Some children had committed offenses which would not be an offense if committed by an adult. For example, truancy at school, running away from home, incorrigibility, disobedience to their parents. And some children had committed actual crimes like petty theft. The juvenile court system was another attempt to humanize criminal justice and to avoid the situation of placing very young people in institutions with hardened criminals. In its early years, its backers felt that it was a completely benign system. Later on, it became much more controversial. Here we should say a word about the criminal trial itself. The basic form of the criminal trial had been inherited from earlier periods and is still familiar. A jury of 12, in this period all of them were men. The adversary system, the role of the lawyers, cross-examinations, I object, and the whole drama which is familiar to us from television and the movies. But trial by jury was actually in deep decline during the 19th century. More and more defendants simply pleaded guilty. In this case, there would be no trial at all. Often they pleaded guilty as the result of a deal, the so-called plea bargain. They agreed to plead guilty, and in exchange the prosecution agreed to drop certain counts or to ask for a more lenient sentence. At the level of the lowest courts, police courts and municipal courts, trials were perfunctory. Huge numbers of men and women were processed in a routine manner for drunkenness, vagrancy, and other petty offenses. These were more or less the plankton of the ocean of criminality. Full trials remained important for a small but very significant group of trials. These cases attracted the attention of the media, and they caught the fancy of the public. Perhaps the most famous of all during this period was the trial of Lizzie Borden in the 1890s. Lizzie Borden was accused of murdering her father and stepmother. The trial was an absolute sensation and has continued to capture the attention and the fascination of the public to this very day. The trial of Lizzie Borden, like big trials generally, was a striking social document, a kind of social drama, in which two rival versions of the truth vie for attention. Trials like the trial of Lizzie Borden illuminate social norms and give us valuable insights into the minds of the period. What was the issue in the trial of Lizzie Borden? Lizzie Borden was the daughter of one of the leading citizens of Fall River, Massachusetts. She was an unmarried woman in her 30s, almost certainly a virgin. She lived at home with her parents. She was a church-going woman. She was a pillar of the community. The real issue in this case was, is it possible that such a person could commit this brutal and horrifying crime? The jury clearly thought it was impossible and acquitted Lizzie Borden. Most scholars of the case feel that she was guilty. The issue was, then, whether underneath this surface of bourgeois morality there was a seething mass of pathology which rendered a woman like Lizzie Borden capable of snapping and murdering in this incredibly bloody fashion with an axe her own father and the woman to whom he was married. The same kind of analysis can be applied to almost all of the show trials and the famous trials of history, up to and including the trial of O.J. Simpson. For example, in the 1950s, the most famous trial was the trial of Dr. Sam Shepard, who was accused of murdering his wife. Dr. Sam Shepard was almost certainly innocent, but that's beside the point. Here, too, the surface of bourgeois suburban life had been placed on trial, and in this case found guilty. As we saw, the colonial systems put very heavy stress on crimes against morality. In the first part of the 19th century, the emphasis on such offenses as fornication and adultery diminished. Indeed, in some states, the law was changed in a very interesting way. The crime of adultery was criminal only if it was, quotes, open and notorious, close quotes. In other words, occasional secret acts of sexual misbehavior were not crimes at all. It would be an exaggeration to say that vice and sexual misconduct were tolerated, but very little effort went into enforcement. If only open and notorious adultery is a crime, this means that the real offense is not the sin itself, but the danger to public morality from flaunting it. What you do not flaunt, therefore, becomes no longer illegal. In the cities, there were red light districts where prostitution and gambling flourished, sometimes, of course, with payoffs to the police. We could call this whole system the Victorian Compromise. Vice, sexual misconduct, and the like are inevitable. They are part of the human condition. We will tolerate them, but only if they stay hidden and in their place. At the end of the century, and in the first third of the 20th century, this situation changed radically. For complex reasons, powerful social forces led to a crackdown on vice and crime. Underlying this movement was a sense of deep cultural crisis. This was a period of heavy immigration and urbanization. Many people felt that civilization itself was under threat, and that vice and immorality had to be crushed in order to protect the moral security of the nation. In 1870, Congress passed the so-called Comstock Law. Anthony Comstock was a famous crusader against vice and impurity. Under the Comstock Law, it was a crime to send obscene material through the mail. It was also a crime to send any material relating to contraception and abortion. This was also the period in which abortion was criminalized, in many states for the first time. A number of women and men had become quite rich by arranging for abortions for middle-class and upper-class women. The most notorious of these abortionists was a woman who called herself Madame Restel. Her real name was Anne Lohman. She lived in a mansion on Park Avenue and died there, a suicide, after cutting her wrists in a gold-plated bathtub when the law began to close in on her. The anti-abortion campaign had many roots. Obviously, there were those that objected to abortion on religious grounds. But another aspect of the anti-abortion campaign is worth noting here. Many people felt that abortion was becoming too common among middle-class American women of old Protestant stock. The new immigrants were multiplying like rabbits, while the sound old Americans were failing to reproduce themselves. This was part of the general sense of crisis in the community, the sense that the old order was changing, the frontier was over, America's soul was in danger. In this period, too, laws against sexual misbehavior were tightened considerably. The campaign against vice was strong by 1900 and would become even stronger, as we will see in a later lecture, in the 20th century. In this lecture, we've taken a look at some of the dramatic changes in the criminal justice system in the 19th century. We've seen how the disorder in the cities and the sense that the urban mobs were not to be trusted led to the invention of the penitentiary, the privatization of capital punishment, and the development of urban police forces. We also saw how in the latter part of the century, penal reformers introduced methods of humanizing the correctional system. These methods, which included the indeterminate sentence, parole, probation, and the juvenile court, did have the effect of humanizing the system, but at a certain cost of introducing more randomness, arbitrariness and prejudice into the handling of offenders. We looked at the criminal trial and the significance of the big criminal trial as a social document, and also how, at the very end of the century, a sense of cultural crisis led to a tightening of the war against immorality and vice. In the next lecture, we will look at another area of conflict and struggle: labor law and social legislation in the course of the 19th century.
This ends Lecture 9. The American Legal Experience, Lecture 10, Conflict and Struggle, Labor and Social Legislation.
In this lecture, we're going to look at another area of conflict and struggle: labor and social legislation in the 19th century and in the early 20th century. We're going to look at the welfare system to begin with, how the states treated people who were poor and destitute. After this, we're going to look at the consequences of industrialization. Industrialization created, for the first time, a large urban landless working class, and it set the stage for dramatic conflicts between labor and capital. These conflicts often took the form of direct action, strikes, and sometimes even violence, but they also enlisted the law on either side. And in this lecture, we'll examine the role that the law played in mediating and sometimes exacerbating the struggles between labor and management. We'll begin by taking a look at the welfare system, or to give it the name that it had in the early 19th century, the Poor Laws. The Poor Laws were of English origin. Their outstanding characteristic was that they were intensely local. Each community, each township was supposed to take care of its own poor. A person who was poor, a pauper, was entitled to relief only if he or she had a legal right to that kind of relief in the community. The term that was used was settlement. You were entitled to relief only in the place where you were settled. This seems like a fairly simple idea, but in fact it was extremely complicated. And there were many cases, actual litigated cases, in which one township would sue another township, trying to pass the burden of taking care of some poor or destitute person on the claim that the settlement was really in Township B rather than Township A. Because a legal settlement meant that the community was going to have to pay for somebody who became sick or destitute in some other way, communities were not exactly happy at the influx of people who they were afraid were going to be or were already paupers. So in many places, there was the law or custom of warning out. That is, when a new arrival came in the community who seemed to be poor or likely to become poor, instead of being greeted by the welcome wagon, they were told, "Get out." They were told, in other words, that they could not remain in the community. And if they felt that they wanted to, they could be forcibly removed. In the first half of the 19th century, however, there was a very important shift in policy with regard to the poor. This is often called the shift from outdoor to indoor relief. Outdoor relief meant relief to a person in their own home. Indoor relief meant that in order to get funds from the community, the pauper had to enter an institution, a poorhouse or poor farm, in order to have any claim for funds. The communities began to build these poorhouses. They were highly regimented institutions. They were more like prisons than anything else. The idea behind them was to make relief so painful and stigmatic that nobody but the most desperate people would consent to enter into a poorhouse. This policy was based on a fear or horror of, quote, sturdy beggars, close quotes. That is, men who could work but refused to work. On the whole, this was a fantasy. Most of the residents of poor houses were old or sick or mentally ill or destitute women with children. The idea behind the poorhouse was that they were supposed to be severe but humane. But in many of them, conditions were absolutely appalling. In general, in the history of the United States, the poor have not been treated with compassion. In a society of this kind, which was supposed to be self-governing, there was a particular fear that people would fail to meet the standards that were required of life in a democratic society. In an aristocratic society, the rulers rule, and the character of the people is less relevant. In a democratic society, people are supposed to govern themselves, and people who fail to meet these standards are treated severely, almost as if they are felt to be a kind of traitor to the American ideal. There's also the fear that lies behind the fantasy of the sturdy beggar, that unless incentives are given to people to work hard and to try to better themselves, they will become lazy and immoral. At any rate, the problems of the poorhouses did not escape attention. And toward the end of the century, states at least began to try to improve the situation. They tried to centralize the administration of relief through the creation of state boards of charity. One constant feature in the history of welfare law is the attempt to distinguish between two categories of poor people, the worthy and the unworthy poor. The sturdy beggar, of course, is the archetype of the unworthy poor. The worthy poor are people whose misfortune are felt to be not due to any fault of their own, people who are blind, or veterans of the Civil War who had fallen on evil days. In general, these are treated with much more dignity and were more easily granted both institutional and financial aid. Veterans' pensions were perhaps the only exception, and these were hardly considered as falling within the category of welfare. The federalization of welfare took place only in the 20th century under the stimulus of the Great Depression. Perhaps the most important social development in the late 19th century was industrialization. For the first time in U.S. history, there was, as I've mentioned, a large landless class of urban working people, people who worked in factories and mines. Their position and their livelihood was legally and socially precarious. Under the law, the owner had absolute power to hire and fire at will. The workers tried to organize and form labor unions as a counterbalance to the power of the employers. The efforts of the workers were often bitterly opposed by management. There were frequent and sometimes violent strikes in the latter part of the century. The battle between labor and management was also a legal battle. Generally speaking, the legislatures tended to be somewhat more favorable to workers. After all, workers were voters as well as workers. When legislators passed laws that seemed to be favorable or relatively favorable to organized labor, management sometimes had recourse to the courts. The courts, in some notable instances, tended to be more favorable to management. One powerful weapon which the courts forged and used against strikes and organized labor was the labor injunction. An injunction is a court order to do a certain act, or sometimes not to do a certain act. An injunction is a very powerful legal tool. If a judge issues an injunction, it must be obeyed. If someone disobeys an injunction, they can be considered in contempt of court. A person who is in contempt of court can be thrown into prison without trial. It has been estimated that in the 1880s, courts issued more than 100 labor injunctions. In the 1890s, more than 400. In the 1900s, more than 800. and in the 1920s more than 2,000. Labor had very good reason to fear and dread the injunction. One famous example of the use of the labor injunction occurred during a major strike against the Pullman Company in 1894. This strike paralyzed the country's railroads. The president, Grover Cleveland, called out the troops. The government also asked for and got an injunction against the union leader, Eugene V. Debs. The court ordered him to stop interfering with the operation of the railroads. Debs refused to obey. He was then jailed for contempt. The case was appealed all the way to the United States Supreme Court, but in 1895 the Supreme Court upheld his conviction. The labor injunction continued to be used as a device to harass organized labor and to break strikes for some decades afterwards. Organized labor, in addition to trying strikes, boycotts, and other devices, tried to get legislators to pass laws favorable to their cause. They wanted laws that regulated conditions of work, including health and safety measures, and they wanted such matters as the outlawing of child labor. The labor unions were concerned about child labor for a variety of reasons. First of all, no doubt many union members felt that child labor was a real offense against social justice. The aim of the labor unions also was to keep wages high as possible. Women and children, imported labor, the Chinese, all those that they thought would be willing to or were working for less than the wage that would be paid to an adult male, were enemies of the labor union. Many northern states did in fact pass child labor and factory inspection laws. The enforcement was pretty often weak and underfinanced. Employers also challenged all of these laws in court, often on constitutional grounds. They had mixed success, and the results tended to vary from state to state and from court to court. On what basis could the employers attack, let us say, a law regulating the conditions of labor? It was certainly conceded that the states had the power to pass legislation on behalf of the public, helping the public in some way or guaranteeing safety or health. On the other hand, the courts were reading the 14th Amendment to the Constitution in such a way as almost to enshrine laissez-faire theories of government. The 14th Amendment declared that no state could deprive any citizen of life, liberty, or property without due process of law. The courts argued, or some courts argued, that an unreasonable and unjust regulatory law in effect deprived the employers of their property or their liberty without due process. This was, in some cases, a fairly tenuous argument, but in a number of notorious or famous cases, it prevailed. One of the most famous of these cases was Lochner versus New York, decided in 1905. In this case, the court struck down a New York statute that limited the hours of bakery workers. No bakery worker could work more than 10 hours a day and 60 hours a week. In fact, a great deal of the statute, which was passed in New York State in 1897, had nothing to do with the hours of work of bakers at all. Much of it had to do with sanitary conditions. For example, every bakery had to have a washroom and water closet apart from the bake room. No cats and dogs were allowed in any room where bakers were baking, and there had to be proper ventilation. It was only the provisions about the hours of work that became controversial. The case was brought by Joseph Lochner, who owned a small bakery in Utica, New York. He was accused of letting a worker work more than 60 hours in 1 week. Lochner was convicted and fined $50. He appealed all the way through the New York court system and up to the United States Supreme Court. Obviously, in a case like this, It's not the $50 that's at stake. This is obviously a test case which is being brought for the purpose of testing the validity of the law, and Lochner himself is in a way merely a sideshow. The United States Supreme Court, in an opinion written by Justice Rufus Peckham, thought that the law was just plain unconstitutional. The provision about the bakery workers violated the liberty of contract of workers and employers, and therefore violated the 14th Amendment to the Constitution. There were two vigorous dissents. One dissent was by Justice John Marshall Harlan. He took exception to the idea which was expressed by Peckham that the law was not really a health law. He pointed out that bakers lived short and unhappy and unhealthy lives. Their hours were a health issue, he insisted. Oliver Wendell Holmes, Jr. also wrote a dissent. In his dissent, he accused the majority of reading into the Constitution a particular economic and ideological view. The 14th Amendment, according to Holmes, is not intended to embody such an ideology. It is not intended to embody, quotes, a particular economic theory, close quotes. The issue, of course, was the right of the states to interfere in the workings of the economy. The Lochner case was very famous in its day, and it has become even more famous since then. It is taken to be a symbol, an archetype of the Supreme Court as a reactionary institution standing in the way of progressive labor legislation. But we have to ask the question, how typical was the result in Lochner versus New York? The answer is not very typical. The results of cases on labor and social legislation in the United States Supreme Court were decidedly mixed. For example, in one case, Holden versus Hardy, which was decided in 1898, the Supreme Court confronted a law of Utah, which instituted an 8-hour workday for miners and smelters. The Supreme Court upheld the law. It also upheld a law of Oregon, which restricted the hours of labor of women. In Muller versus Oregon, decided in 1908, the court confronted a law on the working hours of women. It upheld the law, to be sure. The law also stood in the judgment of the court for family values, domesticity, and motherhood, as a law about families and the future of the country. Interestingly enough, Muller versus Oregon, which was considered in its day an extremely progressive decision, really looks bad to us today, with all its talk about motherhood and women as subject to the control and the domination of men, and as needing special protection from the law. Another case that was very controversial was Adair versus the United States, decided in 1908. This case concerned the so-called yellow dog contract. Some companies demanded that workers sign these contracts, that is, that they promised never to join a union. Congress passed a law in 1908 that made it illegal for a railroad to discriminate against an employee because he or she was a member of a labor organization. In the Adair case, an agent of a railroad had fired a locomotive fireman because he was a member of a union. And the Supreme Court, referring to the same idea of liberty contract that they leaned on in the Lochner case, struck down this statute. This, too, was extremely controversial. The court appeared at its most retrograde on the issue of child labor. The northern states had enacted child labor laws, the southern states had not. As one might have expected, a number of northern factories began to move to the southern states where they could employ child labor and where, in general, there was less unionization and wages were much lower than in the north. In a federal system, the only solution to this problem, as the northern states saw it, was an act of Congress. Only an act of Congress could create a national standard and stop the flight of factories to southern states by taking away this regional advantage. In 1916, Congress in fact did pass a law which tried to provide a national standard. The law applied to any mine, quarry, or factory that hired children under a certain age. These mines, quarries, and factories were not to be allowed to ship their goods and products in interstate commerce. There were fines and jail time for repeat offenses. Since Congress had power to control interstate commerce, it was expected that this law would help to curb the problem. But in a test case, a man named Roland Dagenhart, who worked in a cotton mill in Charlotte, North Carolina, brought a lawsuit on behalf of himself and his minor sons to enjoin the enforcement, that is, prevent the enforcement of the child labor law. And in 1918, the Supreme Court struck down the law by a narrow 5-4 margin. The majority said that, sure, Congress could regulate interstate commerce, but this statute went too far. If Congress could prohibit this kind of goods from moving in interstate commerce, it could prevent anything at all that it wanted from crossing state lines. This, the court felt, would destroy the authority of the states and unsettle the whole American system of government. On the surface, this is a case about the federal system, about the way power is distributed between federal and state governments. The United States was a giant free trade area. It was an economic unit, though not a legal unit. But the Supreme Court perhaps should not be taken at face value in this case. It had allowed a lot of interstate commerce regulation, and the question is, why did it balk at this particular subject? The aftermath is also interesting. After the Supreme Court had struck down the child labor law, Congress tried another tack. In 1919, it passed a tax law. It put an excise tax of 10% on the net profits of any mine or factory that hired children. Congress thought that its power to tax was broader than its power to regulate commerce. But when the law was challenged, the Supreme Court struck it down again. This was not really a tax. It was another attempt to get rid of child labor, and that, said the court, was completely beyond the power of Congress. It is very hard to reconcile the various cases. The child labor cases, which seem so retrograde, and the cases like Holden versus Hardy, and the cases on the labor of women, which seem to go in the other direction. Basically, the Supreme Court seemed to be reacting now one way, now another. The members of the court were men of the upper middle class. They were fairly conservative on many issues. They feared the power of organized labor because of their fear that organized labor threatened the security of the nation, threatened to overthrow a system that they valued very highly. There is no reason to doubt the sincerity of the justices, but in the cold hindsight of history, a lot of their actions today look mistaken and retrograde. Supreme Court decisions on these subjects were intensely controversial. But the Supreme Court, as we saw, had accepted a great deal of social legislation, and the state courts, too, seemed quite inconsistent. One interesting issue has to do with occupational licensing statutes. In the late 19th century, the legislatures in the states enacted dozens and dozens of occupational licensing laws. These were statutes that required members of health professions, like doctors, nurses, and pharmacists, to have a license and to pass an exam. There were also laws about architects, morticians, barbers, plumbers, and even horseshoers. Most of these could be described as friendly statutes, in which essentially the occupation or profession was governing itself. Like union activity, they were really attempts to control the labor market. The plumbers would go to the legislature and get the legislature to pass a statute under which the plumbers themselves would control who was licensed to do plumbing work. There would be a board established dominated by plumbers. It would hold examinations and grant licenses. It could be argued that all of these statutes restricted liberty of contract. They prevented people from practicing occupations like barbering, plumbing, horseshoeing, or working as an architect or a nurse without a license from a board controlled by the profession itself. Yet the courts almost universally upheld these statutes. They did not raise the specter of class warfare, they did not frighten the judges, and on the whole they passed muster with hardly a murmur. In this lecture, we've looked at some aspects of social and welfare legislation in the 19th and early 20th century. We began by looking at the poor law system, which was on the whole both local and harsh. We looked at the transition from outdoor to indoor relief and the peculiar and unfortunate American habit of demonizing the poor and the unfortunate. We also took a look at the struggles between labor and management in the late 19th and early 20th century, and the role that the legal system, and in particular the courts, played in that struggle. The courts, in some notorious cases, appeared to be extremely reactionary, and from our standpoint, perhaps they were. On the other hand, they were reacting to what to them seemed the perfectly justified fear of class struggle and class warfare. Other types of statutes, which also arguably interfered with the free market, were much less threatening to them and did not arouse the same kind of suspicion on their part. The example we gave there was occupational licensing laws. In the next lecture, we're going to pick up the story once more of crime, punishment, and the criminal justice system, and watch how it developed in the 20th century.
After listening to Lecture 10, a student posed this question to Professor Friedman. Is it a luxury that we can be concerned with health and the environment? Let's listen to the professor's response.
In many ways, it is a luxury to be concerned about health, safety, and conditions of work. I remember a trip I took recently to a third world country that I won't identify, in which I observed workers that were building a building under conditions that would be completely intolerable in the United States. First of all, they were working at night, seemingly very long hours. They had no safety equipment, no scaffolding. They were high up in the building, and so on. I imagine that what happens in a case like that is that they're told, you want the job? There are hundreds of us who would take that job and do it for even less money than you are. If you're going to complain about anything, you can just go back to your village and starve. It's a pattern throughout the Western world that as a society modernizes, as it gets wealthier and more advanced, the ordinary people, the working people, begin to complain about conditions which perhaps in an earlier time they would have put up with simply out of excessive desperation. So in many ways, the industrial struggle can even be seen as a sign of progress, a sign that people were less willing to put up with conditions that they had accepted as perhaps fate or inevitable or nothing can be done about it before.
This ends Lecture 10. Remember to visit this course's webpage at www.modernscholar.com, where you'll find additional information about the lectures that you just heard. If you borrowed this course from a public library and would like your own copy of the course guide for future reference, call Recorded Books at 1-800-636-3399, and we'll send you a free copy. A shipping charge will apply. The American Legal Experience, Lecture 11, Crime and Punishment in the 20th Century.
In this lecture, we're going to continue the story about crime, punishment, and criminal justice and see how it developed in the 20th century. Here are the main points that we will consider. The first is the federal role in the criminal justice system. The federal government was practically not a player at all in the 19th century. In the 20th century, it entered the picture and today is a player of some importance in the criminal justice system. We are also going to continue our story of the regulation by criminal law of morality and sexual behavior. The 20th century saw some very startling changes in the law. In the first part of the century, increased stringency, and in the latter part of the century, a period of great permissiveness. In the latter part of the century also, a rising crime rate led to an increased emphasis on harshness and imprisonment. At the same time, somewhat paradoxically, the Supreme Court expanded dramatically the rights of criminal defendants. We'll also take a look at the death penalty and its rather remarkable career in the last half of the 20th century. Criminal justice is mostly a matter for the states. It always has been, and it continues to be so today. The vast majority of all criminal trials are state trials. The police, the jails, the prisons are state institutions. The federal government did not even have a prison it could call its own until almost the end of the 19th century. There were only a few federal prisoners, and they were boarded in state prisons. Of course, the District of Columbia was federal and had a criminal justice system, and this was true also of territories. But on the whole, the federal government was simply not a player in the criminal justice system. In the 20th century, however, federal criminal justice became significantly more important. This happened for a number of reasons. In the first place, this is a century that has had a whole host of new regulatory statutes, and these have greatly expanded the list of crimes that are federal in nature. For example, there is now a federal income tax law. Tax fraud, tax evasion have become federal crimes. The federal government has also become a factor in the fighting of crime with the formation of the Federal Bureau of Investigation. The FBI dates back to 1908, when the Attorney General set up a Bureau of Investigation inside the Justice Department. The name of the Attorney General was Charles Bonaparte, and yes, he was in fact a relative of Napoleon. Eventually, this Bureau of Investigation became the Federal Bureau of Investigation. In 1924, J. Edgar Hoover took over as director, and he turned the FBI into a very important tool of interstate crime fighting. He made the FBI more scientific and efficient. He opened a crime laboratory in 1932. The FBI also began to gather more accurate statistics on crime from the 1930s on. Hoover was also a master of publicity and public relations and made himself and the FBI famous for catching and killing celebrity bandits. But the growth of the FBI is not simply a tribute to Hoover and his genius for self-promotion. The fact is that there was, for the first time, an interstate factor in crime. Crime itself was no longer as local as it used to be. The Dyer Act, a federal statute, for example, made it a crime to transport a stolen motor vehicle across state lines. In its heyday, this statute provided a lot of prisoners for federal jails. National prohibition filled the jails even more in the 1920s. In later decades, and at the present day, the drug laws have contributed tens of thousands of prisoners to federal prisons. In the age of radio, the movies, and TV, a national culture and the increasing importance of the president and the presidency has thrown the spotlight on the federal government. Partly for this reason, in the last half of the century, crime for the first time became a national issue. No president in the 19th century or the early 20th century, in his State of the Union message, ever talked about the problem of crime. But in the late 20th century, crime was considered to be a national issue and therefore had to be discussed by the president. The federal government also inserted itself into local systems of criminal justice, mostly by funneling money to states and localities. Thus, while it remains true today that the criminal justice system is overwhelmingly state and local, by now the federal presence is a matter of importance to be reckoned with both politically, economically, and socially. In the first part of the 20th century, the war on vice that had begun in the late 19th century continued and was strengthened. A number of cities, for example, began to attack the problem of vice. They appointed vice commissions to look into the situation, to issue reports, and to recommend what should be done. One of the most famous examples was the Chicago Vice Commission, which issued its report in 1911. It denounced what it called the social evil. The social evil led to, quote, sterility, insanity, paralysis, the blinded eyes of little babes, the twisted limbs of deformed children, degradation, physical rot, and mental decay. The commission called for the repression of prostitution, and the ultimate goal was, quote, absolute annihilation. The red light abatement movement came out of the work of these vice commissions. The idea was to end the Victorian compromise and stamp out vice once and for all. In 1910, Congress passed the Mann Act, the famous white slave law. This act made it a crime to transport a woman across state lines for immoral purposes. In the background of the Mann Act was a national uproar. You could almost call it a hysteria over something that was called white slavery. The claims were that there were evil men in the sex business who lurked in movie houses, dance halls, dark passages, and lured innocent country girls to their ruin. They used trickery or force, or even, quotes, poisoned darts or hypodermic needles. The girls would be held as virtual slaves of sex. There were state and local laws, of course, but they were considered ineffective. The Mann Act was a response on a national level. Was there anything behind the hysteria over white slavery? The sexual oppression of women and venereal diseases are certainly worth worrying about. But the most important problem underlying prostitution was the economic condition of women at low-paid jobs in big cities. Many women, in fact, turned to prostitution on their own. They were simply desperate for money. But this was a very hard idea for people to accept. The propaganda shifted the blame from the economy to evil, sinister, dark-haired men who preyed on virtuous women and ruined their lives. The Supreme Court gave the Mann Act a very broad reading. A famous case involved two young men from California, Drew Caminetti and a friend of his named Maury Diggs. They were married men from prominent families, but they were not particularly faithful to their wives. They went off to Nevada with two young women. The trip caused something of a scandal. The men were arrested and tried for violating the Mann Act. In their defense, they said that the Mann Act was aimed at white slavery or prostitution or commercialized vice, and there was no indication whatsoever that the women they went to Nevada with were the least bit unwilling to go and join in the fun. Nevertheless, they were convicted, and the Supreme Court affirmed their conviction. They had crossed the state line for an immoral purpose, and that was enough to satisfy the act. In addition to the Mann Act, the states toughened their sex laws in part by raising the so-called age of consent. The age of consent is the age at which a woman may consent to sexual intercourse. Below the age of consent, sex with a female is rape, a very serious crime. The common law age of consent was 10, which strikes us today as exceedingly low. But in the late 19th and early 20th century, a number of states raised the age of consent to 18, which strikes us as a bit high. Under the laws, if two 17-year-olds have completely consensual sex, the male is guilty of a very serious crime, statutory rape, and the female is, by definition, a victim, no matter how eager she was to participate in this noxious crime. The point was simply to criminalize teenage sexuality. There was a strong moral sense powering this movement, but there was also the notion of severe danger to the polity that came from vice and crime. This sense of danger was reinforced by the growth of the eugenics movement, which we've mentioned once before. It was widely believed that crime and vice were inherited traits. It was thus very important to prevent defective human beings from breeding. A number of states, starting with Indiana in 1909, passed sterilization statutes, which called for the sterilization of the feeble-minded or of criminals. The Supreme Court confronted these statutes in the famous case of Buck versus Bell, decided in 1927. Carrie Buck, who was described as a feeble-minded white woman, was 18 years old and lived in the Virginia State Colony for epileptics and the feeble-minded. She was said to be the daughter of a feeble-minded mother and in turn the mother of an illegitimate feeble-minded child. Oliver Wendell Holmes Jr. wrote the opinion, and he approved of the Virginia law without the slightest hesitation. After all, the state could force children to be vaccinated. It could force young men to die in battle. Why not order a woman to be sterilized? In a famous line, Holmes said, 3 generations of imbeciles are enough. The irony is that there were no generations of imbeciles at all. It turns out that neither Carrie, nor her mother, nor her child was actually retarded. In fact, the child who died young was considered quite bright. The case was based on an unfortunate misconception. It was really 3 generations of poor, inarticulate women, 3 generations of white trash at the bottom of the heap in society. The crown jewel, however, of the movement against vice and sin was national prohibition. A constitutional amendment criminalized alcoholic beverages, and the decade of the 1920s was officially dry. After the amendment to the Constitution was ratified, Congress passed the Volstead Act in 1919 to provide prohibition with some teeth. Under the Volstead Act, it was illegal to make or sell any kind of intoxicating liquor. Many states passed their own little Volstead Act. From 1920 until 1933, prohibition was an object of controversy. Prohibition arrests and prosecutions filled the jails, but millions of people went right on drinking. Prohibition is often blamed for the rise of the gangster culture, for Scarface Al Capone, the Chicago mob leader, and his counterparts in other cities. It is blamed, in short, for the spread of organized crime. It is also held up as a textbook example of an unenforceable law. In fact, it may have been more effective than most of its critics admit. City people, particularly ones with money, kept right on guzzling away. But in the countryside, there were many dry areas. Deaths from liver disease and drunken driving dropped significantly. It did, in fact, lead to a staggering amount of municipal corruption. Prohibition was repealed in the 1930s, and the tables began to turn on the whole movement. In the last half of the 20th century, there was a dramatic and steady reversal of the trends that characterized the early portion of the century. Many states completely repealed their laws against adultery, fornication, and sodomy. The Supreme Court in 2003 completed the job by striking down all the surviving sodomy laws. The Mann Act was amended so much that it essentially is meaningless today. Control over pornographic literature basically evaporated. Gambling spread from Nevada to Atlantic City and then basically all over the country. The so-called sexual revolution was in large part responsible for this shift, and this in turn probably rested on even deeper social forces, which drove a culture of self-realization and personal choice. All of this deeply influenced the law. To this trend of permissiveness, there is one outstanding and extremely important and glaring exception: the drug laws. The drug laws also date from the early part of the 20th century. In the 19th century, on the whole, while nobody thought drug addiction was a good idea, drug addiction was not criminalized. The war on drugs began at roughly the same time as the war on the red light districts and the culmination of the movement for national prohibition. The drug laws, however, have been survivors. They have become, on the whole, sharper and more draconian over time, and very few voices speak out for decriminalization. The drug laws have been one factor that has led to an enormous increase in the prison population. They fall with special severity on members of racial minorities. It is a little bit of a mystery why the drug laws have been such an egregious exception to such a strong trend of decriminalization. Perhaps it has something to do with people's fears for their children. They no longer are afraid of the white slaver, but they are afraid of the drug pusher. They fear that the drug pusher will involve their children in an addiction from which there is no means of escape. The death penalty has had an unusually interesting and complicated history during the 20th century. In the first half of the century, the use of the death penalty declined slowly. At one point in 1972, the Supreme Court struck down all existing death penalty laws. Only a minority of the court had held that the death penalty was inherently unconstitutional. The majority of the justices felt that the death penalty was wrong in the way that it was administered, that it was far too arbitrary and random. This led the states that wished to retain the death penalty searching for clues in the text of the Supreme Court decision for ways to draft a death penalty statute that would meet the approval of the Supreme Court. In 1976, the court did give its stamp of approval to one type of law. This then became the template for death penalty statutes in the majority of the states. The procedure that's used in death penalty cases is quite complex. It involves essentially a double trial. First comes the guilt phase, then comes the penalty phase. About a dozen states have no death penalty whatsoever. Most of the other states use the death penalty very sparingly. The exceptions are some states of the Deep South, though not all of them. Texas is in a class by itself. About a third of all executions within the country take place in the state of Texas. At the very end of the 20th century, fresh doubts arose about the death penalty. A few highly publicized cases of innocent men wrongly convicted and put on death row and exonerated by DNA or some other device have led to a kind of backlash against the death penalty, though it still remains on the whole quite popular. Violent crime rose dramatically in the years after the Second World War. Throughout the 19th century, and during the first half or so of the 20th century, the violent crime rate either declined or rose very slowly. Now, for reasons that remain extremely obscure, there was a dramatic escalation in murders and other forms of violence. As a consequence, fear of crime became a major social fact, and crime itself became an enormously important political issue. It became almost essential for political figures to announce how tough they were on crime. The states embarked on an orgy of prison building, and they filled the prisons with new prisoners. Harsh statutes were passed, such as California's three-strike law. California adopted this law by referendum in 1992. In the background was a horrible crime. A young girl named Polly Klaas had been abducted from her own bedroom and brutally murdered. As is often the case in the history of criminal justice, a particularly loathsome crime is the impetus for the passage of a relatively harsh statute. The California law is extremely complex. It rested on a very, very enticing slogan, 3 strikes and you're out, that was catchy and easy to understand. If a defendant had 2 or more prior convictions for serious felonies and was convicted of yet another one, he had to receive a life sentence and serve a minimum of 25 years in prison. In theory, there was no flexibility whatsoever in this system. No room for discretion on the part of the judges, no room for mercy. The California statute was the most severe, but other states chimed in with their own versions of this kind of law. Some states repealed their parole and indeterminate sentence laws. Laws were also enacted making it possible to try juveniles as adults. In short, there was a considerable movement of backtracking, of undoing the reforms passed in the late 19th century. At that time, the emphasis had been shifted from the offense to the offender. We remarked that this was characteristics of periods that were not excessively concerned with the crime rate. The late 20th century was the opposite, paralyzed by fear of crime. Hence the shift once more from emphasis on the offender to emphasis on the offense. Whether all of these laws actually had any impact on the crime rate is a much contested question. And at the very end of the 20th century, the crime rate began to slacken for reasons that are as poorly understood as the reasons why it rose so dramatically in the first place. Trial by jury is a constitutional right, but in the late 20th century, comparatively few defendants really made use of it. The vast majority simply pleaded guilty. We have already mentioned the plea bargaining system. By the late 20th century, the plea bargaining system had become totally pervasive and remained pervasive despite attempts to limit or abolish it in particular kinds of crime or in general. Paradoxically, the period in which the crime rate rose so dramatically and in which states began to pass ever harsher laws was also a period in which the Supreme Court became interested in expanding the rights of criminal defendants. The Supreme Court under Chief Justice Earl Warren in the 1950s and 1960s issued a dramatic series of cases which, in theory at least, gave criminal defendants much greater rights than they had had before. 2 of these cases are particularly famous. In Gideon versus Wainwright, the Supreme Court decided that a criminal defendant had a right to free counsel, a lawyer paid for by the state, in any case in which he was accused of a serious crime. A second very dramatic and important case was Miranda versus Arizona, decided in 1966. Ernesto Miranda had been arrested for the crime of rape. The police gave him a thorough grilling, and at the end of this, he confessed to the crime and was convicted. The police insisted that they had not mistreated Miranda, They had not beaten him. They had not seduced him with false promises. Nevertheless, the Supreme Court reversed the case. A person that is held for questioning has to be told specifically about his rights. The right to be silent, the right to consult a lawyer. This gave rise to the famous Miranda warning, which the police now read to everyone they arrest, and which everybody knows from TV if from nowhere else. Ironically, in 1976, the Miranda warning was read in both Spanish and English to a man who was arrested after a fight in which he stabbed another man twice. The victim died on the way to the hospital. His name was Ernesto Miranda. Perhaps the last words that he heard before he lost consciousness was the famous warning named after him. Whether the Miranda warning itself has an impact on police behavior is a much discussed and much contested question. Police brutality, in fact, remains an issue and a problem. It is probably true that police behavior has improved considerably in the period since the famous Supreme Court decisions. Probably this has less to do with the decisions than changes in society itself. There are more minority police officers, and the police are more conscious, at least, of the issues of brutality and police behavior in general. At any rate, the rights of criminal defendants has been and continues to be a much discussed issue. At the dawn of the 20th century, the war on terror has led to new demands for the curtailment of ordinary criminal process for terrorists and people who are suspected of terrorist activity. This, too, has led to considerable discussion and controversy. In this lecture, we've discussed developments in the system of criminal justice in the 20th century. We talked about the role of the federal government, which for the first time was a player of some importance in the criminal justice system. We also talked about the rise and fall of the war on vice, from the early part of the century in which it heightened and led to prohibition and a number of other laws relating to victimless crime, to the latter part of the century in which there was a wholesale decriminalization, particularly of laws regulating sexual behavior. The big exception, of course, has been the drug laws. We talked about the rise and fall of the death penalty and also about the war on crime and the way in which it led to reforms or changes in the criminal justice system and the passage of very draconian criminal justice statutes. We also talked about the way in which the Warren Court attempted to expand the rights of criminal defendants. What effect any of these measures have had on the crime rate cannot be answered with any degree of certainty. In the next lecture, we will talk about the rise of the welfare regulatory state, the increasing importance of federal and state regulation of the economy, and the laws about health, safety, and welfare that have been so prominent a part of the 20th century legal scene.
This ends Lecture 11. The American Legal Experience, Lecture 12. The Rise of the Welfare Regulatory State.
In this lecture, we're going to look at the rise of the welfare and regulatory state, the efforts of government to control, monitor, and improve the economy and to provide for the health, welfare, and benefit of the general public. We will look at the beginnings of major federal regulation in the 19th century, specifically of railroads, and the passage of the Sherman Antitrust Act, which was aimed at the giant combines of the period. We will then take a look at the New Deal revolution, the great transfer of power from the states to the federal government, and the whole cluster of new initiatives that came in during the presidency of Franklin Delano Roosevelt. Lastly, we will look briefly at the welfare and regulatory state as it has evolved since the end of the New Deal. In the early 19th century, travel and communication were painfully slow. It took months for messages or personnel to go from one end of the country to another. The very idea of centralized control of the economy was simply unthinkable. The railroad and the telegraph brought about a fundamental change. We saw in an earlier lecture how eager the general population was to secure railroad connections between their farms and the cities of the East. By 1870, national railroad nets had formed. The early railroads were small and went from one town to another town. They gradually consolidated and formed larger enterprises. In 1869, the first transcontinental railroad was completed. Now the country was bound from one end to another by a single network of rails. The farmers and merchants had, of course, welcomed the railroad, but they now found themselves at the mercy of giant corporations, which were often both greedy and corrupt. In the 1870s, some of the Midwestern states tried to regulate the railroads with statutes which are usually called the Granger laws. State regulation failed politically, and it was weak and legally inadequate in a federal union. No one state could control the railroads. How much power did Connecticut, or for that matter even Texas, have over the railroads that went from one state to another state? Out of this came a demand for national railroad regulation. In 1877, the Interstate Commerce Commission Act was passed. This was one of the first great federal independent agencies. An agency is independent when its members, once appointed and confirmed, cannot be removed by the president. The Interstate Commerce Commission was given the power to control the railroads. At least it was given this power on paper. How it succeeded in this task is another question entirely. The law itself was an incoherent jumble of contradictory aims. This is only to be expected. The farmers and merchants that were in favor of control of the railroads were politically powerful, to be sure, but the great railroads were equally powerful. Any major piece of legislation of this type is bound to be a compromise. The ICC law was no exception, and its administration was hardly what the farmers and merchants had hoped for. The great railroads were only a symptom of something that seemed to threaten the small man, the ordinary citizen, the farmer, the little merchant. The rise of big business seemed to be an enormous threat. Corporation law was essentially permissive. It made little attempt to control the behavior of corporations. At the end of the century, there were more and more consolidations and the formation of huge combines. One of the prime examples was Rockefeller's Standard Oil Company, which essentially monopolized this crucial industry. The Sherman Act was passed in 1890. This was the first American antitrust law on the federal level. The aim of the law was to control or even suppress the trusts, that is, the giant combines, the great mergers like Standard Oil. It was a brief law, and unlike the Interstate Commerce Commission Act, it failed to set up an agency to enforce the act. That meant that the courts and the administration itself had to carry the act into effect. Everything depended then on the attitude of the President, the Department of Justice, and the federal courts. Some of the early cases tended to interpret the Sherman Act very narrowly. But in the early 19th century, the government did succeed in breaking up Standard Oil. And the Clayton Act, passed in 1914, created a federal agency with power to enforce fair trade practices. Since then, antitrust law has been a significant aspect of federal economic policy. The antitrust division has had some notable successes and some notable failures. The breakup of the telephone monopoly was one of the successes. The failure to break up IBM was one of the failures. At the end of the 20th century and the very beginning of the 21st, the government moved to try to break up Microsoft, so far without signal success. Federal regulation and regulation in general had been growing slowly but definitely since the late 19th century. The New Deal was a great watershed. It's important not to exaggerate the impact of the New Deal, however. In 1901, 240,000 people worked for the government. In 1920, 655,000, and by 1939, another 300,000. President Hoover, at the end of the 1920s, already presided over a vast federal bureaucracy. The flow of power and influence from the states to the federal government was accelerated greatly by the New Deal. But this was a process that was probably inevitable. To the railroad and the telegraph were added the telephone, the airplane, then later radio, TV. These were all instruments of transportation and communication that bound the country more and more into a single cultural unit and focused attention on the central government and away from the governments of the states and the localities. The power of the states has not vanished. In fact, they are more powerful in the present time than they were 100 years ago. They have gained power absolutely, but lost power relative to the federal government. The Great Depression was, however, a very important landmark in American history and also in American legal history. It was a cataclysmic event. The economy was in total collapse. About a quarter of the population was unemployed. The country was desperate. The New Deal came into the vacuum and rushed into the great social void that was created by the Depression. The country was hungry for some kind of action. And the country got action from Franklin D. Roosevelt and the New Deal. The New Deal attempted to create jobs through massive public works. The Works Progress Administration, or WPA, was created in 1935 by executive order. It was authorized by Emergency Relief Acts from 1935 on. At its peak, millions of people were on its employment rolls. All over the country, artists painted murals in post offices, writers wrote guidebooks, humbler workers built thousands of miles of roads and culverts, drained swamps, cleared slums, and promoted public health. Every part of the country was affected by WPA projects. The significance of the WPA was, of course, that it created jobs and gave some hope to the hopeless. But it was also an almost unprecedented incursion of the federal government into a field, welfare, that had once been exclusively a state and local responsibility. But the states and the localities were completely bankrupt during the Great Depression. There was no way that they had the power or the money to do anything significant about the armies of the hungry and the unemployed. The New Deal, in effect, had taken over the welfare system. No achievement of the New Deal was more important than the Social Security Act of 1935. In the midst of the Depression, one could almost speak of the creation of a new class, which we might call the submerged middle class. These were millions of people who had once considered themselves part of the middle class, but who had been plunged into poverty by the catastrophic effects of the Great Depression. It was vast and articulate, and its members demanded some kind of help from the government, something to lift them out of their troubles and put them back where they belonged. Out of this climate came the Social Security Act. Old age pensions were an idea whose time had come. One goal of the New Deal was always to make jobs. Public works programs were part of the answers. Pensions for the elderly were another. It was an attractive idea in itself, but it also was a way to ease thousands out of the labor market into a comfortable retirement. Young, unemployed people could take their place. It would be hard to think of a law that has had more of an impact on American life than the Social Security law. Today, it still has a powerful economic and political grip on the population, and indeed the solvency and the future of the Social Security system is something which is much debated and discussed today. The Social Security idea is essentially untouchable. What makes it untouchable is its character. Nobody thinks of it as welfare. You earn your pension through payroll deductions. This is not a dole. This is a kind of insurance policy backed up by the government. Of course, if the average person thinks that somewhere in Washington there's an account with her name on it, something like a bank account which grows every year, that's a mistake. Social Security is not like an insurance policy. It's not at all like a bank account. But that's the way the Social Security system feels to the public. There was and is no means test. Getting a Social Security check is not a disgrace. It's something that one is entitled to. And that's the secret of the law's tremendous success. It was, in the main, and is a program for the submerged middle class. The New Deal did many, many other things. It sought to cure the ills of Wall Street. After all, the Great Depression started with a stock market crash. Fraud and corruption in the sale of stocks and bonds was epidemic. The goal of the New Deal was to tame Wall Street. A crucial regulatory act was the Securities and Exchange Commission Act, which set up a new independent agency, the SEC, to monitor the stock exchanges and to make sure that the public was told the truth about stocks and bonds. The New Deal also brought in federal deposit insurance to try to prevent the collapse of the banking system. It started a public housing program. It created a national labor relations board. This law tilted toward the unions. It guaranteed them the right to organize, and it prevented employers from interfering with union elections. There was also a New Deal agricultural program which tried to cure the problem of poverty on the farm. The problem here was overproduction, as the New Deal saw it, and underconsumption. The New Deal paid people not to grow crops. It tried to do something about low farm prices. Whether it was successful is something which is debated to this day. Roosevelt was a master politician. His message reached millions of people through radio and newsreels. His personality accelerated a process that really was inevitable. This was the process of centralization and the relative shift of power from the states to the federal government. Roosevelt enjoyed enormous majorities in both houses of Congress. There was some opposition, but it was at first relatively feeble. There was one institution of government, however, that Roosevelt did not control, and that was the federal court system. Federal judges are appointed for life, and the judges that Roosevelt confronted at the beginning of his term were holdovers from a prior era. This was particularly true of the Supreme Court, the famous 9 old men. In a series of very striking decisions, the Supreme Court struck down some of the key statutes that had been passed during the early days of the New Deal. In 1936, Roosevelt was reelected with a triumphant majority. and he resolved to try to do something about the Supreme Court. He came up with a plan to add new justices to the court and thus swamp the justices who were opposed to the New Deal program. His proposal would have given him 6 new justices and would have effectively neutralized the court and prevented it from showing what he thought was a bias against the New Deal. But this was not to be. His proposal generated an intense controversy. Somehow he had profaned some kind of sacred or holy aspect of American government. There were fervent New Dealers who favored the plan, but the opposition was even more powerful. The plan was denounced, it was condemned, it was considered a threat to the integrity of the courts. The tide ran very strongly against the plan, and in the end it had to be abandoned. It was an amazing defeat for a president who was amazingly popular. But Roosevelt lost this battle and won the war. Even in the short run, the situation really changed. In 1937, the Supreme Court began to uphold New Deal legislation. By a narrow 5-4 margin, the court approved of the National Labor Relations Act. In this and a number of other cases, one justice, Owen Roberts, apparently changed sides. This converted 5-4 votes against New Deal measures to 5-4 votes in favor of them. There has been intense controversy ever since then as to whether there really was a kind of switch or change of heart on the part of Roberts, and if so, whether it was a reaction to the court-packing plan or not. But in fact, the court had been in the process of rethinking the way it understood the Constitution. It was changing its general outlook. The court had once been very deeply committed to drawing a bright line between state power and federal power. It had once woven a tissue of doctrines which limited the extent to which the federal government could interfere with private businesses. But all this was gradually changing, and it may be that the switch, or apparent switch, in 1937 was more apparent than real. It was simply the continuation of a process that had begun years before. In any event, time was definitely on Roosevelt's side. He was elected 4 times. The 9 old men died off or resigned. Roosevelt replaced them with fervent backers of the New Deal. In the later Roosevelt years, the Supreme Court renounced any sort of economic activism. It gave its stamp of approval to all of the programs of the New Deal. It abandoned the whole line of cases that were epitomized by Lochner versus New York. All but one of the justices at the time of the death of Franklin Delano Roosevelt had been appointed by Roosevelt himself. The child labor cases and the other cases that so offended progressives were overruled or simply ignored. The outbreak of war in 1941 led to even further centralization. The country needed to mobilize the entire population. It had to raise a gigantic army, navy, and air force. It had to control a wartime economy. There was wage and price control, and an enormous black market, which grew up as a consequence. The post-war period was not a period in which there was any retreat from the New Deal, even under Republican presidents. In fact, there was extremely important social legislation in the period right after the end of the Second World War. One of the most important pieces of legislation was the so-called GI Bill of Rights. One of the consequences of the war had been full employment. All available manpower was sucked up by the armed forces or in the many defense factories. Millions of women also went to work in defense industries. In 1946, Congress passed an Employment Act, which boldly announced that the federal government had a continuing responsibility to promote employment opportunities. There actually were no teeth in the act, but it had an important symbolic significance. The announcement that the federal government had some sort of responsibility to make jobs was something which would not have been heard before the New Deal. The GI Bill of Rights was an amazingly important law. It was passed out of a genuine sense of gratitude to the veterans who had fought the war, but it also had other motivations. One of the great fears was that the end of the war would bring back the desperate period of unemployment that had ended only with the outbreak of the war. The GI Bill authorized a readjustment allowance of $20 a week for veterans who are looking for jobs. More importantly, it gave GIs loans to start businesses or buy houses. It financed the higher education of all veterans. The GI Bill paved the way for the vast expansion of higher education. It paved the way for the flight to the suburbs, for the creation of new communities, places like Levittown. With tuition paid and a monthly stipend, veterans flocked to schools they would not have dreamed of going to before. Socially, the veterans transformed higher education. The colleges and universities were bursting at the seams, and they lost much of their elite flavor. In the post-war years in general, there was no retreat from the big, important laws that were part of the revolution brought about during the New Deal. Congress did not repeal any of the major laws. They did not even amend them drastically. The one possible exception was in the field of labor law, where in 1947 Congress passed an important act called the Taft-Hartley Act. It responded to a widespread feeling that the unions had gotten too much power during the Roosevelt years and that something was out of balance. Another wave of legislation came during the presidency of Lyndon Johnson. In January 1965, President Johnson, in his State of the Union speech, announced something that he called the Great Society. His aim was to step up the war on poverty. Congress established a Department of Housing and Urban Development in 1965. Even more significant were laws that were passed in July of that year. This added on to the country's policy of social insurance two new programs, Medicare and Medicaid. Medicare promised basic protection against hospital costs to everybody over 65 years old. It covered up to 90 days in a hospital for any one illness. The elderly could also get their doctor bills paid in exchange for a modest premium. Medicaid, which was part of the same statute, gave funds to the state to help pay the medical bills of blind people, the disabled, and dependent children. It also had the potential to cover everybody that was poor. The states were allowed to take the money they once used for the elderly poor, who were now covered by Medicare, and use it for this purpose. Medicare, in particular, was wildly popular almost from the moment it started. Of course, it helped senior citizens enormously, but it also helped their middle-aged children. It was a special boon to the middle-class members of the sandwich generation, people who were struggling to pay off their mortgages and send the kids to college, and at the same time were saddled with old, sick, and elderly parents. The government had stepped in to ease this burden. Johnson no doubt thought of the war on poverty and the Great Society as a kind of bold new beginning, a great leap forward. In retrospect, the Great Society doesn't quite look that way. It looks like the crest and the peak. Soon there was a kind of falling off. Medicare was untouchable, but the welfare state never marched forward as many thought it would and should. In this lecture, we've talked about the rise of the welfare and regulatory state. and in particular, the drift of power from the states to the federal government. We began by looking at regulation of railroads and the antitrust laws of the 19th century. We then took a look at the New Deal revolution, a revolution in welfare and a revolution in the responsibility of the federal government for management of the economy. We also looked at the relationship between Roosevelt's New Deal and the Supreme Court. Lastly, we took a look at some post-World War developments and the Great Society programs of Medicare and Medicaid. In the next lecture, we will return to the issue of race relations, civil rights, and civil liberties and examine their course of development in the 20th century.
This ends Lecture 12. The American Legal Experience, Lecture 13, Race Relations, Civil Rights, and Civil Liberties in the 20th Century.
In this lecture, we're going to examine race relations in the 20th century. In the early years of the century, white supremacy was riding high in the South. But the black movement began to gather strength, and it found an ally in the United States Supreme Court. In the latter part of the 20th century, the civil rights movement made astonishing gains. During this period, too, for the first time, gender discrimination became an object of the law. The movements against race and gender discrimination are in fact symptoms of an even larger movement which affected other minorities as well. Religious minorities, the handicapped, sexual minorities, and the elderly. The 20th century is also a period in which there was a tremendous burst of law and legislation with regard to civil liberties. The Supreme Court had, practically speaking, never ruled on issues like freedom of speech during the 19th century. But in the 20th century, they developed an impressive body of case law on the subject. Civil liberties, however, is more than a matter of court decisions, as we will see. There have been low points in the practical living law of civil liberties, particularly after the First World War and during the so-called McCarthy era. In the early years of the 20th century, black people in the South, where most of them lived, were politically, economically, and socially powerless. They were also victimized in many ways. The most extreme and dramatic example of this was lynch law. Lynching was sometimes incredibly brutal. There was one case, for example, in a small town in Georgia, where the victim's toes were cut off one by one, his fingers were removed, his teeth extracted with pliers. The man was then soaked with gasoline, set on fire. Thousands of people watched as his body was pumped full of bullets. Nobody was ever punished for these hideous acts of barbarism. Indeed, most white Southerners thought lynching was perfectly justified. They blamed the justice system, which they condemned as too slow and too inefficient. In fact, the justice system was very fast and very slapdash when it came to blacks. In one case in 1909, a black man was indicted, tried, convicted, and sentenced in 6 hours in Mississippi. Then he was hanged in public in front of 3,000 people. Since blacks had no entree to the political system, they were driven almost by necessity to seek redress through the court system. To be specific, through the federal court system, because the local courts were biased against them. The NAACP was founded early in the century. It began to fight American apartheid with a litigation strategy, and these cases began to show results as the century proceeded. In Thurgood Marshall, the court found itself an exceptionally talented and effective advocate. A particularly important case was Shelley versus Kramer, decided in 1948. The issue in this case was housing segregation. In some ways, this was the very heart of a system of apartheid. The precise issue was a racial restrictive covenant. A covenant was a private agreement in the text of a deed to a house. The point of the covenant was to protect the value and quality of neighborhoods. Deeds contained all sorts of covenants, promises, for example, that owners would not use the land for anything but a family home. But notoriously, they also often provided that the land and the house were only for Caucasians. By one estimate, up to 80% of the city of Chicago was covered by racial covenants. This system came before the United States Supreme Court in the case just mentioned, Shelley versus Kramer. The Supreme Court decided in that case that no court could enforce such a covenant. Why not? Because the 14th Amendment outlawed race discrimination by any state or any state agency. Chief Justice Vinson, writing for the court, pointed out that in order to enforce the covenant, you needed the active intervention of state courts. Constitutionally, he said, this could not be done. Shelley versus Kramer was a blow against housing segregation. The door opened, but only by a crack. Powerful norms and customs still kept cities divided into black zones and white zones. But without Shelley, the vast suburban empire would have been totally closed to non-whites. More important, the case was a straw in the wind. The Supreme Court found American apartheid repulsive and, what is more significant, of dubious constitutionality. The Supreme Court had long since mounted an attack on school segregation, particularly on school segregation, and specifically on the doctrine of separate but equal. They won most of their cases, but on narrow grounds. For example, in one case decided in 1950, a black mailman had the ambition to go to law school at the University of Texas. The University of Texas was for whites only. The state of Texas, afraid of losing the case, hastily created a new law school for blacks only. It consisted of 3 small rooms in a basement, a part-time faculty, and a tiny library. The Supreme Court certainly did not think this was equal in any sense. The University of Texas had prestige, it had traditions, it had great qualities. The plaintiff had to be admitted to the law school of the University of Texas without further ado. The case was decided unanimously. It seemed pretty clear that Plessy versus Ferguson, the separate but equal doctrine case, was losing its force. The dramatic turning point came in 1954 under a new Chief Justice, Earl Warren. The case was Brown versus Board of Education. Thurgood Marshall argued the case for the NAACP. In Brown, Marshall had decided to go for broke, to stop the piecemeal approach, and to ask the court to put an end to segregation in the schools once and for all. His strategy won a smashing victory. Brown v. Board of Education declared the system of racially segregated schools unconstitutional. It violated the Equal Protection Clause of the federal Constitution. In some ways, the case was cautiously worded, although it was unanimous. It spoke only about education. But in later cases, the Supreme Court made it totally clear that the principle of the case went far beyond public schools. In fact, all racial segregation was unconstitutional. For instance, a case decided in 1955 dealt with segregated beaches and bathhouses. The Supreme Court affirmed a judgment holding this unconstitutional in an opinion that was exactly 1 sentence long. The principle that the court was applying was by now perfectly clear. Segregation and race discrimination through law, rule, ordinance, regulation, or custom was an evil, and the Supreme Court would destroy it wherever it appeared. Finally, in 1967, in Loving versus Virginia, the Supreme Court confronted what had once been the ultimate taboo: interracial marriage and sex. Virginia's law, like the law of many states, made it a crime for any white person to intermarry with a colored person. Virginia's courts had upheld the law, citing earlier cases that talked about racial integrity, corruption of blood, and racial pride. Virginia also argued that this was not a law that discriminated against anybody. Its burden fell on whites just as much as it did on blacks. The Supreme Court was having none of this. Unanimously, the court struck down the statute. The statute was designed solely to maintain white supremacy, according to Chief Justice Warren. No state could infringe the freedom to marry or not marry a person of another race. The reaction of the white South to the Brown case and the cases that followed was bitter, intense, and sometimes violent. Desegregation was painfully slow. A decade after the Brown case, very few black children in fact attended integrated schools. Even the universities in the South had resisted integration. In a number of instances, federal troops had to be called in to enforce integration. One notable example occurred in connection with Central High School in Little Rock, Arkansas. But the civil rights movement persisted. The lower federal courts, where desegregation cases were actually handled, stood firm in general, and the civil rights movement found a charismatic leader in the person of Martin Luther King, Jr. Moreover, the advent of television made an important difference. Now everybody all over the country could watch on television and see scenes coming from the South. They could see dogs set upon protesters. They could see howling mobs spitting at little girls trying to enter a schoolhouse. The result was an outpouring of support for the civil rights movement from many circles in the North. In 1964, under the leadership of President Lyndon Johnson, Congress passed a major Civil Rights Act. The Civil Rights Act was a breakthrough in all sorts of ways. It was, to begin with, a political breakthrough. Southern whites controlled many important committees in Congress, and they had always killed any attempt to pass a civil rights law. A last-ditch filibuster failed when the Senate voted to cut off debate. The act was long, detailed, sweeping, and comprehensive. No hotel, motel, no inn, no restaurant, cafeteria, or lunchroom, no gas station, no theater, no sports stadium was allowed to discriminate on the basis of race or color. There could be no discrimination, moreover, in public education. And a crucial section of the Act forbade race discrimination in hiring and firing. It covered all employers of 25 or more workers engaged in an industry, quotes, affecting commerce. This turned out to mean almost everybody. The Act also set up an administrative agency, the Equal Employment Opportunity Commission, to hear complaints of violation of the Act. The Supreme Court unanimously upheld the Act in two cases decided in 1964. One of these cases came out of Birmingham. The owners of a restaurant specializing in barbecue and homemade pies called Ollie's Barbecue refused to serve blacks. Some of the barbecued meat had in fact crossed state lines. The court said this was reason enough to uphold the law. Besides, according to the court, discrimination against black people means that they buy less, and that means that bigotry impedes the flow of commerce. a 19th century court, or even a court in the first half of the 20th century, would have found this reasoning preposterous. But in the age of the civil rights movement, the Supreme Court was not about to strike down the most important civil rights law of the century. The next year, Congress passed a law that was in some ways even more significant. This was the Voting Rights Act of 1965. Ever since Reconstruction, in theory, blacks had had the right to vote, but this was only in theory. White governments in the South had stripped this right away. There were counties where not a single black was registered. In 1957, the Attorney General had been given the right to challenge race discrimination in the voting process. But this law was totally ineffective. The government had to work case by case against each state, county, town, or township. This was like trying to push a boulder up to the top of a mountain. The Voting Rights Act of 1965 tried to avoid this difficulty. It contained some ingenious but practical provisions. It swept away all the tricks and traps that kept blacks from voting, poll tax, literacy tests, and so on. It basically gave the federal government control of the voting process in any state or any county where less than half the people of voting age were actually registered on November 1st, 1964, or where less than half had actually voted in that election. Because the Justice Department was serious about enforcing the law, and because the law was drastic and hard to evade, the Voting Rights Act was not a dead-letter law. Quite to the contrary, it turned Southern politics inside out. For the first time since Reconstruction, blacks began to vote in serious numbers, and soon there were black mayors and members of Congress from the Southern states. The Civil Rights Act was itself in many ways extremely successful. It ended segregation in public accommodations, for example. Housing and employment have been more troublesome. In employment, the courts and agencies have developed doctrines to ferret out and fight covert discrimination. Since overt, patent discrimination is now illegal, some prejudiced employers have more or less gone underground. Under the law as it is now interpreted, if an employer adopts a policy that has a disparate impact racially, then the employer has to show that the requirement is essential to the job. What this means is as follows. Suppose an employer suddenly decides that you must have a college degree to hold a certain job. And suppose that this policy excludes more blacks than it excludes whites. The employer now has the burden of proof to show that this requirement is essential to the job. If he doesn't meet this burden of proof, the requirement cannot be sustained. One area of law that remains deeply controversial is affirmative action. It's been adopted by businesses, municipalities, and universities in an attempt to increase diversity. But affirmative action is unpopular. It's usually voted down if presented to the electorate. The Supreme Court has vacillated on this issue over the years. It's gone this way and then that way. There are justices who think that affirmative action is a very sound policy. Others feel that it's a form of race discrimination. They argue that discrimination against whites, for whatever reason, is as bad as discrimination against blacks. Ultimately, in 2003, the Supreme Court handed down two decisions in which they seemed to approve of the idea of taking race into account in a case that concerned admission to the law school of the University of Michigan. But outright quotas were illegal. To be honest, the standards remain somewhat vague. Basically, the decisions gave the green light to universities and other institutions to keep on doing exactly what they had been doing in the past. The 1964 Civil Rights Act included a ban on sex discrimination. The EEOC also enforces this ban. And over the years, many occupations have opened up to women that were closed to them before. In 1971, the Supreme Court also, for the first time, decided that the 14th Amendment outlawed gender discrimination. The legal treatment of race and sex discrimination is not identical. There are, after all, real and significant biological differences between men and women. But most statutes and practices which make a distinction between men and women have been declared void. This includes many of those that were ostensibly passed to protect women. It also includes statutes from which men were excluded. One significant case decided in 1971 was brought by a man who wanted a job as an airline flight attendant. At that time, on domestic flights, all the flight attendants were stewardesses. The defendant was Pan American Airlines. Pan American insisted that their customers preferred women. They even brought in a psychiatrist to testify that women were better at the job, that the airplane was a sealed enclave in which people are out of touch with their accustomed world, and that women do better in this situation than men. This was, in effect, an argument that an airplane was like a womb, or perhaps an argument that male customers preferred rather attractive young women. In any event, the court struck down this limitation and opened the occupation to men. In this case, men won a victory, but arguably in a deeper sense, it was women who won. These cases tried to break down old stereotypes about women. The stereotypes were barriers to women in the job market, even when they were couched in flattering terms. The courts made it clear that there could be no longer employment ghettos. To let men serve coffee on airplanes was, in that sense, a step toward letting women do brain surgery, mine coal, ride in police cars, or work as firemen. The ban on race and gender discrimination is in a way a symptom of an even larger movement, which has affected all other minorities: religious minorities, ethnic minorities, students, aliens, the elderly, the handicapped, the so-called sexual minorities. Native American rights have been increasingly recognized. The various tribes have gained more autonomy, including the right to have systems of tribal courts. Age discrimination became illegal in the workplace in the 1960s, and Congress later abolished mandatory retirement. A worker who is 80 or 90 or even 100 cannot be fired simply because he or she has reached a designated age. Of course, an employer can get rid of an employee who cannot do the job, but an arbitrary age is now illegal. An important statute was passed in 1990 called the Americans with Disabilities Act. Now, an employer cannot refuse a job to a person with a handicap unless the disability really prevents him or her from actually doing the job. The statute was very important to those who were in fact disabled. There is no question that this act has made a mark. It has permanently changed the architectural landscape, for example, with ramps, lifts, braille in elevators, closed caption broadcasts, and the like. Life has perhaps become a bit more easy for people with disabilities. Their consciousness and the consciousness of the rest of us has also been raised. If we put together all of these various aspects of civil rights, we can, in a way, put together all of these various forms of civil rights movements. They all represent a movement to treat individuals as individuals and to ignore characteristics such as race, gender, ethnicity, or even whether or not you're in a wheelchair as irrelevant to their ability to do a job, to live a life, and to be part of the mainstream in the United States. We should say a word or two about civil liberties in the United States, an important topic to be sure. The United States has always possessed a tradition of freedom of speech and freedom of the press. But only in the 20th century has the Supreme Court concerned itself with defining the boundaries of freedom of speech. What kinds of speech can be controlled by government, and to what extent? The first key cases arose during and after the First World War, partly because of the vigorous way in which the government tried to suppress what it considered sedition. In one case, Schenck versus the United States, the defendants were accused of violating the Espionage Act. They mailed circulars to men about to join the army. They claimed the war was a conspiracy of the capitalist class, and they said that the draft violated the constitutional rights of Americans. They were convicted of violating the act, and they appealed. The Supreme Court affirmed. But the important thing about the case was the opinion, which was written by Oliver Wendell Holmes, Jr. Holmes said that freedom of speech was not absolute, that freedom of speech was not a doctrine that would protect a man who shouted fire in a theater. The issue was, he said, were the words used of such a nature as to create a clear and present danger that they would bring about some evil that Congress has a right to prevent. The phrase clear and present danger was a huge success and has been used thousands of times since then. It has even gone into English idiom. This wasn't much comfort for the defendants, of course, who lost the case. But in the years since then, the Supreme Court has been much less willing to give the government its way in suppressing opinions with which it differs or which it considers somewhat dangerous. The period right after the First World War was a very trying time for civil liberties. It was the time of the famous Red Scare. Another trying time for freedom of speech and for civil liberties in general was the Cold War era, and in particular the episode associated with Senator Joseph McCarthy. During this period, there were many cases directed against left-wing organizations, and there were many states and organizations that instituted loyalty oaths. The Supreme Court vacillated on this issue. During the early part of the McCarthy period, the Supreme Court, generally speaking, upheld the right of the government to suppress the Communist Party. In 1957, however, the court seemed to dramatically change its way and turn its back on its prior Cold War stance. The Supreme Court has also wrestled for years with the issue of the limits of sexual expression. The Supreme Court has never developed a satisfactory or usable test for determining the limits of what is and what is not permissible. In most big cities, the attempt to exercise any control in the era of the sexual revolution has been, practically speaking, given up. Here, as is often the case, society makes the norms, and the Supreme Court more or less simply reflects them. In this lecture, we have chronicled the rise of the civil rights movement and shown its success in cases like Brown v. Board of Education. We have also talked about the Civil Rights Act of 1964 and the Voting Rights Act of 1965 and the ways in which they have permanently altered the relationship between the races. We also touched on the development of gender discrimination law and other forms of anti-discrimination, including discrimination against the elderly and Americans with disability. We ended the lecture by briefly discussing the history of civil liberties law during the 20th century. In the next lecture, which is the last of our lectures, we will talk about culture, policy, and law in the late 20th century. This will include some attention to the environmental movement and a discussion of the right of privacy. At the very end of this lecture, we will say a few words about the status of American law in these, the first years of the 21st century.
This ends Lecture 13. The American Legal Experience, Lecture 14, Culture, Policy, and Law in the Late 20th Century.
In this lecture, we're going to look at some aspects of American legal culture in the late 20th century. We've already mentioned the fact that there's been a relative shift of power to the center, which has altered the federal system. We're going to talk about two aspects of the new federal or national legal order in particular. One is environmental law, and the other is the protection of the right of privacy. Both are essentially products of the 20th century. At the very end of this lecture, we want to say a few words about where we stand, the status of American law and the American legal order at the dawn of the 21st century. The story we've been telling in these lectures is an incredibly complex story, and the closer we get to present times, the more complex it becomes. It's really impossible to sum up developments in the late 20th century in a few short sentences or even in a few long sentences. Social change is going on very rapidly, and it's social change, obviously, which makes a profound mark on the legal system. It's profoundly altered the federal system, too. As I mentioned, the shift toward the center has been going on since even before the days of the New Deal. What's really important about modern American legal culture is the dominance of the mass media, and particularly television. Among other things, these have accentuated the importance of the presidency and the federal government in general. They've created a single mass culture. It's the federal government, and especially the person of the president, that we see every day on TV, on the evening news. It's the president that we seem to know the most about. His habits, his way of walking and talking, his very identity. The transportation revolution has also helped to contribute to a single national economy and a single national culture. All of this has had a deep effect on American federalism as well as on American law in general. There are so many aspects of this shift that it's impossible to cover them all. I'm going to concentrate on two of them. The first is environmental law and the environmental movement. The late 20th century produced an entirely new field of law, environmental law. It did not wholly come out of the blue, of course. There had been conservation laws before, laws that protected fish and game, and the national park movement goes back to the 19th century. But in general, the 19th century treated resources as essentially infinite. Witness the slaughter of the great herds of buffalo. Witness the extinction of a number of birds and animals, such as the California parakeet. The sea otter and the elephant seal were hunted almost to extinction. Interest in the environmental accelerated dramatically in the last half of the 20th century. What lies behind this is a profound shift in culture or attitude. In the 19th century, nature was in fact the enemy. It was something to be fought, something to be conquered. The destiny of a forest was to be chopped down and turned into timber. The destiny of a swamp was to be drained and planted and plowed. The states paid money to people who killed wolves. There was no Endangered Species Act. Even the standards of beauty reflected the culture of boom, plow, and build. To say that something was a wilderness was not a compliment. Quite to the contrary. The deserts were considered ugly and dangerous. They stood in the way of progress. These attitudes are actually perfectly natural. Nobody would admire a valuable wetland, which is what we now call a swamp, if it was the source of yellow fever. If you were a traveler trying desperately to get to California, the desert would certainly be an enemy to you. It took a century of wealth, vaccines, and antibiotics to turn a swamp into a valuable wetland. It took air conditioning, a national highway system, and a change in consciousness to make the desert a thing of beauty and a tourist attraction. to make Death Valley a place to take vacations instead of what it literally was, a valley of death. Thus, the environmental movement reflects some romantic or emotional considerations, but these are not random. These are not accidental. They reflect changes in the culture, in the nature of society, in methods of transportation, in the growth of leisure, and so on. All of this, of course, is reflected in the law. As early as the 1930s and 1940s, there were attempts to extend protection to grizzly bears and the bald eagle. In 1964, Congress passed a Wilderness Act to protect the wilderness. In 1969 came the Endangered Species Conservation Act. Now it became illegal to import endangered species. Congress passed a Wild Free-Roaming Horses and Burros Act in 1971. In 1972, an act to protect marine mammals. The Endangered Species Act has not had entirely smooth sailing. Most people probably accept the principle for big, sexy animals and birds like the whooping crane or the California condor or the manatee or the sea elephant. But the language of the act includes everything else, including little beetles, crabs, worms, spiders, and salamanders. Environmental groups are able to latch onto the text and take it for a wild ride. The law in action necessarily steps on some powerful toes. It's easy for business interests to make fun of the law, to talk about jobs that are lost and huge projects killed to protect some miserable little worm, or a fluttering moth, or a bug-eyed owl. After the Endangered Species Act became law, the snail darter, a tiny fish nobody ever heard of before, was the excuse to stop construction on a mighty dam in the Tennessee Valley. Millions had already been spent on the dam. The environmental groups never wanted it in the first place, but the snail darter gave the enemies of the dam a brilliant new strategy. The battle raged on in the courts, and the Supreme Court ultimately came down on the side of the fish. The dam was never built, as a matter of fact, even though Congress had intervened in an attempt to see to it that the Supreme Court was not the last word. To this day, the Endangered Species Act remains a matter of intense controversy. The current struggle over the drilling for oil in Alaska is still another example of the conflict between economic and environmental interests, especially with regard to the vast public domain. The environmental movement is not only about beauty and the preservation of nature. It rises also out of an increased concern for public health. For example, there is an issue about air and water quality. Los Angeles was infamous for its smog, a noxious haze that smothered the mountains, hid the blue sky, and make people choke and wheeze. On October 29, 1948, a heavy fog or smog enveloped the town of Donora, Pennsylvania. It literally brought about darkness at noon. People began to gasp for breath. The basement of a community center was turned into a temporary morgue. About 20 people died, and 7,000 people, half of the population of the town, had to be hospitalized. This was a kind of national wake-up call. Federal and state health agencies started investigating. This was the first important effort to pin down the facts and the dangers of air pollution. The federal government stepped into the picture, but somewhat gingerly. An act of 1955 offered grants to states and to local agencies to do research on the problem. In 1963, Congress enacted a more substantial law, the Clean Air Act. In 1965, Congress enacted a law trying to control air pollution coming from motor vehicles. And an Air Quality Act in 1967 expanded the role of the federal government. The Clean Air Act of 1970 decisively shifted the balance of power to the central government. The point of much of this was that the states were either unable or unwilling to take care of the problem. The creation of an environmental protection agency was an important step in the direction of centralizing control within a single agency of government. It was created by an executive order signed by President Richard Nixon. There was also a concern for clean water. Practically speaking, the federal concern with water began with the Water Pollution Control Act of 1948. This law offered loans to the states to treat water. In the 1960s, the issue became more salient, and in 1965, Congress passed an important Water Quality Act. This act was later amended and strengthened. In 1974, the Safe Drinking Water Act gave the EPA the job of setting standards to make sure the water that comes out of the faucets in the United States is good and clean and pure. The environmental movement, thus, is made up of two parts, one of them ideological and aesthetic, the other one rooted in considerations of public health and safety. But both of them reflect the fact that in some ways America has come of age. It is a mature industrial society. It is a wealthy society which is rich enough to afford something that would be an impossible luxury in many third world countries. Wealth, leisure, and a search for individual fulfillment were characteristics of American culture in the late 20th century. They fueled the environmental movement, for example. Another striking reflex of current social forces has been the evolution of the so-called right of privacy. A law review article written in 1890 argued that there ought to be a tort action for invasion of privacy. That is, a person whose privacy was invaded by another ought to have a right to sue. And some states later did recognize a kind of right of privacy. For example, where a company uses a person's name or picture without their authorization in advertising. In an interesting case decided in 1931, a woman named Gabrielle Darley brought an action against a movie company which had made a movie called The Red Kimono based on her life and times and using her real name. Gabrielle Darley had had a colorful life. At one time, she'd been a prostitute. She was also arrested and tried for murder, but a jury acquitted her. According to her complaint filed in court, by 1918 she had abandoned her life of shame, married a man named Bernard Melvin, and lived a righteous life with a place in respectable society. People in her new circle knew nothing about her checkered past. She brought a lawsuit claiming that her right of privacy had been invaded. In fact, her claim was probably a tissue of lies, but the California Appellate Court was sympathetic. It was wrong to destroy her reputation and her social standing and publish the story of her former depravity for no other reason than private gain. This was probably the high watermark of the tort of invasion of privacy. Since then, it has come upon fairly evil days. In the age of tabloid journalism, privacy has no meaning at all for anybody who is the least bit public or notorious. For example, in one case, a man named Mike Virgil, who was a minor celebrity, a body surfer, complained about a story in the magazine Sports Illustrated. The magazine told about his exploits as a surfer, but it also revealed that he never learned how to read, that he ate spiders and other insects, and that he liked to dive down a flight of stairs to impress the chicks, as he put it. A federal court in 1975 thought that body surfing was a matter of general public interest. It thought that there were limits to sensational prying into private lives, even for such a celebrity as Mike Virgil, and it was a close case. It was sent back down the chain of courts to be examined again. In the last quarter of the 20th century, Gabrielle Darley would not have had the slightest chance of winning her case. The right of privacy, however, is also attached to something that seems on the surface quite different. Hardly any development in this period was as dramatic on the level of the Supreme Court as another right that the Supreme Court discovered in the text of the Constitution, the so-called right of privacy. The leading case is a case called Griswold versus Connecticut, which was decided in 1965. Connecticut had a law which made it a crime to use any drug or device, quotes, for the purpose of preventing conception, close quotes. This was the most stringent law of its kind in the whole country. The Supreme Court struck down the law on the grounds that the statute invaded a protected zone of privacy, which wasn't explicitly mentioned in the Constitution, but was more or less implied. In the Griswold case, the majority opinion referred to the sacred institution of marriage. Justice Douglas, who wrote the main opinion, invoked the boogeyman of police searching the, quote, sacred precincts of marital bedrooms for telltale signs of the use of contraceptives. He ended his opinion with a hymn of praise for marriage, which he called, quotes, intimate to the degree of being sacred, close quotes. According to the Supreme Court, then, sex and marriage were in some degree sacred, and some aspects of the choice of sex relations, and marriage were protected to some degree by the Constitution. The later cases carried the idea somewhat further. They made it very clear that the bedrooms that were protected were not bedrooms only of married people. And the climax of this line of cases, beyond a doubt, was Roe versus Wade, the famous 1973 case on abortion rights. Probably no decision since Brown v. Board of Education created more of a furor and excited more controversy than Roe versus Wade. But Brown versus Board of Education is more or less canonized by now. Nobody criticizes it. There may be details about the form of the opinion which are controversial, but practically everybody applauds the result. Roe versus Wade is different and has had a different fate. It is still a major political issue. Millions of people have as their goal getting rid of Roe versus Wade, while millions more have made up their mind to defend it to the death. Exactly what did the case decide? To begin with, it threw out all existing abortion statutes. Justice Harry Blackmun, who wrote the majority opinion, invoked the right of privacy. He said that this right was broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The right was not absolute. It was pretty much absolute in the first trimester of pregnancy. In the second trimester, the state might regulate the abortion procedure, and in the last stage of pregnancy, when the fetus was viable, the state had greater regulatory power. There is no doubt that Blackmun thought this was something of a compromise. There were women's groups who wanted the law to recognize an absolute right to an abortion, anytime, anywhere, up to the moment before birth. There were many people, on the contrary, that would have liked to see a total ban on abortion. Blackmun probably thought he was splitting the difference. But this was an issue on which many people felt there could be no compromise whatsoever. To many people, abortion was murder, a crime against God, a crime against humanity, the slaughter of innocent babies. It is impossible to compromise with murder. The decision has continued to be controversial, and the controversy has never ended. It has become one of the most important political issues in the country. It stimulated the growth of a right-to-life movement, but the case has also generated great passion in support of a woman's right to choose. Roe versus Wade and the whole privacy line of cases has only a tenuous connection with the text of the Constitution. This has been a source of criticism from certain academics, but it is not the real reason why people are for or against Roe versus Wade. By 1992, it was widely thought that there was a conservative majority on the Supreme Court that would finally get rid of Roe versus Wade. The court, somewhat surprisingly, declined to do so. President Clinton appointed 2 justices who were committed to the pro-choice side. As of 2003, the decision seems at least temporarily secure. Many states and many members of Congress have tried, if not to get rid of Roe, at least to limit its impact. The Hyde Amendment, which was enacted by Congress in 1976, banned the use of federal Medicaid funds for abortions, except for victims of rape or incest, a tiny group, or where the life of the mother would be endangered. Poor women have no access to federal money for the most part. Some of the pro-choice people predicted that there would be a grim return to the system of back-alley abortions. But the worst of these problems did not in fact happen, mostly because private agencies moved in to fill the gap as much as they could. But there are some states which continue to battle against Roe versus Wade and to nibble it to death with exceptions and provisos. An increasingly conservative court has accepted most, but not all, of these attempts to limit Roe versus Wade. But, as we said, the core of this decision remains firm. In 1986, the Supreme Court refused to extend the right of privacy one step further. The case was Bowers versus Hardwick. In this case, a man named Michael Hardwick had been arrested and charged with violating a sodomy statute in the state of Georgia. A police officer had barged into his bedroom and found him in the process of having sex with another man. 5 justices of the Supreme Court found the statute perfectly valid. They said there was no such thing as a right of privacy that covered, quotes, homosexual sodomy. 4 justices dissented. In the outside world, there was also plenty of evidence of backlash against the movement for gay rights. In 1992, voters in Colorado adopted an anti-gay rights amendment to their constitution by a small majority. The amendment to the Constitution, in effect, provided that no community could pass an anti-discrimination ordinance which protected homosexuals, lesbians, or people of bisexual orientation. Somewhat surprisingly, the highest court of Colorado struck down the amendment as unconstitutional, and the Supreme Court, even more surprisingly, agreed with them by a 6-3 vote. Colorado had no right to single out gays and lesbians and subject them to this special disability. In the year 2003, moreover, the court overruled Bowers versus Hardwick and invalidated all remaining sodomy statutes. The rise of the computer has brought the issue of privacy to the fore in a much more literal sense. Today, big government and big institutions have the capacity to gather information about ordinary citizens, to compile elaborate dossiers, and an almost infinite ability to store this data, to link it with other data, and to share it with other institutions. The right of privacy in every one of its senses may well be one of the major legal and social issues of the 21st century. In this lecture, we have talked about 2 very important and significant aspects of modern American legal culture: the environmental movement and the right of privacy in various senses. Both of them reflect the increasing role of the federal government in the legal system. They both also represent something that has been true of American law since the very outset, and that is its overwhelming importance. Our century is only a few years old, But it continues to demonstrate a point that we made at the very beginning of this course: the centrality of the American legal system in our lives. The Supreme Court decisively intervened in the election of 2000 in the case of Bush versus Gore. The attack on the World Trade Center on September 11, 2001, led to important changes in law. There was an innovative program of compensation for victims of disaster, but Congress also passed the Patriot Act and other measures designed to fight terrorism. There has been intense political controversy over appointments to the federal bench, and continuing controversies over environmental policy, social policy, tax policy, and everything else. It is far too early to assess the meaning and impact of many of the legal events of this new century. One thing and only one thing is clear: the omnipotence and the supreme importance of the legal order in this country as in others will continue and indeed is likely to grow.
Now that you've completed this course, be sure to test your comprehension by taking the final exam. You'll find the exam on this course's webpage at www.modernscholar.com. If you enjoyed this program, the Modern Scholar series from Recorded Books offers courses in a variety of subject areas taught by the world's greatest professors. Call 1-800-636-3399 or visit the course webpage for a free catalog. This course, produced by John J. Alexander, is copyrighted 2004 by Recorded Books, LLC. The lecture text is copyrighted 2004 by Lawrence M. Friedman. The lectures were recorded under the direction of Matthew Kavner.